Number 759, Ernesto Miranda, petitioner versus Arizona. We'll wait just a few minutes until I get seated. Mr. Flynn, you may proceed now.
Mr. Chief Justice, may it please the court, this case concerns itself with the conviction of a defendant of 2 crimes of rape and kidnapping, sentences on each count of 20 to 30 years to run concurrently. I should point out to the court, in an effort to avoid possible confusion, that the defendant was convicted in a companion case of the crime of robbery in a completely separate and independent act. However, the Supreme Court of the state of Arizona treated that conviction as a companion case in a companion decision, and portions of that record have been appended to the record in this case as it bears on the issue before the court. Now, the issue before the court is the admission in evidence of the defendant's confession under the facts and circumstances of this case over the specific objection of his trial counsel that it had been given in the absence of counsel. The trial court in June of 1963, prior to this court's decision in Escobedo, allowed the confession into evidence. The Supreme Court of the state of Arizona in April of 1965, after this court's decision in Escobedo, affirmed the conviction and the admission of the confession in evidence. This court has granted us review. The facts in the case indicate that the defendant was a 23-year-old Spanish-American extraction, that on the morning of March 13th, 1963, he was arrested at his home, taken down to the police station by 2 officers named Young and Cooley. That at the police station, he was immediately placed in a lineup. He was there identified by the prosecutrix in this case, and later identified by the prosecutrix in the robbery case. And immediately after the interrogations, he was taken into the police confessional at approximately 11:30 a.m., and by 1:30 they had obtained from him an oral confession.
Well, what's a police confession?
The interrogation room, described in the transcript as interrogation room number 2, Your Honor, please. He had denied his guilt, according to the officers at the commencement of the interrogation. By 1:30 he had confessed. I believe that the record indicates that at no time during the interrogation and prior to his confession, his oral confession, was he advised either of his rights to remain silent, of his right to counsel, or of his right to consult with counsel. Nor indeed was such the practice in Arizona at that time as admitted by the officers in their testimony. The defendant was then asked to sign a confession, to which he agreed. The form handed to him to write on contained a typed statement as follows, which precedes his handwritten confession. I, Ernest A. Miranda, do hereby swear that I make this statement voluntarily and of my own free will, with no threats, coercion, or promises of immunity, and with full knowledge of my legal rights, understanding any statement I make may be used against me. This statement was read to him by the officers, and he confessed in his own handwriting. Throughout the interrogation, the defendant did not request counsel at any time. In due course, the trial court appointed counsel to defend him in both cases, and defense counsel requested a psychiatric examination which has been made and the medical report has been made a portion of the transcript of the record in this case, as it enlightens us to a portion or some of the factual information surrounding the defendant.
Mr. Flynn, sorry to interrupt you, but you said that that Miranda was not told that he might remain silent. Did you say that?
That is correct, Your Honor.
Is there a dispute as to that?
Yes, there is, Your Honor, and I believe it arises as a result of the appendix and the robbery conviction. In this respect, I would answer Your Honor's question by referring to page 51 of the petitioner's brief and to the appendix, page 52. At the top, which the question was asked by Mr. Moore, the trial counsel, did you state to the defendant at any time before he made the statement you are about to answer to that anything he said would be held against him? Answer, no, sir. Question, you didn't warn him of that. Answer, no, sir. Question, did you warn him of his rights to an attorney? Answer, no, sir. Mr. Moore, we object, not voluntarily given. Mr. Turoff, I don't believe that is necessary. The court overruled. On page 53, succeeding page, a portion of the same record indicates further examination concerning this conversation. Had you offered, and starting approximately 1/3 down the page, had you offered the defendant any immunity? Answer, no, sir. In your presence, had Officer Cooley done any of these acts? Answer, no, sir. Question, about what time did this conversation take place, officer? Answer, approximately 1:30. Shortly after Mrs. McDaniel made her first statement, is that correct? Answer, yes, sir. Can you tell us now, officer, regarding the charge of robbery, what was said to the defendant and what the defendant answered in your presence? Answer, I asked Mr. Miranda if he recognized, and there the question terminates.
Well,
I submit.
I was referring to page 4 of your brief, in which you say that Officer Young believes that Miranda was told that he need not answer their questions.
I was about to continue, if Your Honor please, to page 54, in which we find, question, you never warned him he was entitled to an attorney, nor anything he said would be held against him, did you? Answer, we told him anything he said would be used against him. He wasn't required by law to tell us anything. Consequently, this would answer Your Honor's question, except bearing in mind that the record clearly reveals that from the lineup and the identification to the interrogation room, the officers established the time as 11:30, and that the confession was completed and signed at 1:30. Reading the testimony of the robbery conviction, it is apparent to me that the officers, when they recite or answered on page 54 of the transcript that he had been advised of his rights, were again relating to this formal typed heading, which would be at 1:30 at the time he signed the confession. That hence there really is no conflict in the record as to when he was advised of his rights. The further history relating to this defendant found in the psychiatric examination would indicate that he had an 8th grade education, and is found by the Supreme Court that he had a prior criminal record and that he was mentally abnormal. He was found, however, to be competent to stand trial and legally sane at the time of the commission of the alleged acts. Now, the critical aspect of the defendant's case of confession, I think, is eminently demonstrated when during the trial the prosecutrix was asked the question concerning penetration, in which she first responded that she thought it was by finger under questioning by the prosecuting attorney. Immediately thereafter, she expressed uncertainty as to the manner or method of penetration, and after some prompting responded to the prosecuting attorney that it had been, in fact, by the male organ. On cross-examination, she again expressed the uncertainty in relation to this penetration, which, of course, is the essential element of the crime of first-degree rape in the state of Arizona. When she responded to his question, that she simply was unsure whether it had been by finger or by penis. Now, of course, the defendant's confession neatly corrects this reasonable doubt that otherwise would have been engendered, when in precise terminology he wrote, asked her to lie down, and she did. could not get penis into vagina, got about 1/2, parenthesis, half written, inch in. The only thing missing, or the only thing that the officers failed to supply in words to this defendant at the time he wrote this confession, was in violation of section 13-611, Arizona Revised Statutes. And then, of course, they would have had the classic confession of conviction, because they could have argued that the man even knew the statutory provisions relating to rape. The state, as I read their response, take no issue with the statement of facts as I've outlined them to this court, except to say that we overstate his mental condition and minimize his educational background, and also the concern that is expressed by Mr. Justice Fortas concerning at what stage of the proceeding he may have been advised of his right to remain silent. Now, the petitioner's position on the issue is simply this. The Arizona Supreme Court, we feel, has imprisoned this court's decision in Escobedo on its facts, and by its decision is refusing to apply the principles of that case, and for all practical purposes has emasculated certainly every court desiring to admit a confession can find distinguishing factors in Escobedo from the fact situation before it. I would like to very briefly quote from the transcript of record, which contains the Arizona decision at page 87. Will be noted that the court in the Escobedo case set forth the circumstances under which a statement would be held admissible, namely, 1, the general inquiry into an unsolved crime must have begun to focus on a particular suspect. 2, the suspect must have been taken into police custody. 3, the police in its interrogation must have elicited an incriminating statement. 4, the suspect must have requested and been denied an opportunity to consult with his lawyer. 5, the police must not have effectively warned the suspect of his constitutional rights to remain silent. When all of these 5 factors occur, then the Escobedo case is a controlling precedent. Now, the Arizona Supreme Court, having indicated its clear intention to imprison the Escobedo decision, set about to do it precisely that. First, as to the focusing question, it indicated that this crime had occurred at night. And consequently, despite the positive identification of the defendant by 2 witnesses, which the state urged were entirely fair lineups, the Supreme Court of Arizona indicated that even then, perhaps under these facts, attention had not focused upon this defendant. I think this is sheer sophistry and would clearly indicate the obvious intent of the Arizona Supreme Court to confine Escobedo and to distinguish it whenever possible. Next, the court found that the defendant was advised of his rights in the reading of the typed portion immediately preceding its transcript. They permitted that document to lift itself by its own bootstraps, so to speak, and to indicate that here was a man who was knowledgeable concerning his legal rights, despite the facts and circumstances of his background and his education. And they further found that he was knowledgeable because he had a prior criminal record, though in the decision they indicated this would be knowledge of his rights in court, and certainly not his rights at the time of the interrogation. I think the numerous briefs filed in this case, indicating the substantial split in the decisions throughout the various states, the circuits, and the federal district courts, indicate the interpretation that has been placed upon Escobedo. On the one hand, we have the California decision in Dorado. We have the Third Circuit's decision in Russo, which would indicate that principle and logic are being applied to the decision, and that the words of Mr. Justice Goldberg, that when the process shifts from the investigation to one of accusation, and when the purpose is to elicit a confession from the defendant, then the adversary process comes into being. On the other hand, the other cases that would distinguish this have found and give rise to what I submit is not really confusion by merely straining against the principles and logic in that decision.
What do you think is the result?
of the adversary process coming into being when this focusing takes place. What follows from that? Is there then a right to a lawyer?
I think that the man at that time has the right to exercise, if he knows, and under the present state of the law in Arizona, if he's rich enough, and if he's educated enough to assert his Fifth Amendment right, and if he recognizes that he has a Fifth Amendment right to request counsel. But I simply say that at that stage of the proceeding, under the facts and circumstances in Miranda, of a man of limited education, of a man who certainly is mentally abnormal, who is certainly an indigent, that when that adversary process came into being, that the police, at the very least, had an obligation to extend to this man not only his clear Fifth Amendment right, but to afford to him the right of counsel.
Well, I suppose if you really mean what you say, or what you gathered from what the Escobedo opinion says, the adversary process starts at that point, then every single protection of the Constitution then comes into being. Does it not? The right to it. You have to bring a jury in there, I suppose.
No, Your Honor, I wouldn't bring a jury in. I simply would extend to the man those constitutional rights which the police would at that time take it away from him. Simply his
that's
Fifth
begging the
Amendment.
question. My question is, what are those rights when this focusing begins? Are these all the panoply of rights guaranteed to a defendant in a criminal trial?
I think that the first right is the Fifth Amendment right, not to incriminate oneself, the right to know that you have that right, and the right to consult with counsel, at the very least, in order that you can exercise the right, Your Honor.
Well, I don't fully understand your answer, but because if the adversary process then begins, then what you have is the equivalent of a trial, do you not? And then I suppose you have a right to a judge and a jury and everything else that goes with the trial right then and there. And if you have something less than that, then this is not an adversary proceeding. Then you don't mean what you're saying.
I think what I say when I'm interpreting adversary proceeding to mean, that at that time, a person who is poorly educated, who in essence is mentally abnormal, who is an indigent, if he is an adversary proceeding, at the very least, is entitled to, at that stage of the proceeding, to be represented by counsel and to be advised by counsel of his rights under the Fifth Amendment of the Constitution, or he has no such right.
Well, again, I don't mean to quibble, and I apologize, but I think it's first important to define what those rights are, what his rights under the Constitution are at that point. You can't be advised of his rights unless somebody knows what those rights are.
Precisely my point. And the only person that can adequately advise a person like Ernest Miranda is a lawyer.
And what would the lawyer advise him that his rights then were?
That he had the right not to incriminate himself, that he had a right not to make any statement, that he had the right to be free from further questioning by the police department, that he had the right at an ultimate time to be represented adequately by counsel in court, that if he was too indigent, too poor to employ counsel, that the state would furnish him counsel.
And what is it that confers the right to a lawyer's advice at that point and not at an earlier point?
The adversary proceeding.
The Sixth Amendment?
No, the attempt to erode or to take away from him the Fifth Amendment right which already existed, and that was the right not to incriminate himself and to be convicted out of his own mouth.
Why didn't he have that right earlier?
If he knew about it.
Before this became a so-called adversary proceeding?
Yes, Your Honor, if he knew about it.
Why
He was
didn't
aware of it. He was knowledgeable.
Then didn't he have the right to a lawyer's advice earlier than that?
If he could afford it, yes. He was intelligent enough, strong enough to stand up against police interrogation and request it, yes.
What I'm getting at is I don't understand the magic in this phrase of focusing, then all of a sudden it becomes an adversary proceeding, and then I suppose if you literally mean that it becomes an adversary proceeding, then you're entitled to all the rights that a defendant is given under our Constitution at a criminal trial. And if you mean less than that, then you don't really mean it's now become the equivalent of a trial.
Well, I simply mean that when it becomes an adversary proceeding, at the very least, the person in Ernest Miranda's position needs the benefit of counsel. that unless he is afforded that right to counsel, he simply has, in essence, no Fifth or Sixth Amendment right, and there is no due process of law being afforded to a man in Ernest Miranda's position.
Is it possible that prior to this so-called focusing, or let's say prior to arrest, knowing that those don't mean the same thing, that a citizen has an obligation to cooperate with the state, give the state information that he may have relevant to a crime, that upon arrest or upon this focusing, that the state and the individual then assume the position of adversaries, and there is at the very least a change in that relationship between the individual and the state, and therefore in their mutual rights and responsibilities. I don't know whether that's what my brother Stuart's getting at, and perhaps it's unfair to discuss this through you. But if you do have a comment on it, I'd like to hear it.
Well, I think that the only comment that I could make is that without getting ourselves into the area precisely when focusing begins, that I must, in this instant, limit it to the fact situation and the circumstances of Ernest Miranda, because for every practical purpose, after the 2-hour interrogation, the mere formality of supplying counsel to Ernest Miranda at the time of trial, and what I would submit would really be nothing more than a mockery of the assertion of his Sixth Amendment rights to be represented in court through the formality of a trial and conviction takes place. While this simply is not a matter of the record, it's in the robbery trial, and I think it is so illustrates the position of what occurs in the case of persons who have confessed as Ernest Miranda. The question was asked in the robbery trial, which preceded the rape trial by 1 day, of Mr. Moore. The court, are you ready to go to trial? Mr. Moore, I have been ready. I haven't anything to do but from my man and sit down and listen.
May I ask you one question, Mr. Senator, about the Fifth Amendment? Let's forget that this amendment that provides that no person shall be compelled to be a witness against himself. Disassociated entirely from the right to counsel. You've said several times, seem to indicate that in determining whether or not a witness, the person should be compelled to submit himself, it might depend to some extent on his literacy or illiteracy, his wealth or his lack of wealth, his standing or his lack of standing. Why does that have anything to do with it? Why does the amendment not protect the rich as well as the poor, the literate as well as the illiterate?
Well, I'd say that it certainly, most assuredly, does protect.
What is that?
That in the state of the law today, as pronounced by the Arizona Supreme Court under those guiding principles, it certainly does protect the rich, the educated, and the strong. Those rich enough to hire counsel, those who are educated enough to know what their rights are, and those who are strong enough to withstand police interrogation and assert those rights. It does not afford protection.
I'm asking you only about the Fifth Amendment provision. No person shall be compelled to be a witness against himself. Does that protect every person or just some person? I'm not talking about in practical effect. I'm talking about what the amendment is supposed to do.
Protects all persons. Incriminating or convicting
Would
themselves.
literacy or illiteracy have anything to do with it if they compelled him to testify? Whatever comes within the scope of that?
At the interrogation stage, if he simply is too ignorant to know that he has the Fifth Amendment right, then certainly literacy has something to do with it, Your Honor. If the man at the time of the interrogation has never heard of the Fifth Amendment, knows nothing about its concept or its scope, knows nothing of his right, then certainly his literacy...
He'd have more right because of that. I don't understand. The Fifth Amendment right alone, not to be compelled to be a witness against himself. What does that cover?
Perhaps I have simply not expressed myself.
Does that cover everybody?
It covers everybody, Your Honor.
Well, that's what I mean.
Clearly, in practical application, in view of the interrogation and the facts and circumstances of Miranda, it simply had no application because of the facts and circumstances in that particular case. That's what I'm attempting to express to the court. Now, the Arizona Supreme Court went on to in essence, we submit, turned its decision primarily on the failure of the defendant in this case to request counsel, which is the only really distinguishing factor that they could find.
Is there any claim in this case that this confession was compelled, was involuntary?
No, Your Honor.
None at all.
None at all.
You mean that there's no question that he was not compelled to give evidence against himself?
We have raised no question that he was compelled to give this statement,
So
in the
there's
sense
no-
that anyone forced him to do it by coercion, by threats, by promises, or compulsion of that kind.
Of that kind, was it voluntary or wasn't it?
Well, voluntary in the sense that the man, at a time, without knowledge of his rights,
You claim his Fifth Amendment right?
I would say that his Fifth Amendment right was violated to the
So he
extent,
was compelled to do it.
because he was compelled to do it,
That's what the amendment said.
yes, to the extent that he was, number one, too poor to exercise it, number
Well,
two,
whatever
mentally
the sense
abnormal.
is, whatever the sense is, you say he was compelled to do it.
I say it was taken from him at a point in time when he absolutely should have
Well,
been
I know, but
afforded the Sixth
I'm
Amendment.
not violating the amendment, namely the provision that he was, to violate the amendment, his Fifth Amendment right, he has to be compelled to do it, doesn't he?
In the sense that Your Honor is presenting to me the word compelled, you're correct.
You know, I was talking about the Constitution says.
He doesn't have to have a gun pointed to his head, does he?
Of course he does. So he was compelled to do it, wasn't he, according to your claim?
Not by gunpoint, as Mr. Justice Black has indicated. He
I
was
know,
called
but-
upon to surrender a right that he didn't fully realize and appreciate that he had.
But in all the
was taken from him.
circumstances, I'm just trying to find out if you claim his Fifth Amendment rights were violated. And if they were, it must be compelled, that you say he was compelled to do it on all the circumstances.
I would say that as a result of lack of knowledge, or lack of a better term, failure to advise, the denial of a right to counsel, stage of the proceeding when he most certainly needed it, that this could, in and of itself, and certainly in most police
Why wouldn't you add
interrogations,
to that the
constitute
fact that the
compulsion.
state had him in its control and custody? Why would that not tend to show some kind of coercion or compulsion?
The whole process of a person having been raised, I would assume, to tell the truth and to respect authority.
Was he allowed to get away from there at will?
No, Your Honor, he was in confinement, under arrest.
The state had moved against him by taking him in to question him, not?
That is correct.
I suppose, Mr. Flynn, you would say that if the police had said to this young man, now, you're a nice young man and we don't want to hurt you and so forth, we're your friends, and if you'll just tell us how you committed this crime, we'll let you go home and we won't prosecute you. That would be a violation of the Fifth Amendment, and that, technically speaking, would not be compelling him to do it. It would be an inducement, wouldn't it?
That is correct,
But it
Your
would,
Honor.
I suppose you would argue that that is still within the Fifth Amendment, wouldn't you?
It's an abdication of the Fifth Amendment
Yeah.
rights simply because of
That's what I mean.
the total circumstances existing at the time. The
Right.
arrest, the custody, the lack of knowledge, the
In
status
fact, we
of the
have held
individual.
that in cases of that kind, that confessions are bad, haven't we? Where they said it'd be better for you if you do, we'll let you go,
Well-
and so forth.
That, of course, is an implied promise of
Yeah.
some help or immunity
That
of some
isn't
kind.
strictly a
That certainly is not
compulsion either,
compulsion.
as we've been talking about.
In the sense of the word, as Mr. Justice White has applied it.
As I recall, in those cases, I agree with the Chief Justice. As I recall, in those cases, that was put on under the Fifth Amendment. And the words for the Fifth Amendment was referred to in the early case by Chief Justice White, I believe it was. The fact that inducement is a compulsion and was brought in that category. Therefore, it violated the amendment against being compelled to give evidence against yourself.
I'm sure Mr. Justice Black has
So it's
expressed it far
a
better
question
than
of what compel means. But does not depend, I suppose, I haven't seen it in any of the cases, on the wealth, or the standing, or the status of the person, so far as the right is concerned.
Yes, I think perhaps that was a bad choice of words in context, Your Your Honor, please, at the time I state this. I would like to state that, in conclusion, that the Constitution of the state of Arizona, for example, has in statehood provided to the citizens of our state language precisely the same as the Fourth Amendment to the federal Constitution as it pertains to searches and seizures. And yet from 1914 until this court's decision in Mapp versus Ohio, we simply did not enjoy the Fourth Amendment rights or the scope of the Fourth Amendment rights that were enjoyed by most of the citizens of the other states of this union and those persons who were under federal control. In response to the amicus from New York and for the amicus for the National Association of Defense Attorneys that would ask this court to go slowly and to give the opportunity to the states, to the legislature, to the courts, and to the Bar Association to undertake to solve this problem. I simply say that whatever the solutions may be, it would be another 46 years before the Sixth Amendment right, in the scope that it was intended, I submit, by this court in Escobedo, will reach the state of Arizona. We're one of the most modern states in relation to the adoption of the American Law Institute rules. We have a comparable rule to Rule 5. To my knowledge, there has never been a criminal prosecution for failure to arraign a man. There is no decision in Arizona that would even come close to the McNabb or Mallory rule in Arizona. In fact, the same term that Miranda was decided, the Arizona Supreme Court indicated that despite the necessity and requirement of an immediate arraignment before the nearest and most accessible magistrate, that Mallory versus McNabb did not apply.
Mr. Nelson?
Mr. Chief Justice, may it please the court, counsel, somewhat caught up in where to begin. I think perhaps the first and most important, one of the most important things to say right now is concerning Mr. Flynn's last remarks. I, as a prosecutor, even of only short duration, take serious issue, as strenuous issue as I can take before this court, in the statement that it will take another 46 years in the state of Arizona for the right to counsel to become full-blown. I just simply think there is no reason for that statement to be made. If there's any reason for it to be made, any possible justification for it to be made, then there's no point in going any further. One issue that might be a good starting point is concerning the description of the Arizona court's supposed off-the-cuff referral to or ignoring of the Escobedo decision, or the attempt to avoid it clearly. There is no such thing in the Arizona Supreme Court opinion, and a reading of it shows that. They agree that they must follow this court, not begrudgingly. They simply stated that it's a fact. And then in exploring the case of Escobedo, the case of Miranda, they try to find out what happened in Miranda, what the case of Escobedo says, and apply those principles. There's no attempt to avoid, and I don't think you can read it implicitly or otherwise in the Arizona court's opinion. Clearly, they did not base it on a request. They did not say, we have A, B, C, D, E, D wasn't present, therefore it's not controlling. That was not what they said. They said many courts in other jurisdictions had gone off on that particular area. They mentioned that as a factor, but they discussed but many other factors in Miranda which differentiated it from Escobedo. To get to the facts in Miranda, I think it's very clear from the record that Mr. Miranda, as an individual defendant, does not particularly require any special rule. I certainly agree with Mr. Justice Black 100% that the Fifth Amendment, the Sixth Amendment, every other part of our Constitution applies to everyone, poor, rich, ignorant, intellectual, what have you. There's no possible basis for differentiation. I don't argue that. I don't think any prosecutor of note argues it. But Miranda, I think, characteristically by the petitioner, is portrayed in this light in an attempt to make something that isn't there. Sure, he only went through the 8th grade. And one of the psychiatrists said he had an emotional illness. I might say there is another psychiatric report. It's not in the printed record, and I just discovered it in my file. But it is in the record before this court, the record that was on appeal, and I would urge the court to advert to that psychiatric report also. And as to the fact that Mr. Miranda could not have made the statement that he made, I just don't think there's any basis for alleging that. The fact that he uses the words, the medical words, to describe the male and female sex organ rather than some 4-letter vernacular words that he might have used, this doesn't condemn him just because he knew those words and maybe felt in this context in writing a statement that he could use them. There's no indication in the record that the police put these words in his mouth. The fact that this particular 1/2-inch penetration is something that the police conjured up in his mind is just simply not supportable by the record. You read the psychiatric report, and that is in the record. And he said he was upset when he found out that she had not had sexual relations before. Well, she told him that. The only way he found out was because, obviously from the record, as he said, he was only able to make penetration only a slight ways, simply because the fact that the woman's hymen had not been ruptured. This is a clear factual as to that he knew why he made that statement and why it was accurate, not a fabrication of the police officers.
Mr. Nelson, on page 19 of your brief, you assert that the petitioner was advised of his constitutional rights, specifically including his right to remain silent, the fact that his statement had to be voluntary, and that anything he did say could be used against him.
Yes, Your Honor. I wouldn't have...
Is the only basis for that the printed legend in the confession that he signed?
No, I don't believe I would have put in as strong a statement concerning his right to remain silent had not we agreed to stipulate to this other portion of the other record. But I believe that as long as that's in the record, I can make this statement because it's supported in the finding of the court based on the interrogation of the officers, the testimony of the officers in the trial that is actually before this court concerning their advice to him, and the findings of the court based on his understanding, the reading of the statement, the testimony coupled with this. I believe then that the court below, which clearly found that to be true, that he had been fully advised, had a proper basis for finding all these to exist, except that there is no quarrel, that he was not specifically advised that he had a right to counsel.
Is it your position that the record shows that he was advised of these rights somehow, some way, in addition to the legend on his confession? That's my question.
Yes.
And where is that?
I believe the police officers testify to the fact that they told him of his rights, and that they also, besides telling him, the record is a little unclear in both cases as to exactly when it took place, but I believe the record supports a statement that he was advised specifically by them of his rights, and then he was adverted to the paragraph, and perhaps even again the paragraph was read to him. But the record is not really all four square. It's not that clear.
All right. Let us assume that he was so advised, and I understand you've said the record is not clear on the point. Let us assume that he was advised of these rights. In your opinion, does it make any difference when he was advised? That is, whether he was advised at the commencement of the interrogation or in an early stage of the interrogation, or whether he was advised only when he was ready to sign the confession, the written confession? Does that
Well,
make any difference in terms of the issues before us?
Assuming for a moment that some warning is going to be required, or should have been given, or is, then I would think to be of any effect, it must be given before he'd made any statement. Perhaps he might have refused to sign a written confession. Certainly still the oral statements could have been introduced against him.
So you you think that the warning, if necessary, has to be given prior to the interrogation?
At some meaningful time, right? I think it has to be at some time prior to the fact that that after, if they use it before, of course, the warning would mean nothing. If they could introduce what they had obtained from him before they gave the warning and what afterwards.
Well, now, do you believe that, is it your submission to us that a warning is necessary before a confession in the absence of counsel can be taken and subsequently introduced in the trial?
No.
What is your position on that?
No, my position basically is concerning the warning is that each case presents a factual situation in which the court would have to determine, or a court or a judge or a prosecutor at some level would have to make a determination as whether or not a defendant, because of the circumstances surrounding his confession, was denied a specific right, whether it be a right to counsel, the right to not be compelled to testify against himself, and that a warning or an age or literacy, circumstances, length of questioning, all these factors would be important, but I don't think you can pin it to one simple thing as a warning, because there are perhaps many situations we could think of where a warning would be completely inadequate.
Well, tell me some of the factors that would be relevant in the absence of a warning.
His age, his experience, his background, the type of questioning, the atmosphere of the questioning, the length of questioning, the time of day, perhaps. All these factors.
You think, well, what we ought to do is to devise something like the Betts and Brady rule, special circumstances?
Well, I think that's what the Escobedo case indicates. In other words, I'm, of course, my opinion is biased, and if it is not something like that, then it's an absolute right to counsel. I don't think there can be any in between unless some other theory. Under the way I read the decisions of this court, if it is an absolute right to counsel, the same sort of right to counsel that attaches.
No, we're not talking about right to counsel. We're talking about the warning. When is a warning necessary? And as I understand you, you say that if the warning is necessary, and it should be held to be constitutionally necessary in the absence of counsel, then the warning has to be given at a meaningful time.
I would think so, certainly.
And then I proceeded to ask you, give us the benefit of your views as to whether a warning was necessary. And as I understand it, you say that you have to look at the circumstances of each case.
I would say not absolute.
Now I'm asking, and then I ask you what the circumstances of each case, what are the relevant circumstances to look for in a particular case? And how about this particular case? Is the psychiatric report to which you referred, psychiatric report number 2, a material variance with the one that to which you're...
I don't think so. I'm not a psychiatrist, so I can't say it. I think both reports say in the effect that the man has an emotional illness that should be treated, but that he knew what was going on. Both the reports say his mental faculties, whatever they were sharp, acute. He had no psychotic disorders. I think they both say basically the same thing. I think the diagnosis in the other report was a sociopathic personality.
So that if the Betts against Brady test were applied in the way that this court did apply it prior to Gideon, I suppose it's quite arguable that Miranda, the petitioner here, was entitled to a warning. Would you agree
Well,
with
it's
that?
arguable. I have extensively argued the facts that he wasn't of such a nature as an individual because of his mental condition or his educational background as to require any more than he got. He got in other words, I'm saying he got every warning except the specific warning of the right to counsel. He didn't have counsel. Counsel wasn't specifically denied to him on the basis of a request to retain counsel. The only possible thing that happened to Mr. Miranda that, in my light, assuming that he has the capability of understanding it all, is the fact that he did not get the specific warning of his right to counsel.
Well, even if we assume that he got all the other warnings, and putting aside the question of right to counsel, assuming that the record does show that he got these warnings, it's still, is there any evidence, I have to ask you again, does the record show that he got it at what you would call a meaningful time?
Yes, I think the police officers, they were never pinned down as to when, in other words, whether at 11:30, when they went into interrogation room 2, they immediately warned him. This was never pinned down by either side, but they did say that he was warned, and then they went to elaborate that he was warned specifically, as I believe, as my recollection serves me correct, in response to a specific question concerning the statement. They said the part of the statement was read to him again. Now, I believe that the court could find from the record that he was warned at 11:30. If the warning is required in this particular case to protect his rights, and it's found, as a matter of fact, which the court below did not find, that it was not given until the written statement, and I would suppose that it wasn't given at the proper time.
Mr. Nelson, I certainly want your views, and only your views, and I don't want to state anything unfairly. But am I correct in inferring from what you have just said in answer to my questions that the state of Arizona does agree that there are occasions when the United States Constitution requires that a warning as to the right to remain silent must be given
Your Honor,
to a person who's in custody, and it must be given at a meaningful time. Do I correctly state the position that you're presenting to us here?
Not completely. I don't think that the Arizona Supreme Court has worded its holdings, and I cite the case that followed Miranda and referred back to it concerning the point to waiver, and they go on to expand on their thinking. I don't believe the Arizona court has specifically said that warnings as such are of a constitutional dimension. The court has said that in some cases, warnings may be required in a given case. In fact, in the Goff case, which I cite as the next case in the Arizona court's determination, they say it's important that all steps be taken at the earliest possible time when they're indicated by the fact situation to ensure that the state doesn't overreach and that the man is given every benefit of his rights under the Constitution. But I don't believe they've yet said as a constitutional dimension any specific warning at any specific situation needs to be given. Yeah, it's my argument concerning the factors surrounding Escobedo that if Escobedo is a completely distinct and separate determination of a Sixth Amendment right as divorced from a Fifth Amendment right, which I think is pretty hard to do, then in order for it to be meaningful and effective, not just to the defendants, but to the people of the state, of the country, it's got to announce a rule which forbids affirmative conduct on the basis of police officers or prosecutors calculated in a given situation to deny the man the implementation of his right, whether it be the right to counsel or the right against compulsory self-incrimination. As I understand it, there's no right not to incriminate himself. The right is for him not to be compelled, whether it's subtle compulsion or direct, but it is still a right not to be compelled to incriminate himself. At least this is my understanding, and he doesn't have a right not to incriminate himself. He has a right not to be compelled to incriminate himself by some means, either direct or devious. Now, I think if the extreme position is adopted that says he has to either have counsel at this stage or intelligently waive counsel, that a serious problem in the enforcement of our criminal law will occur. First of all, let us make one thing certain. We need no empirical data as to one factor, what counsel will do if he is actually introduced. I'm talking now about counsel for the defendant. There, at least among lawyers, there can be no doubt as to what counsel for the defendant is to do. He is to represent him 100%. Win, lose, or draw, guilty or innocent, that's our system. And when counsel is introduced at interrogation, interrogation ceases immediately.
Why?
Well, for one reason, first of all, let's assume there's several different situations, but assuming counsel is immediately introduced and he knows nothing about the case, he's not talked to his defendant, he's appointed, say. He's appointed to an indigent defendant who says, I want a lawyer. I need a lawyer right now. I don't want to talk to you without a lawyer. He's given a lawyer. He talks to the defendant. Well, first of all, he stops the interrogation until he can talk to the defendant. I would think if he's going to represent him, he cannot allow him to say anything until he finds out what his story is, what he's going to say is going to, how it's going to affect him. So the interrogation immediately would stop for that purpose. And then after he has had an opportunity to confer with his client, let's assume another thing. Let's just assume his client said, yes, I did it. I'm guilty. Had all the requisite intents. He makes a statement to his lawyer in confidence that he did it and asks his lawyer what he should do. Well, the lawyer maybe doesn't know his past history. Maybe the lawyer would want to find out what the police have if he can. And so maybe more time would, in order to properly represent him, would be taken up here, time which there would be no interrogation. Let's further assume that he advises his client. Well, I think you ought to confess. I think there's a possibility for a light sentence. You did it. They have other evidence. Or maybe they don't have any other evidence. Let's say they don't have any other evidence. And you can confess. And the fellow says, well, I don't want to confess. I don't want to go to the gas chamber if I don't have to. Is there anything else that you as my lawyer can do for me? Well, what does he got to tell him? Then under our system, he's got to tell him, yes, you don't have to say anything. And the fact that you don't say anything can't in any way hurt you, be inferred otherwise, and we can put the state to its burden of proof. And
why does our system compel his lawyer to do that?
Well, as I understand it,
compelled by our system to do that.
Yes, I'm sure. It's my understanding that he is.
But why does it do it? For what purpose? What's the object of that on the part of the lawyer?
Because we believe that it's right and proper that the criminal defendant not be deprived of his life, liberty, or property without due process of law.
And something about giving testimony against himself.
Right. This is just the one issue wherein the lawyer has to guard all these rights. But I'm saying the practical effect of introducing counsel at the interrogation stage is going to stop the interrogation for any and all purposes except what counsel decides will be in the best interests of his defendant. Otherwise, counsel will not be doing his job.
Isn't that about the same thing as the practical effect and object of the amendment, which says he shall not be compelled to give evidence against himself? Is there any difference between the objects and purposes of the two, what the lawyer tells him and what the amendment?
Well, certainly that's the object of what his lawyer is telling him.
Well, isn't that the object of the amendment?
Well, that is the question. Whether it's, of course, the Fifth Amendment, he has a right never to be compelled to incriminate himself at whatever stage. And this is, of course, involving him a knowledgeable implementation of that right at this time if he wants to. What I'm saying is that the state does not have to, at this stage, insist on that right being enforced or waived. Because pretrial police interrogation does more than just develop confessions or it develops incriminating statements. It develops exculpatory statements, which pin a story down to a defendant very closely after the crime has been committed or very closely after he's been taken in police custody, which prevent or effectively make it unprofitable for him to perjure himself or change his testimony at the trial. Should he
Is
take a
anything
stand?
fantastic in the idea that the Fifth Amendment, that the protection against being compelled to testify against oneself might be read reasonably as meaning there should be no pre-trial proceedings when he was there in the possession of the state?
Well, of course, to me, I think there is. I think there's a valid interest.
With a valid interest, of course, if they can convict him, and more, that's the identity to try to convict him.
Right, but I think that, well, and this is another argument that I think must be made. Our adversary system as such is not completely adversary even at the trial stage in a criminal prosecution, because Canon 5 of the Canons of Ethics of the American Bar Association, which are law in Arizona by rule of court, says that the duty of the prosecution is not simply to go out and convict, but is to see that justice is done. I know I've talked to many prosecutors myself, and in my short time, I've gotten as much satisfaction out of the cases in which I was compelled to confess error in a case where a man has been deprived of his rights by due process, that I gotten satisfaction in being upheld in a tight case in our court.
You give defendants access to the state's evidence against them in your state?
Mr. Flynn would tell you more about that at the trial level. I don't believe that the rule has been interpreted very broadly. I think it's been interpreted narrowly. I think he can get his own statements, and perhaps he can get police officers' reports. There is a rule providing for motions, but the judges, as I understand it, have construed fairly narrowly.
So that it is possible to speculate, isn't it, that the state has limitations, places limitations upon its obligation to cooperate with the defendant, as witness the denial of discovery to the defendant, discovery of the evidence that the state has against him.
Yes. Of course, I'm sure the prosecutors would 100% go along with the full discovery for both sides, but
With
this,
what?
Well,
with full discovery for both sides, but this is...
Maybe the prosecutors that you know.
But this would do by the defendant. The defendant, of course, is compelled to no discovery, no ordinary discovery procedures in the scope we think of them in a civil case. So I just say this today. I'm not sure the analogy is completely.
The only point I was calling your attention is that there are in our system there are limitations upon the degree of cooperativeness on both sides. It's not just that the arrested person has under the Constitution a privilege against self-incrimination. It is also that the state, when it assumes an adversary position, even before that time, takes advantage of certain reticences, shall I say, with respect to disclosure to the accused person.
Surely it does, but there is no compulsion. In fact, compulsion is to the contrary on the defense side to cooperate, whereas there is complete compulsion, at least by my interpretation of the law, for the prosecutor to do as much, if it's available to him, to show that the defendant's innocence, prove is guilty.
Well, I think we've established in this colloquy that
doesn't always work that way.
complete is a little bit of an overstatement.
It doesn't always work that way. I'm sure that's the case. But this, here again, is another point that I emphasize. This is no reason, I don't think, for a constitutional rule which would, in effect, take care of what I consider to be the exceptions to the rule, rather than the general practice. I might just say, since I noticed my time is about up, counsel made a statement to the effect, in answer to a question of one of the justices, I forget which one, something about that why Miranda talked that maybe he was raised to tell the truth, or our society, you're raised to tell the truth and respect authority. This brings another thing into play, I believe, which is vitally important, and the prosecutors in my state consider it so, that if, in fact, you either have counsel or you don't, and it thereby seriously circumscribes interrogation and confession. You eliminate an early part of one of the most important principles, hopefully, in our criminal law, and that is to not just to convict, not just to deter, not just to put somebody away, but to rehabilitate, and at the earliest possible moment. And I don't have that many personal experiences, so we had a meeting with the prosecutors in our state, and many of the cases involving confessions and pretrial interrogation were the cases wherein a man has at least admitted he's done something wrong, were cases where the defendants were much more susceptible to rehabilitation at this stage. And if you foreclose this and you develop an attitude in the police officers, you take a personal attitude away. Many a hardened police officer, when he's developed a case of tremendous circumstantial evidence against a man, and yet the man sits there and keeps telling him, I didn't do it, he is going to wonder, there's a personal factor there, he's going to wonder, well, why doesn't this man confess? Why doesn't he say something about doing it? Even assuming now, arguendo, that it's not coercion, that I have no argument that whatever is considered coercion, whether it's subtle or otherwise, should not be used. But assuming that the interrogation is good except for that, he's going to wonder. And maybe he's going to go out and examine that eyewitness who saw him at 2 o'clock in the morning under a dark streetlight and examine his other evidence, because he wonders that personal element. He ought to confess. Here's all the evidence. It's a prima facie case. This is wiped out completely if you terribly circumscribe this particular pretrial investigation. This particular personal element is out. And he can say, well, I got the evidence. Maybe he's guilty, maybe he's not. I didn't talk to him. I don't know how he acts, how he turns up. And I think its defendants could be hurt as much as the prosecution.
General Taylor?
Chief Justice, members of the court. The state of New York is appearing not only in the present case, the Miranda case, but in the ensuing 4 cases that have been scheduled for consecutive arguments, in which these problems of the right to the assistance of counsel are raised. I think the state has appeared here as amicus numerous previous occasions when there has been a constitutional question in the general field of criminal procedure. The nature of our interest is stated in the opening statement brief, and I do not believe that I need to elaborate that orally. Excuse me. I should add that the brief has been circulated to the other states and has been joined by something over half, I think about 27 other states, as well as Puerto Rico and the Virgin Islands. Now, I'll try to say what I have to say in less than the allotted time, and my task of brevity is the easier because some things I might otherwise say I think will be said much better by others. And I'll also try to say a few things that, as I read the briefs, no one else is going to say, or at least say in the same manner. The factor common to all 5 of these cases is that a confession is received in evidence which was taken when counsel were not present and when there had been no waiver of counsel. And therefore, a contention that runs commonly through all 5 of them is the one that emerged, I think, most clearly in answer to Justice Black's question as to whether this is a matter of constitutional dimension under the 5th Amendment, or for that matter, the 6th or the Due Process Clause. If I may say... Pardon?
You said one thing common. Is there another thing common as to where they were when the confessions were made?
Well, the cases, well, they were all in detention. That's also
All what?
All in a state of detention. Yes. Otherwise than that, there is quite a spectrum of circumstances that these cases reveal. The surrounding circumstances are not uniform. Now, may I just state what the thrust of our position is, very briefly, before indicating likewise its limits and why we are taking this position. Our contention is that insofar as these cases present a constitutional claim, that a valid confession cannot be taken unless counsel is present or has been waived, that claim in constitutional terms, in the constitutional dimension, is not sound. In other words, Justice Black's question we would answer in the negative, that the Fifth Amendment cannot be, should not be read as requiring counsel to be present at the time the confession is taken. I will come to my reasons for that very presently. Our secondary position is that if the court should decide to enunciate a rule of that sort in constitutional terms, or other new rules pertaining to the validity of pre-arraignment confessions, those should not be applied retroactively, but should be prospective only. Now, before speaking in support of those two positions, and I intend to spend most of my time on the first one, may I make clear the limits of our position here and what we are not saying, because I think this is of almost equal importance. We are not taking any position for either affirmance or reversal of any of these 5 cases. That is because all 5 of them, as we see it, involve problems or possible problems that go beyond the limits of our contention here. In the Miranda case that's just been argued, there is obvious division of opinion about the characteristics of the defendant, about whether the warning that Mr. Justice Fortas' questions were directed to was given at a meaningful stage, what the significance of that warning is in legal terms. The other 5 cases involve questions of trial procedure in which we are not presently interested. They also, 2 of them involve a period of long detention from which counsel are making arguments derived from the McNabb-Mallory principles. We are not taking a position on those matters, and therefore we could not say that in any one of these 5 cases we are supporting an affirmance or a reversal. Secondly, may I make quite clear that we are not saying that new rules about requiring counsel to be present when an investigation is taken, interrogation is made, or confession taken, we are not saying that such rules are necessarily unwise, without merit. We say that these are not matters of constitutional dimension, but we do not say that they might not be very wise rules to adopt. In fact, we are saying that this whole problem of the assistance of counsel at the pre-arraignment stage can, we think, be more appropriately and perhaps better dealt with in the legislative dimension and in the area of judicial policy rather than in purely constitutional terms. Now, of course, insofar as we say there's no constitutional basis here, our position cuts against the defendants. But as I repeat, we are not taking a position against such rules found in other ways, through legislative means, through judicial policy or otherwise. Now, may it please the Court, the inclusion in these 5 cases of one federal case, the Westover case, number 761, I think underlines this distinction that I have been endeavoring to state. And it also discloses the one respect in which I think our position departs from that that's taken by the Solicitor General. As a federal case, this being a confession taken by federal agents and introduced in evidence in a federal prosecution, I would suppose that the Westover case is susceptible of disposition in non-constitutional terms under this Court's federal supervisory jurisdiction, as enunciated in the McNabb-Mallory cases and that general line of authority. As I read the Solicitor General's brief, however, he is saying not only that the Constitution does not raise a requirement of the presence of counsel, but is also saying that such a rule should not be laid down by this Court as a matter of judicial policy in the way it was done in McNabb-Mallory. Our position does not extend to that second step. We do not take any position one way or the other on it. I think it entirely appropriate to say, though, that would be a dimension in which we would consider this Court might very appropriately deal with the matter. One further thing
with respect, beg your pardon, can we do that with respect to the states?
No, Mr. Justice Fortas. I was pointing out that the Westover case brings out this. It's only in the Westover case that you can do that.
So what you're saying is that we lay down such a rule some way, somehow, short of constitutional basis.
Right.
For the federal courts and leave the states alone. That's what it comes down to.
Well, that's correct. The states are, of course, affected only by the constitutional dimension. The federal courts are subject to a broader range of review. I might add that in New York, our own Court of Appeals has noted and acted upon this very distinction between decisions in the constitutional dimension and decisions in the domain of judicial policy.
So what's the difference between this problem in those terms and the problem that this court handled in Gideon? Problem of right to counsel.
Well, if Your Honor is asking what the reasons for drawing a distinction between the trial stage and the pretrial stage may be,
and yes, in the terms in which you're discussing. In other words, would New York State have taken the position that Gideon was wrongly decided?
Wrongly decided, no. And indeed, in New York State, this would be treated now as a matter of constitutional requirement. There's no question about that in my mind. But in the dimension we're talking about, that is the pre-arraignment right to counsel. New York State held, prior to Escobedo, Mr. Justice Fortas, that whereas in Escobedo there is an interference by the police authorities with the access of counsel to his client, that this was, in the constitutional dimension, a violation of the defendant's rights. This case is cited with approval in the Escobedo decision. Just last year, it went further than that, the Court of Appeals, and held that if there is a telephone call from counsel to the police authorities asking that there be no more questioning of the client, that any questioning that takes place after that cannot result in admissible admissions or confessions. But when the further question was raised, in a case where counsel arrived at the station while a confession was being taken, the state made the contention that that part of the confession that took place before counsel arrived could be admitted, and not the latter part.
General, I don't want to take any more of your time. I just want to say that I think the problem is whether it's not too late in the day to make that kind of a distinction. I'm asking the question. That is to say that once this court has made the rulings that it has made and Gideon and Escobedo, I wonder if it's still of much avail to argue that we ought to draw the kind of a line that you're suggesting here.
Well, that brings me back to Mr. Justice Black's question and its relation to the ones that you have been putting, Mr. Justice Fortas, and that is whether there is anything in the Constitution, either in the Sixth Amendment, Assistance of Counsel Clause, in the Due Process Clause, or in the Protection Against Self-Incrimination, whether any of those clauses, together or conjointly, should be read as requiring counsel in the pre-arraignment stage. Now, it seems to me that if one is going to approach that question, one must enunciate a constitutional theory. Are we looking to history and original meaning of the Constitution, or are we looking to contemporary standards? Is the Constitution to be treated as fluid, with different and perhaps more rigorous meanings, obtaining by common consent at a later time, or are we to look to the original understanding, as has been called? Now, I suggest, with all respect, Mr. Justice Fortas, that in those terms, it's very difficult to support the contentions being made here, and the situation is quite different from Gideon. Quite different. I forget the exact number of states that already were furnishing counsel in all criminal trials at the time of Gideon, but my recollection is there wasn't more than a handful that weren't already doing this as a matter of state practice. Therefore, one had a very broad practice and consensus in the states on this very point. The same thing, if I may say so, was true in the MAP case to a lesser extent. In MAP, you had about half the states that were applying the exclusionary rule, and the trend was solidly in that direction. California had changed its view between Wolf and MAP, so that in both of these situations, you had a solid basis in practical experience in the states, and really your decision was not revolutionary in those terms. But in the dimension that we're now talking about, I don't know of a single state that presently excludes confessions that are taken in pre-arraignment in the absence of counsel. I don't think there is such a jurisdiction.
But it doesn't, isn't it a fact that most of the states have a regulation that a prisoner shall be taken forthwith to, before a magistrate, and they're advised of his rights, and so forth, and doesn't practically every state in the Union have a clause preventing people from being compelled to testify against themselves?
Indeed, that is so, Mr. Chief Justice, yes.
And so in that respect, we're not much different than Gideon, are we?
Well,
They weren't, there were just an awful lot of states that weren't giving counsel up to the time of Gideon. They had a rule on it, maybe, but they weren't according to counsel.
my understanding is that at the time of Gideon, all but a very few states were indeed according full right to counsel at the trial stage, which is what Gideon related to. And what I'm saying is that we have no such basis in precedent and established practice when we're coming to the pre-arraignment stage. Nor do we have...
Constitutional doctrine, that's something that indicates wisdom, but that's not the same thing as saying that's not addressed to the question of a historical interpretation of the Constitution.
No, indeed. On the basis of historical interpretation, I think one would be hard put to it to find any basis for finding the right to counsel at the pre-arraignment stage, much less the right to be furnished counsel if you are indigent. And therefore, it seems to me the stronger argument for the claim advanced here is not the historical basis, but the common consensus basis. And it is on that basis I was suggesting, Mr. Justice Lourdes, that we don't have the Gideon situation here at all. This court is being asked to enunciate a rule for which there is no basis in the prevalent practice.
Gideon, there was no claim made that the result that she arrived at in Gideon was based on a historical interpretation of the Constitution. It's based upon a reinterpretation of the general constitutional guarantee.
And for that reinterpretation, there was abundant support in what one could see around one, and a commonly accepted view that this was a very desirable thing. We don't have that here. Thank you, Mr. Chief Justice.
General, you haven't gotten to your second point, and there are only 2 or 3 minutes until closing time. Would you mind addressing yourself to that on the question of retroactivity?
On retroactivity. Well, actually, Mr. Chief Justice, that point flows, I would think, as a matter of logic from our first proposition, if that be accepted. If, as we see it, this is not a constitutional claim based on an original understanding, if this is a matter that will be evolved from contemporary practice and changing standards, why then it seems to me that to apply such a rule retroactively presents considerable conceptual difficulties. And I find no conceptual difficulties in a prospective application. The court has confronted this now twice in Linkletter and in Tian. We have set out in our brief the reasons why it seems to us the considerations the court went on there are applicable here. I might say also that if we are to hope for legislative progress and for action within the states by their own courts, why a principle of retroactivity may be a damper on change and improvement rather than a stimulus to it. This would tend to freeze things and make people reluctant to develop new practices, that if everything else has to be unwound, going all the way back to the beginning to make the new practice prevail.
We'll adjourn.
What's up, everybody? What'd you guys think of that? What'd you think of that? Swilly, it's not like Brooke wants to talk to you anyways. There's a link pinned at the top if anybody wants to come up and holler and give their opinions on it or any knowledge on it. Feel free to come up. What's up, R. Boyd, Steak, JD, James Swilly, M Star, Steak. Thanks all of you for hanging out with me and listening to this. It's It's a crazy case, really. Crazy how big of a case it is compared to, how simple of a fix, I guess. Yeah, great history. What's up, Jingy? So that was the February 28th oral argument. There's a total of 5 altogether. There was 1 on February 28th, 3 on March 1st, and then 1 on March 2nd, all 1966. So it sounds like Flex Your Freedoms is free. If anybody's seen Grandma get arrested earlier, it was pretty good. Was a pretty good one.
The Escobedo decision and the Dorado interpretation.
Mr. Nedred?
Mr. Chief Justice, the pleas of the court, my name is Dwayne Nedred. I'm counsel for the Amicus National District Attorneys Association. My co-counsel is Ms. Alberto. I thought that her presence might show that prosecuting attorneys are not all bad, or she wouldn't be working for us on a full-time basis. I may use some words of one of the justices of this Supreme Court. The Escobedo decision and the Dorado interpretation makes it more necessary than ever that we stop and look where we are going. If we are talking about equality between the rich and the poor, we are striving for a worthy objective. If we are talking about equality between the policeman and the criminal, we are on dangerous ground. I would remind this court that we are not talking about the police versus the defendant. We are talking about the people versus the defendant. In the same way that we would not talk about the Army or the Marine Corps versus the Viet Cong, but we would talk about the United States versus the Viet Cong. I have not mentioned in my brief anything about the Fifth or the Sixth Amendment. I concede that this court can interpret those amendments in the way that it sees fit. I am willing to agree with the ACLU in their brief in one point, where they quote me, although they do misquote me when they refer to Malloy and Haynes in substitution for on page 26 of their brief instead of Haley and Payne, whom I consider entirely different. That an admonishment in the Dorado interpretation will not affect materially confessions. If this is to be our objective, to limit the use of the confession in criminal cases, then you are taking from the police the most important piece of evidence in every case that they bring before a court of justice. Police officers are public servants. They are not attempting to put innocent people in jail. They want to follow the dictates of this court, and they will follow them to the best of their ability, but they too are human beings. They do have, however, an experience and knowledge, which many of us lack because this is their job in investigation of crime. And we have not as lawyers, paid attention to their problems. We have seldom been down to the police station and asked, what can we do to assist you in your problems? We are more inclined, and I talk about the prosecuting attorneys, and I am not referring to this court any more than any other lawyer in the United States. In the case, if I may use the present case of Miranda as an example, the defense admits that there is a voluntary confession. He says that we should not allow this confession because he did not have counsel present, because we would not have been able to convict him, because there was no other evidence except his own voluntary statement that his male organ had penetrated a half an inch. Otherwise, he would have been acquitted. Is this what we are looking for, to acquit Miranda because he did not have counsel? The amicus here has presented data covering thousands of man-hours on the part of the members, attempting to show the widespread use of confessions. I am not saying that the widespread use of confessions justifies their use. I am just attempting to present to you, through our members, the importance of the confession in our criminal administration of justice. I believe that there is something beyond that which we are discussing here. I think that there is a need, and I have mentioned this and I pray for it, that all public servants, law enforcement officers and prosecuting attorneys, trial courts and members of this court, work together. We are not adversaries. There is a need, I think, on the part of the people to be able to refer to my policemen, our police, my court, and not those cops.
You
or
think
those
we ought to
police.
overrule Escobedo?
Sir,
Is it your position that we should overrule Escobedo?
if I knew what Escobedo meant, I may say so, but I have said in my brief, Mr. Justice Fortes, that I think that Escobedo should never have been appealed in the facts of the case. I think that this court rightly reversed the case on the facts.
You're not urging that we overrule Escobedo?
No, sir. It's a system, our system of justice, in effect, which we need as a matter of change. I do not attempt to say that defense counsel is wrong when they attempt to do the best they can for counsel. This is our system of justice. But I could tell you, for example, in the state of New York, that when a defense counsel is picked by those who are in the profession of of crime, I can use this, that they wonder who is hot, for example, in winning cases now, and they are picked almost like as if they were racehorses, because now they are winning. There is nothing so fickle as a criminal defendant. He wants only one thing: he wants to win. Now, if a prosecuting attorney only wants to win, then we should not have that prosecuting attorney in office. We should make a change.
May I ask you this, please, Mr. Nedrud? If you agree on the facts that Escobedo should have been reversed, what would you say as to the man who did not have a lawyer, but who said he wanted a lawyer before he talked?
If he asked for a lawyer and he does not waive his right to counsel, I think that he should have a lawyer. I think that even the state should have, I would go so far as to say I think the state should appoint him a lawyer if he asked for a lawyer. I do not think, however, that we should, in effect, encourage him to have a lawyer.
And why do you say we should not encourage him to have a lawyer? Are lawyers a menace?
Mr. Chief Justice, a lawyer must, in our system of justice, must attempt to free the defendant. This is his job.
Because it's his professional duty to raise any defenses the man has.
Yes, sir.
You think in doing that, he's a menace to our administration of justice?
I think that he is not a menace at the trial level. He is not a menace per se, but he is, in doing his duty, is going to prevent a confession from being obtained.
When does he cease being a menace?
Mr. Chief Justice, I did not say he was a menace.
Well, you said he did if he injected himself into it before the trial level.
I merely said that he, in effect, will prevent a confession from being obtained. And if this is what we are looking for, then we should appoint a counsel even before the arrest stage. Because the moment that a murder takes place, the government is out looking for the criminal.
Well, if a lawyer, as you say, he's entitled to a lawyer under the facts of Escobedo, and the lawyer is entitled to tell him that he doesn't want him to talk to the police, why would it be a menace for another lawyer whom the defendant wanted to do the same thing?
Mr. Chief Justice, I'm not disagreeing with you one iota. I am just saying that if, in effect, that this is what should be done, if you want to equalize, for example, the defendant's right against the policeman, naturally, he should have counsel, if this is what we are striving for.
Well, suppose we put it on the basis of not equalizing anything or balancing anything, but on protecting the constitutional rights of the defendant, not to be compelled to convict himself on his own testimony.
Mr. Chief Justice, I, of course, do not interpret the Constitution. This is, of course, your prerogative, sir.
How do you interpret it?
I do not interpret that the defendant is entitled to a lawyer until the trial stage.
When does that, until the trial starts?
Yes, sir.
And where do you get that authority?
As I read the Constitution, you asked me my opinion. I said I have no authority to interpret the Constitution. I am saying that this is the way I read the Constitution.
Has that been the way this court has read the Constitution in days gone by?
I believe so.
Well, counsel, everybody knows that if he's appointed a lawyer at the beginning of the trial, that the lawyer can't possibly represent him. He needs time to prepare for trial.
Yes, sir.
So the appointment must be at some point anterior to the trial.
Mr. Chief Douglas,
And our question here is, at what point? How far anterior?
Mr. Justice Douglas, I am not concerned when the lawyers enter the stage, and maybe part of our problem is that the prosecuting attorney enters before he should.
And under the procedures in some states, as you well know, very important rights can be lost many days, many weeks prior to the trial.
Mr. Justice Douglas.
So we come down to the question as to dealing with the Constitution that conceitedly, I would think we'd say conceitedly, everyone is entitled to a lawyer at the trial and also at some point anterior to the trial.
The question comes, I think, Mr. Justice Douglas, whether or not we are going to allow the trial court to determine the guilt or innocence, or the defense counsel. If the defense counsel comes in at the arrest stage, he will, as he should, prevent the defendant from confessing to his crime, and you will have fewer convictions. If this is what is wanted, this is what will occur.
I guess there's no doubt, is there, that the provision which provides for the protection against giving compelled testimony as a consequence, fewer convictions.
Justice Black, this is true. However, again, we're talking about the voluntary, involuntary rule, and I have not questioned this whatsoever. This is, I believe, a good rule. I have said that Mapp versus Ohio is a good rule. I believe, however, that there is a point of diminishing returns, and that at some stage, the police must be in a position to protect us.
Some stage, according to our opinion, he's entitled to a lawyer at some stage. And we've said, as I recall it, haven't we, that that's at the stage when he needs it.
Well, again,
At least after he's been detained. What about the point where a man is seized by government agents, and they are, as you say, they are our agents.
Yes.
They are our officers, and there's no antagonism between them. But what about the fact that when they're seized by someone who has power to detain them, keep them away from his friends and their relatives, and in seclusion if it's desired? Can you think of any time when he had needed a lawyer more than that? At the point of detention.
Mr. Justice Black, again, the question is, are we interested in convicting the defendant, or are we interested in protecting or acquitting him? This is the point, the only point that I can in effect make. If you say that this defendant needs counsel at this time, for example, let me, if I may use this illustration. I worked when I was a professor of law, which I was prior to taking this position. I worked on the defense project for the American Bar Association, and in the questionnaire, there was a statement, when is the ideal time for counsel to be appointed for the defendant? The question is, when is the ideal time for whom? The people or the defendant? Now, if it is for the defendant, then it is the earliest possible opportunity. If it is for the people, it should not be until a critical stage. If it is White versus Maryland, I agree. It should be at the preliminary hearing stage. If it is in the question of arraignment, as in Alabama, I agree. If it is at the trial stage and he has lost none of his rights, which can be interpreted in one way or another, then I say that it should be at the trial stage.
Well, as a prosecutor, I've found over many years, it's a very critical stage when a person is taken to a police headquarters. Nothing wrong with it. That's our part of our government. Taken to police headquarters under arrest or under detention. He can't leave unless he wants to, unless they will let him. Would you call that voluntary for him then, for them to have him there in that situation and probe him about his probable conviction of a crime? Would you think of that as voluntary?
Being voluntary in the police station? No.
I suppose you'd say, wouldn't you? It's a question of fact for somebody to decide.
Well, I would.
Context of the different circumstances that have arisen.
I would hope, Mr. Justice Harlan, that this court has protected, as I refer to in mine, the Rex and the Pates, by an involuntary rule, the totality of circumstances. And I hope that this court will also continue to invoke this rule, but not go so far as to prevent the police from protecting us.
And then I don't know. And then
Number 760, Michael Vignera, petitioner versus New York. Mr. Earl.
Mr. Chief Justice, may it please the court. This is another confession case arising out of a conviction of first-degree robbery after a trial to a judge and a jury in Brooklyn, New York. The petitioner, Michael Vignera, was sentenced to 30 to 60 years. His conviction was affirmed without opinion in the appellate courts of New York. Briefly, the facts are these. Sometime during the morning of October 14th, 1960, Vignera was arrested in Manhattan after having been singled out by a Confederate. The Confederate had been arrested earlier that same morning while attempting to use a stolen credit card registered in the name of one Harry Edelman. Viniera was first taken to Manhattan Police Station and then transferred to another Manhattan Police Station for questioning. At the second police station later that same morning, he was identified as the man who had robbed a Brooklyn dress shop a few days before. Identification was made by the victim, the same Harry Edelman, and an eyewitness. Then, under police questioning, Viniera admitted having committed the holdup by means of a toy gun, having obtained $93. Sometime thereafter, at about 3 p.m., he was formally arrested. Later that day, he was taken to a Brooklyn police station for detention. At the Brooklyn police station at about 11 p.m., Viniera's deposition was taken by an assistant district attorney and a hearing reporter, and that recorded confession was introduced to the subsequent trial. It amplified the earlier admissions given to the police officer, included such additional details as the time of the day of the robbery, the fact that Viniera was operating alone, the weapon was concealed, number of persons in the dress shop, lack of pre-planning, and the like. The next day, on the way to court, Viniera was again questioned about the weapon. Apparently his story didn't jibe with that of the victim, and he finally admitted that, in fact, a knife rather than a toy gun had been used. And it is conceded, although the record admittedly is silent, it is conceded that at no time was Viniera ever advised of his right to counsel or to silence. For example, the confession, which purports to be a verbatim transcript, has no recital of any kind as to a warning. It was not the practice in New York to give such a warning at the time. I think it's entirely fair to assume that no such warning was given.
When you say that he was never advised of his right to counsel, aren't you, A, begging the question, and B, giving up a good deal of your position? Because one of the questions here is, does he have a right to counsel?
Well, you asked that yesterday, Mr. Justice Stewart, and I want to make it perfectly clear that my position is crystal clear, that he had a right to counsel the moment the state proceeded against him. And the moment when that moment arose, it was at no earlier, or no later rather, than 3 p.m. on the day the police formally arrested him. As a matter of fact, in the court...
You had the right to counsel in the Gideon against Wainwright...
Absolutely.
The constitutional right to counsel.
Gideon decided that question.
Well, then I think you lose your case, period, because then it was the duty of the state to provide him one.
Not necessarily.
Why not he asked for one?
I don't agree with that, Mr.
That's
Justice
what Gideon
Stewart.
holds.
Gideon holds that he had the right to counsel.
He had to affirmatively waive it, then.
He has to affirmatively waive it. That's absolutely correct. And he has to begin to waive it by the police making a showing of waiver. The burden is on them to show waiver. But in Escobedo, the court said in its footnote that the right to silence and the right to counsel can be waived. And I accept that. That's the majority of the court. Now, the beginning, I would think, the Constitution doesn't require a warning.
I misspoke. Because
the police, I would suggest this is a remedy to the police. If they have some other remedy, fine. But I would think the beginning would be to warn him of his rights in a very meaningful way, perhaps to record the warning.
Well, in the beginning, if you're right, then the beginning is just to provide him a lawyer without warning him or telling him anything
Well, that
else.
would certainly be an easy way of handling it, but...
It's the only way to satisfy the Gideon rule, isn't it?
No, I don't think it is, Your Honor, again, because of the waiver point. They obviously don't want to assign counsel. The police aren't very well equipped to do it, and they have to give them. They will want undoubtedly to try and get them to waive. If they can do that, I say the Constitution, at least at this point, history doesn't require any more. Although I should add that even if they get a waiver, we have to look rather suspiciously of that kind of a waiver, and it wouldn't entitle the police to hold him in custody indefinitely even after such a waiver. It would be a very limited waiver concept, in the sense of a principle comparable to McNabb and Mallory.
Well, would he have to have a counsel if the police, when they arrested him and detained him, took him in charge, just left him alone and asked him no questions?
No, I don't think.
Let him answer. If he said anything voluntarily, that might be one thing. But if they interrogate him, then unless they interrogate him, he wouldn't need a lawyer.
Well, I'm not so sure about even spontaneous statements once the accusatory stage has been reached, Mr. Justice Black. But I do think that if they locked him up and didn't get near him, didn't use him in a discovery sense as a device to participate in his own subsequent conviction, that he would not have to, a lawyer would not have to come to the police station. Because he has to be prejudiced.
He wouldn't need one, would he?
It would probably be very helpful for him so the lawyer could investigate the case along with the police. But in terms of criticalness that you were talking about a moment ago, he has to be prejudiced at the trial. I don't think it would be critical if nothing is happening. Once they start a process that tends to undermine the Fifth Amendment privilege, it is certainly very critical. And I might say that it's been perfectly clear from what General Taylor said yesterday and some of the other arguments that many of the briefs want you to overrule Escobedo, and their attacks, I think, have been very thinly veiled. I'm going to assume that Escobedo represents the law in this court and in this country.
May I,
Which part do they want to have overruled? I think the majority opinion in its entirety, Your Honor.
The holding or the rhetoric?
Well, if you mean by rhetoric, Mr. Justice Stewart, the several references to the Sixth Amendment, I think they're part of the holding. And when the Solicitor General's brief talks only about the Fifth Amendment, I'm only perplexed. I read what I read, and that reference is in there several times, that there is a right to counsel. And the critical stage can occur prior to arraignment and prior to trial.
Mr. Earl, may I ask your help on precisely that point? Let's suppose that this conversation, which, as I remember, it took place in a police car going from point A to point B, in which Viñera said something or other about the weapon. Let's suppose that had been the first act here before any other, the first statement that Viñera made. In short, assume with me that the police picked up Viñera, then in the police car going to the station, Viñera said that he did it, that he did the hold-up, and he used a knife. Now, would that be inadmissible because of the absence of a warning or the absence of counsel?
Mr. Justice Ford, if you asked a question like that yesterday, I think the question of does focus and arrest come at the same time? I think that in the hypothetical you gave, the statement might well be admissible. Certainly, a laying on of hands is an arrest, but the probable cause requirements, and there was, I think, probable cause satisfied here because he'd been singled out by a Confederate. The probable cause requirements are probably not the same as the determination that the state has charged him and has begun its proceeding against him. I can conceive of examples, for example, when the police have to make on-the-spot judgments, take in 4 or 5 people who may have been involved in a crime, 4 of them exculpate themselves and they're sent home, and the 5th is proceeded against. Maybe he's picked out of the lineup by the eyewitness. At that point, it becomes clear that the accusatory proceeding has begun, and then he'll have to be, well, then the police are going to have to show waiver. Any statement after that, in the absence of waiver or in the absence of counsel, will be inadmissible.
Well, how do you apply that to my example? I'm really soliciting your help.
I think your example.
Because I think this is the problem, as I think Mr. Justice Douglas's questions indicated, that this is a real problem of defining with such precision as is possible and advisable the point at which the warning has to be given or counsel provided or both. So that, here you have a man who is taken into custody by the police. It's an arrest in the sense that he cannot thereafter leave. The police have him. And then on his way to the police station in the police car, he makes a statement that is in effect an admission. The question is, would that be admissible, in your opinion, if it were made prior to the warning having been given and prior to the offer or appointment of counsel or the waiver thereof?
In the absence of any form of coercion, Mr. Justice Fortas, I think it would be admissible. I'd like to give you a different hypothetical, though, to show you that I think, in my judgment, this thing would vary. For example, even before arrest, the accusatory stage might come into being if, in a situation, government agents had a man under surveillance and saw him commit some very suspect acts and then laid their hands on him. I think there, it would be perfectly clear they were proceeding against him, and you'd move the stage even farther back. But in a more typical situation, as in Viñera's, I think the accusatory stage doesn't begin until sometime after hands have been laid on and he comes to the police station. Here it may have been after he was identified.
Forgive me, I don't want to take excessive amount of your time, but is this what you're saying, that when the point of time comes where it appears that the police have enough information to satisfy themselves that the fella really did the act, that then the right to counsel or to warning attaches and not before? Is that what you're saying?
I think that is correct, although we don't have to look into the minds of the police necessarily. We'll be able to determine that, and they should be able to determine that. And if they're in doubt, I think some people will say, well, how do the policemen know this? If they're in doubt, give the warning, push it up, err on the side of the warning. But that's why I don't see why it should pose so much of a problem. I think the FBI agents who have been giving this warning for so many years probably err on that side.
What should this warning contain, in your view?
Well,
Talk about a warning. What should this warning be?
The chief of police in the District of Columbia last August promulgated a warning, which I understand is now being given by all police agents police officials in the district. It goes something like this. You have been placed under arrest. You are not required to say anything to us at any time or to answer any questions. Anything you say may be used as evidence in court. You may call a lawyer or a relative or a friend. Your lawyer may be present here and you may talk with him. If you cannot obtain a lawyer, one may be appointed for you when you first go to court. I might have a little bit of a quibble about that third point, because it suggests a little bit that you might not be able to get a lawyer now.
More than a little bit of a quibble on the basis of what you told us so far.
Excuse me?
Much more than a little bit of a quibble, I should think, on the basis of what you've argued so far, that he has an absolute right to a lawyer to be appointed for him at that point. That's what I understood you to say. Unless he waives it.
Unless he waives it.
Yes.
And then the question might come up, well, what do the police do when the fellow says, well, thanks, I'd like a lawyer, as a matter of fact, now that you mention it.
Yes.
I don't happen to have any money. They have a very simple choice. They can give him 10 cents and the phone number of the Legal Aid Society, the public defender. And if that bothers them, if they're unwilling or unable to do that, they have another alternative. Just stop interrogating him. That alternative is never mentioned by anyone.
Well, I don't quite yet understand the answer to the question I asked you. What should the warning contain? Not what you read us, obviously.
Well, what I read, I'm satisfied with.
As far as it goes, but that's not enough, is it?
I think it's enough if it's made to an adult who is not a moron or who has his faculties. I think that's probably enough.
Well, then he's not entitled to a lawyer until the trial begins.
No, that's not correct.
Well, would you read again what the warning was?
Well, let me do this for you. I didn't write this warning.
No, but you now say it's sufficient, as I understand.
I would be happy with the first two sections of it. One is, you've been placed under arrest. You are not required to say anything to us at any time or to answer any questions. Anything you say may be used as evidence in court. Two, you may call a lawyer or a relative or a friend. Your lawyer may be present here and you may talk with him. Now, they've got a three that I just wouldn't add.
Good. In other words, you stop right there and you say that was sufficient.
That's right.
Well, then what happens? What if the fellow says nothing at all?
Absolutely nothing?
Well, they did. They give him the warning, and he nods his head, yes.
Well,
I hear you. And then what happens?
It takes a conscious relinquishment of a known right for him to waive his rights, those two basic rights you've been talking about, Mr. Justice.
Well, I understand. I thought that's what you would say. Now, what happens then? The fellow says, he just nods his head, just looks at him.
Well, if we can believe that he nodded his head, it's possible that he waived. I'd be very reluctant to come to that conclusion on that hypothesis.
Well, what besides giving the warning and the failure to request counsel?
I think if the warning is recorded, if he writes down in his own handwriting that I have been warned, I understand that I have a right to a lawyer now to talk to him right this minute if I want to, or I have a right to say nothing if I want to, I understand that, but I would like to go ahead and cooperate with the police, sign Michael Vignera, that would be enough.
So why would that warning, that's just barely the first stage.
Well, that's what the police have to say.
Sure, the police have to say that, but if they want to rely on a waiver at any time, which is the only ground that you would accept for a lawyer not being present, is a written waiver, isn't it?
Oh, I think that's right. I think it should definitely be recorded in some way.
There should be a written waiver of
Absolutely, and it shouldn't be something that he's conned into giving.
And just the giving of the warning is only a minor first step.
Well, Mr. Justice Stewart asked for me to read the kind of warning that would satisfy me. Those are the words that I think make some sense. But it's got to be made meaningful to him, and he's got to acquiesce in it.
Well, what if he doesn't waive and he says, "I do want counsel," and the state says, "Fine, here's a dime and there's a legal aid number," and the fellow calls him, and he talks to the lawyer. And he comes back and sits down, and you ask him some questions, and he answers them.
Without his lawyer being present, for example?
Yeah.
Well, I take it that would be the decision made by his lawyer, and lawyers can waive rights for their
Well, is
client.
that a waiver in your book?
It's
Well, what is it? Is it the waiver of the right to consult counsel, or the waiver of the right to have counsel present?
I think it's a waiver of a right to have a lawyer in all the sense that is always meant.
So
And the
what
lawyer
you-
can make a determination whether he wants to be present or not. Lawyers have waived many rights, including cases that have come to this court, not filing on the 30th day and notice of appeal and the like. And if he makes his decision to throw him to the wall.
Yeah, but this, my question was really going to what you think the scope of the right is. You think the scope of the right is to have counsel present, and that you must find not only the waiver of the right to consult counsel, but the right to have counsel present.
I think that is right, Mr. Justice White.
Well, I just wanted to know what your position was.
Just, for example, right, but I want to elaborate on it, if I might. In a deposition in a civil case, for example, customarily the plaintiff and defendant would have counsel present. But I could certainly conceive of one lawyer deciding not to be present, and his client, through him, would thereby waive that right. Well, it seems the only way we can distinguish this case from Escobedo is the fact that Venera did not make a request. And what we've been talking about with respect to waiver, I think, governs that. Obviously, it wasn't the request that makes the right attach. The right attaches when the state proceeds criminally against the individual. The significance of the request, I think, in Escobedo was that was an objective piece of evidence to show that that stage had been reached there. Actually, it's even clearer in Venera that in this case, that at least by 3 p.m., the stage was clearly reached. There's an independent ground to support reversal in this case, and that is the fact that Venera was detained for an unnecessary period of time. I think that's true both under state law and as a matter of common reasoning. He was, even after the accusatory stage had clearly reached, the police had formally charged him. He was not then arraigned. He was not arraigned for nearly another 18 hours. And I think the point you raised yesterday, Mr. Justice Black, doesn't detention, and I would add especially prolonged detention, doesn't that cut down on the Fifth Amendment privilege? Doesn't it whittle it away? Doesn't it undermine it necessarily? And I would say that it certainly does. As I said earlier, I hope the principle the court adopts is one which combines warning with a rule at least analogous to the guidelines set down by McNabb and Mallory. So even if there is a waiver, the man can't be detained indefinitely. Of course, in my case, there wasn't even a waiver. And there was this.
How can there be a waiver if these are absolute constitutional rights of the importance that you emphasize? How can anybody waive them without the consent of counsel, without the advice of counsel? Doesn't he have a lawyer? Doesn't he need a lawyer before he can waive them?
Well,
right.
They're entitled to waive them in other situations. It's true in court. When they want to plead guilty, for example, that the judge will and decline assignment of counsel, the judge will typically interrogate him at some length as he realizes the significance of his act. And that is a lot more visible a situation and more conducive to our being receptive to the idea of waiver than a waiver in a police station. I agree that that's probably the worst place you can. The party alleging waiver has control over the party alleged to have waived.
Right. So if you're right, it would seem to follow, I should think, that he needs a lawyer before he can waive his right to a lawyer. He needs the advice of counsel.
I wouldn't be terribly unhappy with having lawyers in the police station, Mr. Justice Stewart. I'll be grateful.
Well, I should think it would follow naturally.
Well, it doesn't follow naturally because the majority of the court in Escobedo said these rights can be waived. I think we do have to recognize some of the realities of law enforcement. They do have to investigate. They do have the hurly-burly of crimes that are being committed by the minute, and they do have to operate out of a police station. I think when we're dealing with adults, if we use tape recordings, if the police go to great lengths and indeed do it with a professional spirit, with a spirit not of antagonism, but a spirit recognizing that they are inevitably in an adversary situation, and the man they're dealing with has rights, and they want to protect their conviction. They want to make sure they can get a conviction. They don't throw it out by some careless error. And I might say this is a good example, this case, of where the constable certainly didn't blunder. Here at midnight, after all these hours of detention, a member of the bar marches in with his stenographer. I mean, it certainly was deliberate. There's much talk in the briefs, the SG's brief, about the exigencies of the moment. The exigencies of the moment weren't bothering the assistant district attorney. He was just operating his convenience at 11 p.m.
Is there a claim in this case that the admission was coerced?
In no sense, Mr. Justice Harlan. I don't think it was coerced at all. But I like to say Mr. Justice White asked yesterday, question about compelling someone to give up his Fifth Amendment right, his privilege. And I think there's a substantial difference between that and coercing a confession. It wasn't until 1964 that the Fifth Amendment privilege applied to the states. And so the court inevitably, all through until the 60s really, state convictions were overturned only by looking to the generality of the totality of circumstances under the Due Process Clause. Now we have specific constitutional guarantees that are applied in root and branch to the states, both the Fifth and the Sixth Amendment rights. And it's true that the word compel is used in the Fifth Amendment with respect to the privilege, but it's quite different to say that the privilege is cut down or impaired by detention, and that a man's will has been so overborne that a confession has been forced from him. And I must say, I was a little perplexed to read the Solicitor General's brief when they talk about the principle they would have the court adopt is basically a Bram principle relating to the Fifth Amendment privilege. Then they support that with citations to coerced confession cases, talking about having one's will overborne and going back to the totality of circumstances. The trouble with totality of circumstances in this field, and that would get us back to Betts v. Brady, Mr. Justice Fortas, that you mentioned yesterday. Betts against Brady was not a right to counsel decision. It was a due process decision. I hate to sound too cynical, but if we go back to totality of circumstances, that means that this court will sit all by itself, as it has so many years, to overturn the few confession cases that it can take, necessarily by the bulk of its work. And the lower courts won't do their job. We need some specific guidelines, as is this Escobedo, to help them along the way. Well, you can't decide every case in advance, Mr. Justice White. I don't think it's that hard to tell, for lawyers certainly, or for their trained agents, to know when they've made up their minds to charge someone. The English seem to have no trouble with it. In fact, the New York police for years have had this fiction of saying, I arrested him at such and such a time, that time being long after he was taken into custody. What they meant was I'd made up my mind at that point to charge him. So all I'm saying is that you make up your minds, so give him a warning. I can't understand what all the fuss and feathers is about.
Charge, so far as a charge by the government goes, is usually a rather formal thing. It's an indictment or it's an arraignment on a charge. The various procedures in the states vary, but that's an identifiable event because it's a formal event.
That's true. As Judge Friendly said, we're talking about something here that is short of any defined legal stages, and I agree that that is so.
I'm interested in your statement, Justice Harlan, that there's did you say absolutely no coercion in this case?
Well, there's no claim of coercion. I certainly
suppose it's, what do you mean by coercion?
Well,
you mean completely free from all compulsion. Compel means compulsion. Do you mean completely free from any governmental compulsion?
No, it was not free of that, sir.
Why wasn't it?
Because he was in official custody and questions were being asked of him by officialdom. And questions suggest the right to receive answers.
What you mean then by was not coerced is what?
I mean that it was not coerced in the context of the coerced confession cases that this court has decided until now.
We are now talking about the Constitution.
That's correct.
As well as the confession cases.
That's right.
What about the compulsion here? Can you say, or do you think that the Fifth Amendment, the Amendment to Protection means men must not be under compulsion to give a statement?
I think it does mean that. That's right.
Well, does that mean free from all compulsion? Are we to construe the Constitution, like you said in Boyd, against the United States, giving all liberality to what it means and what was intended to protect?
I think we should. I think you should.
Well, if that is true, can it be said that this man gave the confession free from all compulsion?
He certainly didn't in the Fifth Amendment sense.
Well, that's the sense we're talking about.
That's right, Your Honor. I was merely making a distinction between that and the coercion cases.
You're making it.
Yes, under the Due Process Clause.
That's right, and it didn't refer to compulsion. That was the idea of looking at all the circumstances.
That's right.
To see if it's too offensive to the court.
And it looked.
And the constitutional provision is that they shall not be compelled to give witness evidence against themselves.
That's correct, but those cases also look to the subjective mind and volition of the accused. And I say that that's irrelevant in the Fifth Amendment sense. That's right. I think a volunteer statement is out if it comes after the accusatory stage. No question about it. On the other hand,
Now you're getting pretty close to the rule that prevails by statute in India, where no statement of any kind by a person in custody to the police is admissible in evidence.
in the absence of waiver, we would be very close to that, except that prior to the accusatory stage, the police would be entitled to screen, put people in lineups presumably, and even ask questions on the way down to the police station. They do have the duty to investigate crime, and it's certainly a duty we have to recognize.
Seems to me that in this case, while the two merged to a certain extent, there's been almost complete emphasis on the right to counsel.
Well, I don't mean to imply that.
Rather than emphasis on the fact that the man is not to be, government is not to take confession from him by compulsion, whatever that compulsion is.
Mr. Justice Black, I think that detention, particularly prolonged in a police station, is inherently compulsive. And there's no question but the core right that lawyer should be able to protect if he gets the chance is the privilege against self-incrimination. And that was the chance that never arose here.
We've only been there 15 minutes, and they say, you are under arrest, we think you committed a murder, and we are taking you down, and we're going to interrogate you. Do you think he's under any compulsion when they ask him the question?
I think as a matter of logic, he is.
Well, logic, I'm talking about fact.
Well,
reality.
As an advocate, I'm constrained to be bound by the opinions of this court, Mr. Justice Black, and no decision has gone that far.
We are reviewing a whole series of cases with reference to the extent, coverage, and protection of the Fifth Amendment and the amendment which provides the right to counsel. And whatever we've said in the past, there's no reason why we shouldn't discuss, and counsel shouldn't discuss, as I see it, how far they believe the Fifth Amendment's protection actually goes, and not without regard to what we've said in the past.
Well, to answer your question specifically, I think the privilege only comes into play once the accusatory stage has been reached.
Once what?
The accusatory stage has been reached. So 15 minutes might not be enough in a given case, or it might, depending on the facts.
Then you want to get back to Betts versus Brady?
No, I don't. I get back to Escobedo v. Illinois. I'm perfectly happy with that decision. The reason for that, Mr.
Well,
Black,
if you're going to determine it each time on the circumstances after a man's been arrested, means that someone has just said for you, this court will take him up one by one, and no court in the land can ever know what violates that right not to be compelled to incriminate yourself until it comes to us and we finally decide.
well, that's the last thing that I want, as I tried to say earlier. I think that this stage is going to come
A
very
little
early.
more than we are capable of doing.
It certainly is.
Present capacity to work.
It certainly is. But you see, my problem is this. The police have to investigate crime, and they have to talk to suspects. And I think when they talk to a suspect, his right to silence may very well be impaired. But I don't think that it's critical or that they should be debarred from doing that until they are proceeded against them.
Quite a difference in now meeting a man or asking if he wants to talk with him somewhere and going and taking him to the police station or taking him in charge and detaining him of his liberty. Quite a difference between voluntary.
There certainly is. And if the court were to hold that in every case the accusatory stage arises once the man is taken into custody, I would say hooray.
Well,
I'd be perfectly happy with it.
I don't like labels, and therefore I don't like accusatory stages. I like to consider what happens. But what you're talking about is, as I understand it when you say the accusatory stage, that the government, state or federal, has moved against the man, something like they said in the Magna Carta. It's moved against him. And from that moment on, they're entitled to due process of law, whatever it is.
That's right. He's the defendant. If that's the time it should be, that's certainly fine with me. And as a matter of fact, that really is my point. It's the premise we begin with. Many briefs begin with the premise that there's a need for police questioning. There certainly is that need, but the premise we begin with is that the Constitution recognizes when the man is proceeded against. At that time, the burden shifts to the police.
Chief Justice. Mr. Siegel. May it please the court. If the court will forgive a personal reference, I'd like to say a word or two about myself. I've been a prosecutor now for 26 years. 10 of those years very busily engaged in the trial of cases and
by quick computation, 16 years as the head of the Appeals Bureau in the Kings County District Attorney's Office. But I was a citizen before I became a prosecutor. And I trust that I am still a citizen despite this long record of public service. And it is for this reason that I think some of my colleagues, professionally and officially, have said things and seem to me to have made concessions with which I do not agree. And I think that there has been much too much talk of the police on the one side and the defendant on the other side, and not enough reference to the rights of the community. And if I may, this is the point of view that I want to espouse here this morning. May I say in passing that I have briefed the question of retroactivity. I'm neither a prophet nor a prophet's son, but like one of my ancient ancestors, I'm willing to prophesy that there is at least a possibility of some decision coming out of this argument, or these cases, with which I would perhaps be unhappy. In any event, which might raise the question of retroactivity. I do not argue it because this case has not become finalized within the definition in Linkletter, but I brief it because New York obviously has a great interest in the question of retroactivity. We have thousands of cases, I suppose, where convictions were based in whole or in part on confessions. My very able young...
In your own experience, any judgment as to what proportion of the cases, not that confessions are used in, or that not that confessions are important evidence in, but those cases where without the confession you wouldn't have a case?
We tried to do that when these cases were allowed up by the court. And I think it's obvious that we didn't have very much time in which to...
the short of it is that you have no... do you know of any reliable statistics on this?
We don't have, in my judgment, that type of empirical data that Mr. Justice Stewart spoke about, on which the court could put very much reliance. For myself, I base my argument on the importance of confessions on human nature and human experience and human evaluation. It's a principle of conduct that people don't want, of conduct, of human life, that people don't, as a rule, confess crimes which they haven't committed. And it is for this reason that courts have always said that a true, honest, unforced, and uncoerced confession is the highest type of evidence. And what our point here really is that we don't want to be deprived. We don't want to lose the opportunity to get that type of evidence, not for ourselves, not for any prosecutorial records, not for the satisfaction of winning a case, because I hope we are given the benefit of the presumption that we are above that, but for the benefit of the community. And so I would answer you, sir, that if I were fortunate enough to be in the seat of decision, I wouldn't lay too much stress on, presently at least, unavailable data of that type. Mr. Nedrew has tried to get some on behalf of all of the district attorneys, and in his brief, he has some statistics. Doesn't go very far. I don't think it really can, because after all, when we try a case, we don't write up and say we got this conviction because of a confession, and it wouldn't have happened if it hadn't been for a confession. Oh, yes, where the confession is the only evidence. Of course, sometimes it happens that the confession is later found to be faulty for one reason or another. It happens either in this court, as witness Lira and Noy, or it happens in the lower court. But there are cases where only the confession is available to the prosecution.
Did you say that there are cases in which confession is later found to be unmerited?
Yes, there have been. The records of this court contain two within my own experience, and there are others where this is so. But I hope that there won't be too much importance laid upon this fact, because the impropriety of the confession in these specific cases is only proof of what we all know, that no human institution is perfect, and that we can't expect or require from a prosecutorial system that perfection which is wanting in every other department of human affairs.
Mr. Siegel, I suppose it's at least arguable that prior to Magna Carta and prior to the adoption of our own Bill of Rights, most people who were convicted were guilty. Nevertheless, it has been the wisdom of the ages that some safeguards are necessary. Isn't that so?
Yes, I agree with that.
And I suppose that if one tries to look at this philosophically and morally in terms of the great human adventure towards some kind of truly civilized order, that these great provisions in the Magna Carta and our own Bill of Rights were designed to do two things. One, to eliminate even the unusual case of an unjustified conviction, and two, to lay out a standard for the relationship between the state vis-a-vis the individual. Would you, do you think that that observation is justified?
Oh, undoubtedly, sir.
That is to say that basic to this whole problem that we're considering, however one may come out in the terribly difficult, vexatious, tormenting decision as to where lines should be drawn, however one may come out on that, I think that perhaps one has to consider that what we're dealing with here is not just the criminal in society, but it's the problem of the relationship of the state and the individual in the large and total philosophical sense, viewed in light of the history of mankind, part of that history being Magna Carta and the Bill of Rights.
Well, Your Honor, if I may refer to your second desideratum first, there is no question that it is the hallmark of Western civilization. It is the command of this court. It is the command of the Constitution. It is the desire of all proper-thinking people that justice shall prevail according to civilized standards. My point is that the standard, well, let me second dispose of your first desideratum. What you pose, it seems to me, is an ideal that no man shall ever, under any circumstances, be convicted under an improperly procured confession. Now, this is an ideal, and an ideal by very terms of definition is unattainable. The only point I make is that because under a standard which I prefer to any set rules, which is what my brilliant young opponent is arguing for, the standard works well and enables courts to perform their true function. And the true function of a court is to find out where the truth lies.
Mr. Siegel, I suppose that even in a extreme communist state, that most people who are convicted of crime are really guilty. But I equally suppose that you would join me in finding it abhorrent if those people were convicted without having counsel and what we consider to be a fair trial. Isn't that right? So, the point that upon which I'm asking a comment is that perhaps it is an oversimplification to take a look at this problem solely from the point of view of facilitating the task of putting people in jail if they committed crime. Isn't that right? In other words, does this problem really affect the basic relationship of the individual and the state? And it's really goes beyond the administration of justice, and that's been the history of mankind. If one wanted to say that 90%, if police get a 90% justifiable result, well, that ought to satisfy anybody. You want to be pragmatic and practical about this and say, well, police secure the conviction of, and in 90% of the cases, it's all right. Now, it's a very sensible attitude in one point of view, but perhaps it's a point of view that's been rejected.
Well, Your Honor, I hope
our history.
I hope you won't believe that I disagree with your larger objectives, the larger social objectives that you pose, when I say that there is an immediate objective also. And the immediate objective is to protect society, because if society isn't protected, if in one degree or another it lapses into anarchy because of criminality, then the opportunity to reach this beautiful ideal is gone. And it is the function of the policeman.
I don't think you want to refer to something that is as fundamental as phrase beautiful ideal, but I completely agree with you, and that's the reason that we're sitting here. The problem is to reconcile a good many objectives and values that are not totally consonant, but I am a little troubled, I must say, when I sit here and hear so much reference to this problem as if it were merely a pragmatic problem of convicting people who did a crime, because there's many more dimensions, I suggest, to the problem than just that simple statement.
The conviction is only a means, let me say, to a larger end. And the larger end is the preservation of the peace and dignity of the Commonwealth for the good of everybody who resides in that Commonwealth.
And certain religious and moral values.
Well, this is inherent in our social structure. And I suppose the problem that these cases pose is, well, I have to start again. There's an old aphorism. It's a principle of law, as a matter of fact, that it is better that 100 guilty men go free than that one innocent man be convicted. And this aphorism expresses a point of view with which everybody is in agreement. But it isn't a mathematical equation. There isn't an exact 100-to-1 ratio. It's an expression of a philosophy. And the problem that's before this court, it seems to me, is just how to keep the balance between the ultimate necessities of a civilized, peaceful society and the constitutional rights of a specific defendant.
Don't you think that Bill of Rights had something to do with making that balance?
Yes.
There's not any doubt, is it, that they said that no person should be convicted on evidence he'd been compelled to give. Why do we have to get into discussion of society, uses of the ideal civilization, when that's the issue before us?
Because the Bill of Rights, The Bill of Rights only says that he shall not be compelled. But the word compelled is not self-defining. What compelled means comes from this bench. Now, we, for many, many years, were told by Your Honor's predecessors, and I would say by a great majority of Your Honor's predecessors, that compelled meant that you couldn't make a man talk by the exercise of process.
By the what?
The exercise of process. You couldn't subpoena him into a court and sub poena under pain of punishment make him talk. Now, nobody disagrees with that. And I take it that we are beginning to live.
But then here the main argument we have is whether without summoning him to come into court and talk for that process,
All right.
he can be seized and detained
Yes.
and interrogated
Yes.
while he is in detention.
Now, Escobedo says,
whether that's any compulsion.
Escobedo says, as I understand it, Escobedo says that when he asks for a lawyer, or a lawyer asks for him, to make him, it's a lapsus lingua, to take from him a statement after the rejection of these requests is compulsion. If I get Your Honor's point of view, it is that you don't have to wait till he's in the accusatorial stage.
I don't know what that is. I don't know what that is.
Well,
any more than the fact that a citizen
may I venture a
has been
definition?
seized by authorities and kept with them against his will.
May I venture a definition? The accusatorial stage is when the police have a prima facie case, and it has become their duty, a magistrate or a commissioner being available, to bring him to that functionary for arraignment. This is a true accusatorial stage. But I have a question. If he is entitled, and Escobedo says he's entitled not to be questioned at that point, why isn't he entitled to be not to be questioned at the very point when he's under police restraint so as to stop the probability or even the possibility that by questioning, the police will put him in the accusatorial stage? To me, there's a lack of logic in making this distinction between the investigatory process on the one hand and the accusatory stage on the other hand, because you don't reach, so far as the participation of the arrestee is concerned, you don't reach the accusatory stage until you first had the investigatory stage. And if it is wrong...
Do we have the investigatory stage in this country? I didn't know that we could arrest people for investigation.
Well, I am using the terminology of Escobedo, which makes the distinction. You can ask people to come in and talk. No question about that, and you don't have to invite them in with a lawyer.
But on the question of the accusatory stage, wouldn't you say that the accusatory stage had commenced when a man found himself locked up in jail?
No.
Why? Somebody has accused him, or they wouldn't have put him in jail.
No, somebody may suspect him, but they haven't accused him.
Have they a right?
Accusation is a technical term.
Have they the right to put him in jail because they suspect him?
It's an old common law right, as I understand it, to stop a person and detain him for a reasonable period of time for discussion and investigation. I don't think this has ever been disputed.
Has this court ever said you could put men in jail and hold them there during the investigation of the police unless the police arrest him for probable cause?
It's like many other things, Your Honor. It's relative. I think it's been recognized. There's a whole model code on the right to detain that's in preparation. New York has passed
Where is that model code?
Sir?
Is that in the Constitution?
No, sir. No, sir. But, Your Honor...
I had an idea that the model code, so far as protecting people's rights against government was concerned, basically speaking, had to be found in the Constitution.
I agree with you, Your Honor, but may I say this?
And that we long ago got over the idea that this country tried to adopt every old principle of the common law.
I agree with that, but may I also say that what we're talking about in every one of these cases is a question of definition and what the Constitution means. Now, I know that the Constitution has been differently defined in different eras, and I know also that we are in a period of the history of this court where the changes in definition are rather accelerated, let me put it that way. But case by case, the question always is does man live alone, or is he a member of this community? And doesn't the community have some rights under the Constitution? Now, it may be that what the community has...
Nobody could agree with you on that more than I do.
Now, then we always reach a question of the accommodation of these rights. The community must not, for its own benefit, take away any of the rights of the individual. But the individual's rights must not be defined beyond the point where they are necessary to protect him from oppression by the community. Would
it be wrong to substitute for that the idea that the individual rights should not be taken away from him any further than the Constitution properly defined requires, instead of balancing?
Mr. Justice Black, it is with the greatest respect to you that I say this is a matter of semantics. Because the Constitution does not define, the Bill of Rights does not define what a man's rights in any given circumstance are. We have to come here.
Not be compelled to be a witness against himself.
We've always had to come here to find out what compulsion meant. We didn't know, I've always found Mr. Justice Frankfurter to be not only a great stylist, but a great student of the Constitution. And it is for this reason.
So we agree on that?
Yes, I have no doubt. I have no doubt that despite your classic divergences of opinion in Adamson against California and others cases, you and Mr. Justice Frankfurter had the highest regard for each other. But it seems to me that the question in this case is not whether you should have, as a practical matter, an equivalent of the McNabb-Mallory rule for the states, and not just exactly when the right to counsel applies, although I think I've given you an illustration which might almost drive us all to the point where he needs counsel the minute he stopped and said, "Will you please come down to the station? We want to question you." The question is and ought to remain what it has always been and what Mr. Justice Frankfurter said about it in Columbia. The ultimate test remains that which has been the only clearly established test in Anglo-American courts for 200 years, the test of voluntariness. Is the confession the product of an essentially free and unconstrained choice by its maker? If it is, if he has will to confess, it may be used against him. If it is not, if his will has been overborne and his capacity for self-determination critically impaired, the use of his confession offends due process. Now, Mr. Justice Frankfurter wasn't talking about a mythical man. He wasn't talking about an average.
He wasn't talking about the Fifth Amendment.
No, I think he was, sir. With great
Did he
deference
say
to
so?
you.
Did he say so?
No, it wasn't involved there.
He said due process, did he?
Yes. But the question here is whether the due process clause, the Fifth Amendment and the Sixth Amendment are going to be brought in under the 14th Amendment, and even independently there still remains a question.
Mr. Siegel,
Yes, sir.
may I ask you this question in view of your long experience? There have been references many times, some made by members of this court, to the effect that if lawyers were brought in at the early stage, pre-trial stage, they would always advise the person in custody not to say anything. Now, there are instances, however, where lawyers who represent persons under arrest or in custody tell their clients that they ought to plead guilty. Is that, in your experience, does that occur quite frequently, or do most of the people who plead guilty, not represented by counsel?
In New York, we have this right. We've had this right to counsel long before it became a pressing question. Betts against Brady, or Powell against Alabama, or Gideon, or any of them.
So that the guilty pleas are entered after consultation with counsel.
Oh, yes.
And are guilty pleas rather frequent in your experience?
Oh, yes. We couldn't dispose of the volume of our business if we didn't have 85 and 90% pleas of guilty.
So that, let's say, 85 or 90% of the instances, there are defendants or persons under arrest, and their lawyers do tell them to plead guilty.
But of course, Mr. Justice Borders, this is after the lawyer has learned of the strength of the people's case, and I don't think this has any relationship whatever to the problem of the lawyer talking to the defendant at the time of arrest or accusatorial stage.
That's exactly
because in my experience, and I have dealt with hundreds of lawyers who specialize in the criminal practice, it is a rather obvious indeed who will ever, if he comes into the police station, say to his client, now you go and cooperate with the district attorney. Every one of them. And of course there are exceptions, but they only prove and test the rule. Every one of them will say to his client, and how he will say it will depend only on whether he's a purist or he uses slang or not. But actually, he'll say to him either button your lip, don't talk, or shut up, or anything like that. But he'll dry up this fountain of possible evidence.
Yes, but presently, and our experience up to this point, I suppose, is based on those people who do have lawyers at that stage.
Which stage, Your Honor?
At the investigatorial or accusatorial stage.
May I ask what Your Honor's experience has been?
Well, no,
I understood you say your experience.
No, I didn't say that.
I'm sorry.
I said that our experience, the experience of our legal process, has been with limited groups of persons, or limited numbers of persons who have counsel at that early stage. Isn't that right? That is to say that most people don't have counsel at that stage.
That's right. That's relatively rare. Very rare.
So that, I suppose there's not a coincidence between the number of people who plead guilty and the number of people who have counsel at the investigatorial or accusatorial stage.
No, Your Honor, they may plead guilty because their conscience bothers. They may plead guilty because they've decided that for one reason or another, including perhaps a moral reason, they're better off. They may plead guilty because a district attorney offers them a quid pro quo. There are many reasons why a man pleads guilty. But certainly, it is not a fact that they have been put in the position of pleading guilty only because when they were brought in the police station, they had no counsel. You must give...
I understand that. I wasn't making that point.
You must give...
I wasn't making that point at all. What I was doing really was trying to ask for the benefit of your experience with respect to this statement that most of that so many people are now accepting without any thought, and that is to say that lawyers would practically always advise their client not to say anything.
I believe
Now, it may be that has to be broken down into two parts. One is what the lawyer's advice to the client is before the lawyer's looked into the case. The other is what is the lawyer's advice to the client after the lawyer's looked into the case. And to my mind, there is a question as to whether if a lawyer, as he frequently does now, on the basis of what you said, tells a client pleads guilty, must we assume? Therefore, how do we reconcile that fact with the statement that the lawyer would always tell the client to button his lip, as you put it?
I don't think there's any contradiction at all, because the lawyer advises his client to plead guilty after he's talked to the district attorney. And a fair district attorney will say to him, now look, this is what I have. I have this witness who testified to so-and-so. I have a statement from your client. You want to see it? I've let people see statements. And as a matter of fact, we now have in New York a statutory provision, Section 813F of our code, that if the district attorney intends to offer a confession in evidence on the trial, he must give reasonable notice to the defendant before the trial, and the defendant has the right to a pre-trial hearing as to the issue of voluntary.
But would it cripple law, would it handicap law, materially handicap law enforcement if the person who was under arrest started talking to the police only after his counsel had talked to the state's attorney?
Based on...
I'm asking for your observation.
Based on my experience,
yes.
While, of course, there will always be exceptions, it is my honest belief that a warning to a prospective defendant in the police station or bringing a lawyer in, the manifold difficulties, practical difficulties of those of that are obvious, that this will dry up practically the whole stream of confession. And now, it's been put this way: if you want to equalize the defendant and the police, maybe you ought to do it. But if you want to preserve the rights of an individual, I think this court should be careful as to how it defines his rights so as not to prejudice the total rights of the total community.
Mr. Fawcett?
Mr. Chief Justice.
Yeah.
May it please the court. Before I begin my argument, I should like to call the court's attention to a disparity in the record of this case, as disclosed by the respective briefs. Inasmuch as I had no opportunity to discover this disparity until I received the Solicitor General's brief this weekend after I arrived in Washington, this is the first opportunity I have had to do so. And I do so lest the court think that simply because I took this case under court appointment, I have somehow been negligent either in carrying out my obligation to my appointed client or in presenting to this court, to the best of my abilities, the true and full facts as I knew them. The discrepancy occurs in that while my knowledge of the case here and below has been predicated upon the official record, certified first to the Court of Appeals and then here, the Solicitor General's brief makes liberal use of additional materials not a part of the official record on appeal, never made available to me until this past Saturday from the kindness of your clerk. This is the material which the Solicitor General's brief refers to as, quote, supplementary papers in note 1, page 1 of his brief, consisting of certain pretrial administrative papers and the exhibits in the trial court, both those exhibits which were, and in one particular significant particular one which was not, received into evidence. All of these materials, as I learned on Saturday, were forwarded to this court in late January of this year. I was much surprised by some of the information in them, as I am by their sudden appearance at this time. I am green and unknowledgeable as to the ways of the court, and I don't know whether the court should be considering them. I do know, however, that in view of their 11th hour, 59th minute appearance, I am inevitably caught somewhat by surprise. I will try to the best of my ability to integrate the new material into my argument here. Necessarily, it has not been integrated into my brief. I would simply ask that the court keep that in mind. Excuse me. Because of the shortness of time allotted for argument, as well as presumably the court's most particular interest, I will limit my oral argument to the confession issues involved in this case. In this case, there are two. One, whether for lack of counsel's actual presence during a police custody interrogation, petitioner's two confessions were properly admitted into evidence under Escobedo versus Illinois. Two, because this is a federal case, whether without regard for Escobedo, petitioner's confessions were improperly admitted as a matter of federal criminal law under the standards of McNabb versus United States and, more specifically, Anderson versus United States. The factual circumstances surrounding the confessions may be briefly stated. On the evening of March 20, 1963, at approximately 9:45, petitioner Carl Calvin Westover was arrested as he entered his parked car on a side street in Kansas City, Missouri. The arrest was made by two officers of the Kansas City Police. The chief purpose for the arrest was the suspicion that petitioner was involved in two local Kansas City store holdups. Both petitioner and his car were searched. A certain packet of money was recovered, and his car was impounded. He was taken to the Kansas City police station, was at that point placed in a lineup, identified as to one of the local charges. Thereafter, the police booked him, quote, for investigation. At that point, he had denied all criminal activity. The following morning, however, the Kansas City Police, apparently, according to hearsay testimony at his trial, did obtain a confession on one of the local robberies shortly before noon. At approximately 11:45 in the morning, the Kansas City Police declared themselves through with the petitioner, and the FBI office in Kansas City was at that point permitted to interrogate him. In something less than 3 hours, they returned from the interrogation room with two narrative form statements or confessions to the two federal robberies here concerned. The confession, although in the handwriting of one of the interrogators, was signed by the petitioner. Each of the confessions recited that Westover had been advised that he need not make a statement, that any statement he made might be used against him, and that he had the right to consult an attorney, quote unquote. Each also recited that, quote, no threats or promises, unquote, had been made to induce his statement. Each also recited that the statements were, quote, voluntary. By the time these confessions were secured, Westover had been in custody for approximately 17 hours. He had not been taken for arraignment or loosely arraignment, more properly preliminary hearing, before either a Kansas City magistrate or a U.S. commissioner. The following day, petitioner made certain changes in his statements, still in custody. The federal involvement in Westover's detention had included, besides the confessions themselves, the following. One, a specific telephone request prior to the booking, quote, for investigative check from the FBI that, quote, the subject be held for them also for questioning. At this point, it would seem appropriate for me to clear up the principal discrepancy between my prior understanding of the case and with what the Solicitor General's supplementary papers now do disclose. It was my understanding that the felony warrant from Sacramento, California, to which the arresting officer referred and to which his arrest report referred, was a warrant on these two federal robberies. The government, however, states, and one of their supplemental papers indeed seems to show, that the felony warrant, Sacramento, California, was a state, not a federal warrant. My brief is, of course, in error, therefore, in arguing that the clear federal interest was shown at the time of arrest. However, those same papers, which the Solicitor General has found, do clearly show that at least by the time of the booking, if not the arrest, the FBI was itself very interested in the petitioner for its own purposes. They show that the booking was, in fact, at least as much for the FBI as for the local matters or the California felony warrant. As the arrest report, which is prosecution's Exhibit 12 for identification, shows, Westover was not booked on any specific charge. As in Haynes versus Washington, it was a, quote, small book, hold for investigation. It then reads, well, specifically it said investigation check dash robbery. It then goes on to list the two matters which were to be checked, then recites as follows. Prior to booking the subject, information was received from FBI agent Leon Dobb that Westover was wanted by the FBI for questioning, and also that Sacramento, California holds a felony warrant for the subject, which will be forwarded to this department. In concluding, it recites, Carl Calvin Westover was booked for investigation to be held for the number 1 and number 2 station detective units, this department, and for the FBI. Curiously, it appears to me in reading the Solicitor General's brief that there's quite a conscious attempt to convey that the only outside interest, the only FBI interest at the time of the arrest or booking was the felony warrant, California. This may not be conscious. I think it certainly reads that way. The facts, however, show quite the contrary, that there was an independent federal request for detention for its own questioning. These supplemental papers also show that, at least at the time of the booking, the federal authorities, one, had a pretty fair idea that the petitioner was connected with the two Sacramento federal robberies, enough to want to question him, and two, that they had, by their request, actively contributed, if not to the arrest, to the booking and to Westover's subsequent detention for investigation. The other matters of federal involvement are well enough documented in my brief to warrant the passing reference here. The joint federal-state examination of the recovered currency, the joint federal-state seizure of the top coat, the use of the state-seized gun in procuring the federal confessions, and finally, the transmittal of the state photographs or mugshots to Sacramento, California for use in the case. On the basis of these facts, we submit that under both Escobedo and/or Anderson versus United States, the confessions were illegally admitted. Notwithstanding these two different questions in this case, I cannot urge too strongly that both questions, uncounseled interrogation and protracted detention, are in my mind both fundamentally vital to determination of the first issue, the Escobedo question. Thus, it would seem to me a big mistake for this court to follow the lead offered by the Solicitor General and by the two governmental amicus briefs filed here, which would seek to segregate these two items into two separate cellophane packages. One, police interrogation, and as a second element, quite apart, the period of lengthy detention. As 4 of the 5 cases right now before this court indicate, protracted detention for interrogation appears a routine police behavior. It is precisely because of this detention that, as it seems to me, the need for a safeguard such as presence of counsel has had to be evolved by this court. As in Escobedo, it was to protect the incarcerated suspect from unwittingly or unadvisedly relinquishing his constitutional privilege against self-incrimination. The evil sought to be corrected by an Escobedo-type philosophy is not the street corner confession, not the soul-bearing spontaneous confession of guilt, not the, quote, picture streaked with confusion and alarm, as the government suggests on page 23 of its brief, nor indeed does it have to be, and this perhaps does not here have to be decided, it does not seem to be, the brief question and answer period during what the government calls the completion of administrative formalities. What Escobedo does do, it seems to me, is to strike at precisely the very same evil which for federal law, the McNabb-Anderson exclusionary rule sought to strike at over 20 years ago, the secret detention for purposes of eliciting a confession. The second difficulty I find with the Solicitor General's approach is more serious, more crippling. The Department of Justice would have this court turn back the clock as though Escobedo and its precursors such as Spano, White, and Messiah did not exist. Thus the government states, as Mr. Earle has earlier alluded to, Escobedo was in fact nothing more than one more case of a coerced confession, determined under strictly traditional totality of the circumstances views. In this light, the government expresses some amazement that the present case is before your court. Says the government, repeatedly and at great length, there is, quote, no showing on this record that petitioner's confessions were the product of, quote, coercion or, quote, overbearing on the part of the interrogators, viewed as a matter of the, quote, totality of the circumstances. Of course, we never argued that there was. What we did argue in our brief, do argue now, is that the protracted detention combined with the police interrogation is itself inherently and unavoidably coercive. In that sense, then, Mr. Justice Black, as opposed to the two petitioners who have already appeared before you, we do, yes, claim the confession was coerced. We believe that Escobedo went farther than coerced confessions. We believe also it was not simply a question of the wrong to be righted, but a step in providing a remedy for that wrong. The fundamental philosophy of Escobedo seems to be the right against self-incrimination. The fundamental force of Escobedo seems to be the understanding, the realization that the right to counsel is necessary to remedy that situation. Under traditional views, we concede this particular case would presumably not have merited nor received review by this court. We submit, however, that under Escobedo, the court is trying to establish something less ephemeral, less open to case-by-case doubt than the special circumstances type rule of Betts versus Brady. Finally, on this point, I would suggest that the Solicitor General's entire approach to the problem in terms of police necessity versus individual rights is topsy-turvy backwards. As already discussed, some of his alleged police needs, quote unquote, are entirely wide of the mark. They themselves straw men or possibly red herrings. Escobedo would not in any case interfere. Others are particularly irrelevant to the terms of this particular and not atypical case. Thus, his reference to one, the unwitnessed crime, or the police officer forced to act, quote, in the exigencies of the moment without opportunity for detached reflection. Quite obviously, these are most thoroughly inapplicable here. I submit they are hobgoblins conjured up in order to frighten this court back from what it has already held. It is already held. It is not simply interested in coerced confessions under traditional views. In any event, however, the approach is backwards. The court has affirmed in loud tones that in weighing police need and individual right, the balance has been struck in favor of the latter. Thus, if the Solicitor General's approach of a case-by-case evaluation of the totality of the circumstances is correct and should be adopted, with exceptions thereafter to be carved out, we submit the rule, the starting place, should be the individual's constitutional rights versus self-incrimination as protected by the right to counsel. With the police interference with those rights, the exceptions, being the matters which should be allowed in exceptional cases where, on a totality of the circumstances, a need in fact is shown to exist. Certainly there was no such need here. As the prosecuting attorney himself stated, the confessions were simply the frosting on the cake. As the Solicitor General's brief admits, the other evidence was overwhelming. There simply was no police need at all. And I submit that Mr. Siegel's credentials notwithstanding, we would find that in many cases, when confessions were used, there would be no need at all. On the point of Anderson versus United States, I think I would have to. It's a difficult point, and I think it certainly should be briefed and argued before it was decided by the court. It's not presented here.
The confession is necessary to the case. It may not be because the confession produced other evidence.
That's right. I understand that. Yes, it may. It may. There are no figures on any of it. There are no figures as to how much need there is for a confession to secure its fruits when perhaps independent police work would have found the same evidence about as quickly. Sir? Yes. Yes, it's just as right. On the Anderson point, I would just like to make a very brief comment. Even conceding that, as I now discover, the federal authorities had no part in the original arrest, they clearly had a large and a thoroughly well-documented part in the subsequent detention for investigation. We submit the many pertinent facts and factors surrounding petitioner's arrest, detention, overwhelmingly bring the case within Anderson. They also put the case squarely outside United States versus Coppola, 365 U.S. 762. There it was found the federal authorities had, quote, in no way caused or contributed to Coppola's detention, unquote. Exhibit 12 for identification precludes such a finding here. It was also found in Coppola that the interrogation by the FBI, quote, did not contribute to any delay in arraignment, unquote, since he was initially interrogated by the federal authorities in the midnight hours. Here, when the interrogation began at 11:45 in the morning, certainly no such finding can be made. I submit that if the court sanctions what occurred in this case simply because the detention was nominally that of the state, although not for any specific state charge, it will effectively have taken all teeth from the McNabb exclusionary rule. It will encourage states to adopt broader and broader small book statutes. It will openly invite federal authorities to find themselves sanctuary, forbidden to them directly, in requesting to state authorities that the subject be held for them also, for questioning. In our case, as a matter of federal law, if not as a matter of constitutional law, the confession should have been excluded, the conviction should be overturned.
Mr. Solicitor General?
May it please the court, I will have to check on when the page proofs were mailed to Mr. Fawcett, and I will be able to report that after lunch. I will have that checked. I think in the first place, we have to get a few things cleared up on the factual basis of this case. There is not one word in this record at any place that there was any cooperation at all between the state and the FBI, other than one, that they did notify him they wanted to talk to Westover, and on 11:45 the following morning, they told him they'd like to talk to him, and they didn't until 12. This 17 hours is also very interesting. He was arrested at 9:45, carried to the Kansas City Police Headquarters after questioning on the street and searched. And at some time thereafter, he was put in a lineup and identified. And at 11:45, he was booked. And petitioner himself says booked into the jail. We are unable to find in the record whether he was booked at the police headquarters or the jail. It's kind of confused. But I have checked, and while it does not appear in the record, the jail is directly across the street from the police headquarters. But this interrogation for 17 hours is not in the record. The record shows he was questioned for a portion of the time between 9:45 and 11:45 at night. He was questioned sometime the next morning, but the only pinpoint on that is that 11:45 he was seen talking to a police sergeant in the open area of the police headquarters.
It's 11:45 the next day, the next morning?
11:45 the next day, he was seen talking to a detective, sergeant, I think a Klein or something like that. It appears it was in the open area. The other thing is that what is in the record is that at no time was any federal officer present while the state was questioning. That's positive testimony. There's also positive testimony that there were no state officers present when they questioned him. And when you bear in mind that between 12 and either 2 or 2:30, they had gotten 2 full statements from him. And the time it took to question him and to write it out in longhand, it would appear to me that he must have started talking very soon after 12 o'clock. That just stands to
noon
reason.
of the day of the arrest?
No, sir.
When you say 12 o'clock, what do you mean?
12 o'clock the next day. He was arrested the night before. The FBI asked for him at 11:45. At 12, they gave them a private room, and the federal questioning started at 12 noon on the day after his night arrest at 9:45. There is also evidence, and this evidence is from the defense counsel in calling FBI agents as his witnesses, despite the judge saying it looks as though you got somebody with a uniform with the other team on, but he still called them. And they testified positively that this man was in perfect condition. He seemed to have complete control of his faculties. And number one, there's nothing in this record that he ever asked to call anybody at any time under any circumstances. The record also shows that he was obviously from California with California license plates, living in a hotel in Kansas City, and so far as the record shows, he didn't have any friends, relatives, or anybody else. He did not take the stand himself. He sought to build his case on government witnesses, particularly FBI agents, and he didn't make the grade. It's also apparent that he made a choice, and that is in the record, where the court said in sentencing him, I think it was on 70. Well, anyhow, I get the page. In sentencing, the court says, you know and realize that had you been tried under the laws of the state of California for this same robbery, you could have gotten life. And he said, yes, sir. And I think that he made a choice. He constantly denied the crime to the states. And when the FBI talked to him, he made his two statements.
We'll recess now. Mr. Solicitor General, you may continue your argument.
Mr. Chief Justice, and may it please the court, I checked during the lunch and recess, page proofs were mailed by air mail on Wednesday. And if they didn't reach, it's not the fault of the Department of Justice, it would be the fault of the Post Office Department. I'm sorry if you didn't get them. What I concluded before lunch, I was at the point where I wanted to make it clear that while there's nothing in the record to show what happened the night before, there's also nothing in the record to show that Westover was at any time warned by the state. There's nothing in the record one way or the other. The statutes and the rules of Missouri do apply that a man must be brought to the stage of arraignment within 20 hours after arrest. That brings me to the point that I think is the crux of this case, is that the Mallory rule and the Anderson case and a couple of cases so relied upon by petitioner just do not bear any factual basis in this record. I don't believe there is, this stage, of anything wrong with the state and the federal government in the prosecutorial stage having a statement where one asks the other, if you find so-and-so, I want to talk to him. There's no question that when he was picked up the night before, it was, as the petitioner admits, primarily for the two robberies in Kansas City, specifically a finance company and a bakery. Much is made of the fact that the money that was seized on Westover, $600 and some, was seized by the state police and was examined jointly by the state police and the FBI. It is true that the state and the FBI jointly took down the serial numbers. One read it off and the other marked it down for the use of both to see which place the serial money would fit into. And the record shows, at least as to the federal charges, in the banks that were robbed, they had these packs of money with marked bills in, which they stick into the tellers' cages for this express purpose in case they are robbed. But that's nothing illegal about the cooperation in that stage. Secondly, as I mentioned, there were no federal officers present during state interrogation. That is in the record, positively. Secondly, that the state police denied that they made any inducement to Westover. That if you talk to the federal or anything, they never mentioned it to him. Then it's repeatedly said by each of the witnesses that there was no deal of any kind between the police and the FBI. And this evidence is brought out by the defendant. It's clear that at the time the FBI examined Westover, he was a state prisoner and not a federal prisoner. On page 79 of the record, there is testimony that Westover, when the FBI began to question him, he was mentally alert and appeared to know exactly what he was doing. No evidence that he had been held up late at night or kept awake or anything. There was no federal warrant outstanding at the time of his arrest. At the time of his questioning by the FBI. And the FBI agent says positively, at the time they questioned him, they had none of the details concerning the Sacramento robbery. Not only was he advised of his rights by witness of the evidence of the two statements he made, but the FBI agents testified from the witness stand that he was fully advised of his rights. And the statement is that I advised him that he didn't have to make a statement, that any statement he made could be used against him in a court of law, and that he had the right to see an attorney before he made the statements. And the final point is everything I have said is uncontradicted.
In which state was that statement made, General?
During the questioning between 12 and 2 or 2:30. There were three agents there.
During the questioning by the FBI?
Yes, and the statement says that he was told in front before he made the statement. But the test, sir?
Before he made any statement at all.
That's what the statement says, but this says, where it doesn't say exactly when, it says, were the statements he made free, was he advised of his rights? And after he was told that he went ahead and made the statement, so it appears from page 82 that it was before the statements were made.
He didn't ask for counsel.
He never, there's nothing in the record to show that he ever asked for counsel.
Is this the, what's been referred to as the standard FBI warning?
Yes, sir, this is practically it, and it's always given, and at least so far as the Department of Justice is concerned, has witnessed this unaltered practice of the FBI. We think that this is the practical way to do it.
Mr. Solicitor General, what if, upon giving such a warning, the person being interrogated says, I want to call counsel?
This statement says that if he wants to see an attorney, he can do it before he talks. That's what this warning says.
And if he says, I don't know anyone, don't know a lawyer, and I can't afford one anyway, what happens then? But I still want to talk to one.
If he says, I still want to talk one, then it would be my position that the most the agent would have to say is, we do not have a lawyer, we have no means of furnishing you a lawyer.
Well, but can the agent go, will the agent then go on and interrogate?
I think the agent would then say, in view of the fact that we can't give you a lawyer, we can't pay for a lawyer for you, do you want to talk? And he is then, I think, in a position of saying, if I don't get a lawyer, I don't talk, and that's the end.
In other words, you'd say, you'd read a waiver into it.
I don't think it's necessary, Mr. Justice Clark. I don't want to be accused of dealing in semantics. But at this stage, I'm not too sure he has a right which he needs to waive.
Well, if the FBI said, we can't give you a lawyer, we can't furnish you a lawyer, and we don't know anybody to call. Well, and then, they asked him to go ahead and make a statement, or in part time, that under those circumstances, if you wish to go ahead, you may. Well, that would be, would you say that'd be a waiver?
It would be the waiver of his right to remain silent. It would be a waiver of his right to remain silent, I would think so.
Well, they just said, well, under those circumstances, we won't take any statement.
We will not take a statement?
We won't interrogate you.
Well, I think it's up to the agent at that stage. That's a possibility, but I think the more likely possibility would be the agent will say, since I can't give you a lawyer and I don't think you have a right for us to furnish you a lawyer, I ask you again after repeating this, do you want to talk? And then he has the choice to make.
Well, what if he says no, just says, no, I don't want to talk without a lawyer?
That's
then
it.
Is the interrogation over?
That's what I would think.
Well, is it, or, I mean, you know what the practice is? Do they say, oh, come on now, and go on asking him questions and presenting?
Well, I would say that once the man makes it clear that he does not want to talk, or he will only talk on certain terms, and those terms are not met, I think that the authority at that stage should stop questioning.
Well, do they? No.
I don't know, sir. I imagine it would vary, but with the FBI, I would be reasonably certain they'd stop.
You don't know whether they get a lawyer for him later. Suppose he's an indigent or he's busted.
Well, if he's an indigent, I just don't know of any facilities in existence to get a lawyer. I don't think the
Prior to arraignment or something.
Prior to arraignment, I'm sure that speaking for the federal government, there's no provision I know of to hire a lawyer.
Of course, if the counsel point doesn't need to get into it at all, if the fellow knows enough to say, well, I just don't want to talk without a lawyer here, he knows enough to say, I just don't want to talk.
That's if he understands it, Mr. Justice White. If he understands this, which I submit an average person can understand, then I say the only purpose of a lawyer at this stage would be to advise him of what this statement means. Well, if he knows, he doesn't need it.
Well, but what if they ask him the question? They say, they give him the warning, and he says, I don't know a lawyer, I can't afford one, and the agent says, well, we have no lawyers to furnish you. Do you want to talk or not? And he says, well, and the agent says, well, you don't have to, but if you want to, we want to hear what you got to say. And he then doesn't say, no, I don't want to talk. He says, well, what do you want to know?
Well, then I think he's talking voluntarily. And he's not being, in any stretch of the imagination, either being forced or tricked.
Yes, but he's talking without a lawyer.
Well, I don't think that well.
Well, how does he know enough to make that decision whether to talk or not?
I think it depends on the individual.
If you remember, whether a lawyer is present there or not is relevant to what?
I think the lawyer being present is relative to this point. And if I may go right straight to the Escobedo case on that, where the man wants to see his wife, Haynes against Washington, or wants to see his lawyer, Escobedo, and the investigating authorities say, the only way you will see that person is for me to allow you to see him. I've got the key in my hand to open the door, and I'm not going to open it unless you talk.
That's different. That's a different case than if they just say, well, we don't have a lawyer, and
that's right.
You don't need to talk, but do you or don't you want to talk without your lawyer? And he says, well, what do you want to know?
If the man, number one, if the man says the one way he has a lawyer, I want to call my lawyer, et cetera, then I say the normal procedure would be you'd have to wait until he calls his lawyer and his lawyer talks to him. When he says, I don't have a lawyer, I'm broke, but I would appreciate if you'd get me a lawyer, you said, well, we don't have a lawyer. We have no means of getting a lawyer for you.
Which is true.
Which is true. And so far as I know of no place, unless it's some legal aid society that voluntarily puts lawyers in there. And that's not true in any place I know of.
As soon as he says, I want a lawyer, why hadn't he automatically said, I don't want to talk without one, and therefore the interrogation should cease?
I think we would have to just about say that.
Yeah.
There's nothing wrong with him saying no.
Yeah.
In this case, there's nothing that he's ever, so far as we know, as soon as the door shut, he started talking.
Do you think that the situation that Justice White's asked you about invokes any principles in the Griffin in Illinois and those that succeeded it? As I understand it, you say that, of course, a person who had a lawyer, had money, or who had money to get a lawyer, and could call him, could get one immediately. But this man has no lawyer and has no money to get one. And the only reason he doesn't have a lawyer there is for that reason. Does that raise any principle of what an indigent is entitled to? He's certainly not getting treated like the man ordinarily who has money to get a lawyer.
But he's not being denied anything. He's not being denied anything. The state is not affirmatively denying him anything. The state just is not furnishing him something.
That was the trouble in some of these other cases.
Yes,
In
but
fact, the state didn't have any provision to supply him a lawyer, but we said that if other people have lawyers and have entitled to have them, entitled to have lawyers represent them at that point. The man's too poor to get one.
Well, I think all of those cases, Mr. Justice Black, is where you have a right, and I don't think you have a right to a
But I
counsel.
understood you to say if he had had money, he would have a right to have his lawyer there at that moment.
He would have a right to consult his lawyer.
All right. He would have a right to, but the man who's too poor to get one has no right to do it. He has no chance to do it.
I think
That's the situation we had in Griffin and the cases that succeeded, isn't it?
Yes, but Griffin was a different point.
I know it was a different point, but it was
Because
based on the fact that in the trial procedure,
we can't equalize the whole thing.
That's right.
I just don't believe we can.
What power, in your judgment, from what provision of the Constitution does the government's power to detain him and question him, to detain him and question him, what provision of the Constitution grants that power?
I've been unable to find one that grants it as such. It's inherent in the investigatory process preceding the prosecutorial process. And I don't think it's ever been questioned.
Well, it is with me.
I know it is, sir.
How long do you
do my level best?
How long do you say they can hold him?
I think that the question of holding him, I'm not unaware of the other questions were asked. I think he can be held for a time to at least check out what he was arrested for. And that time would be a very short time. I am thoroughly in complete agreement with arraigning the man or giving him the judicial process as soon as is possible.
But it's one thing to hold him, perhaps for the purpose of checking out what they know about him. It's another thing.
Yes, sir.
It's another thing to interrogate him during all that time they're holding him to check out, isn't it?
Well, providing the interrogation is on the checking out point. Because, for example, a man has an alibi and the alibi is out of town or something like that. If the alibi was right there, you could check it out in 15 minutes. If he's out of town, it would take 2 hours or so. I mean, I don't think there's any short line we can put down. My point is that when the questions are made and the answers are made, I think the mistake is in reading the mind of the questioner. I think you should read the mind of the person who is making the statement. And if he is making the statement on the theory that he is obliged to make it, and not even as far as has to make it, then I think that's overreaching.
My trouble with that is this. I have no doubt that what government has a right to make inquiries about crime. No doubt about it.
Yes.
The question is, do they have a right to detain people as though they are under arrest for the purpose of questioning and questioning when they're there alone and detained or imprisoned during that period of time?
Well, that I think that comes to the point that we have to decide on what kind of a crime we're investigating, what are the problems, and I'm not balancing, Mr. Justice Black. But there's, sir?
That's not forbidden, but it's a lot of my business.
Oh, I don't think I will tread. But if I may, just to give you two cases we mentioned in our brief, the question of the well-trained criminal lawyer, if by any chance any one of them might commit a crime, and he's investigated, he wouldn't need a lawyer. But that could be considered as going to the end. But there's a case pending here right now on certiorari from the Second Circuit, U.S. against Cone, where a man is caught with a huge case of marijuana on the chair beside where he's sitting, and a few marijuana cigarettes in his pocket. And the agents take him outside, the narcotics agents, in broad daylight in the middle of Manhattan, and in walking the one block down from the studio where they picked him up to the car. They don't warn him, they question him, and he tells the whole story. It was all a part of the arrest. I don't see any overreaching there to hold such a confession out. Then you have the confession where the man's been there, and I think the important point of the Chief Justice's story, when you're holding him for this questioning, you certainly can't hold him incommunicado. That is absolutely forbidden. If he wants to talk to his family, he shall be permitted to do it. If he wants to talk to his lawyer, he should be permitted to do it. But the only advice a lawyer can give him is what this statement means. The lawyer can't prevent him from being fingerprinted. The lawyer can't prevent him from being mugged. The lawyer can't prevent him from being put in a lineup. The only thing the lawyer can do would be to tell him,
not yet,
this means.
Mr. General.
Well, Mr. Justice White, I would hope not as long as this court sits, end of quote. I would hope. But I think the real point is that the major difference we have is the denial of the right to see your own lawyer. And I respectfully cannot get too close to this ability to hire a lawyer. You couldn't staff every precinct with a legal staff of lawyers. It can't be done. And once the rule is made that a man is entitled to a lawyer once he reaches the precinct, you must, by force of power in Alabama, insist that it be an effective counsel.
Mr. Solicitor General, apart from the decisions of this court looking to the Constitution and the matter of theory, what is the basis for your statement that if a man has counsel and wants to consult counsel, he should be allowed to do so? What's the constitutional basis?
I don't think that, I don't say that he has a constitutional right to see his counsel. I said to deny him the right to see his counsel or his wife makes the statements that he makes conditional upon him seeing them.
Well, perhaps I am not following you, but you do. Are you saying that there is or is not a constitutional inhibition? Let me put it this way. Are you saying that there is or is not a constitutional inhibition against using a confession which is given after denial of an arrested person's request to see his lawyer?
I would say yes, sir, with one exception. If it can be construed that the person confessing gets the feeling that unless I talk, I won't see my lawyer. Well, I think that's inherent.
Well, let me pass that.
All right.
What is the basis of that? What is the basis of that constitutional right?
It's the Fifth Amendment, which, as in those circumstances, puts upon the man making the statement an unreasonable restraint in urging him to talk in order to gain something.
You think it defeats his constitutional privilege?
It remains out.
His constitutional right to remain
Yes,
silent?
sir. Yes.
Now, how do you distinguish that from a situation in which a man says, I want to see a lawyer. I haven't got one, but I want a lawyer. Then that's denied to him, let's say, and let's say the interrogators say, sorry, if you haven't got a lawyer, we're not going to produce one for you. And then the arrested person confesses, and the confession is offered at his trial in evidence. Now, in that case, does the Constitution prohibit the receipt and evidence of the confession or not?
No, sir, because...
Now, why not? There's a difference in constitutional terms.
The difference, as I see it, Mr. Justice Fortas, is that in the second case, there is no possible urging that the man can get that if I make this statement, you'll then let me talk to a lawyer.
Oh, but why not? Because in one case, the only difference between the two cases
is that there's a lawyer there.
In the first case, the fellow says, I know a lawyer. And then the second case, he says, I don't know a lawyer, but I want to talk to him. But I want to talk to a lawyer.
I go back to I see not too much difference with my position on Escabeta and Haynes. The reason, Haynes had a wife.
I understand that.
But if he hadn't had a wife...
I haven't yet heard anybody urge that the state's got to go out and find him a wife.
Well, I didn't want to go that far. But I think it is that there is something available to you. And if you don't incriminate yourself, you won't get that something that you would normally do.
But General, in the case where a man has a lawyer...
Yes, sir.
He's a gangster, let's say, somebody in organized crime. They're the fellas that generally, as I understand it, have lawyers, not the little fellas.
Before the crime sometimes.
Now, in the case of an organized crime fellow.
Yes, sir.
He's got a lawyer. Your position is that if he's not allowed to consult with that lawyer before he makes his incriminating statement, that then the incriminating statement should not be received in evidence because in that case you say there's psychological pressure on him and the statement is not voluntary and he's being compelled to, in effect, to make statements against himself.
No, sir.
The only difference between that case and the case where that I put to you is that in the second case he's doesn't have a lawyer whom he's retained.
Well, I don't say automatically that confession is out of the second one, because if he's had enough, if the record shows that he's had this lawyer represent him in the last 6 court appearances, I think if I was a judge, I could say he knew his rights.
Well, General, may I ask you what you would do with this case? And it happened in the district here just a few years ago when 3 or 4 years ago when they were arguing the Mallory decision over the Capitol. There was a robbery one night in a restaurant, and the robber not only took the money away from the woman cashier, but he beat her up in a brutal fashion. And she gave a description to the police. And the police went out into a certain area of the city and gathered up 90, not 9, but 90 people who might answer that description. Got them out of bed, threw them into jail at night, and didn't process them by morning. A lot of them couldn't go to work because they were in jail for suspicion of robbery. Now, would you say that those who had lawyers there could get out and not be interrogated, and those of the 90 that were too poor would be entitled, they could be interrogated by the police until they got a confession if they happened to have done it. It happened that not one of these 90 was a guilty party. They found him later, but that was the way they did it. 90 people they threw in jail.
Well, I've always been opposed to dragnet arrests of any kind, but if I may say so, to really put that in proper focus, anybody that had a lawyer would have gotten a writ and got his man out.
Well,
But you wouldn't have to get a lawyer to get a writ to get the other ones out. That's the way the law is now situated.
Well, I don't quite understand you. They were they were arrested in the middle of the night, and if they could get on the phone, as you say, and get their lawyer, and the lawyer said, "Well, don't talk to him. I don't want you to talk to him," and they would follow that advice, and the police could do nothing with them. But the rest of them, who had no lawyer and perhaps were poor and couldn't, at least at that time, get a lawyer, you think that the police would have the right to retain them and question them ad lib?
As the law now stands, I would say that the only redress they have would be that they were the subject of this dragnet arrest and their rights had been denied by the dragnet arrest, and that anything came as a result of it would go out. Now, that's what I think the court should do in such a case.
Well, then all of them, whether they had a lawyer or not, in those circumstances would go out.
Would go out when they, I mean, you wouldn't be able to use those statements in court, in my position. I don't think so, because the arrest itself was invalid, and any incarceration then was bad. But on the cases we're working on the theory that the arrest was a valid arrest.
You don't suggest that we overrule Escobedo, do you?
No, sir. I think that Escobedo can very well fit into this case under the Fifth Amendment point. But I don't want to in any way give support to any theory that we believe that Escobedo requires that a lawyer be appointed to an indigent in the police precinct or at the arrest. Yes. Supposedly, if you use accusatory stage as the point, and a policeman's coming down the street and crash goes in a window, and he rushes up to where the crash is, and there's a rock inside of the window, and the man with his hand on some jewelry. Well, he's in a rather accusatory position. Well, you wouldn't need a lawyer for him at that stage. I mean, this accusatory thing is, I think, what gets us in trouble. It's where the man's mind is changed, not the police's.
Well, General, you wouldn't ask us to weaken Escobedo to the point of saying that a man could be interrogated if he didn't have a lawyer, but he said that he wanted a lawyer and he could not raise one at the particular time, either because of lack of money or couldn't get him on the telephone.
And then I think he could very well say, well, I'm not going to talk. Yeah. Then if it appears to the trial judge that he really meant he wasn't going to talk, and then after that he was cajoled over, or in Escobedo he was handcuffed or something, then I think the statement would be in trouble.
You say that if he wanted a lawyer,
yes.
All practical purposes, the interrogation is over.
Well, for the purpose where, to my mind, once he says any terms, I'll talk if.
Well, no, he just, they read him that
yes.
statement there, and he says, well, I want a lawyer.
Yes.
And the agent says, well, go ahead, get it. Well, I don't have one. The agent says, sorry, we can't furnish you one. He ought to fold up his papers. As I understand you, the agent ought to fold up his papers and leave.
No, sir. I went the other step. I said...
Because the fellow has already said he wanted a lawyer.
Yes, I said that...
Which means he doesn't want to talk unless he has a lawyer.
If he makes that clear, that's it. If he makes that clear.
That's right.
If he makes it clear.
Well, he says, all he says in answer to that warning is, I want a lawyer.
And he says, what I was trying to
And
get
if
over.
he doesn't get one, why isn't the conversation over?
Well, I think that I'm giving him, I'm the agent, I'm giving him another factor, which is that you assume I can get a lawyer for you, and the truth is, I don't have a lawyer, I don't have the money, I can't get a lawyer for you. Now, with that understanding, let me read the balance of this statement to you again. Do you still want to talk? And the guy says, no. Then I say, the agent's through. The agent's through. But I have to, I think in my own mind, I have to have that other one to make sure about it. The real problem is that when he talks later.
But if he says, you read him that part again, and he says, well, what do you want to know? I'll answer some questions, try to straighten some things out. You wouldn't at that point to say that there's anything wrong with further questioning.
I think that
you wouldn't insist that they sign a waiver of some kind. You don't think there's anything to waive anyway.
I don't think he has to sign a waiver at all. I think that I don't know if you notice the real careful trial judges. They always at each stage after recess they put these facts in the record. Well, I don't think that's necessary. If you recess the question for 15 minutes and come back, you have to read him his statement over and over again. I think the whole thing has to be taken into consideration.
General, is the warning that was given by the FBI agents in this case the standard FBI warning?
I think so, Mr. Justice Fortas. I have the manual, but I don't have it with me because it's not supposed to be out. I will check it, sir, and if I may send the letter.
I should very much appreciate.
I think it is.
Knowing that, and I should also very much appreciate knowing whether there is any source available to us as to FBI practices.
Yes, sir, it is.
It's been my understanding that the FBI does have a standard practice as to warning and what happens in one event or the other.
They have an official manual. I have it, as I know it could be released to the court, but the question is I'd feel obliged to give it to petitioner's counsel, and I would much rather check with Mr. Hoover before I do.
Well, I'm not suggesting any particular
It's
way.
a whole,
I might
it's a
even
full
say
manual.
whether it's possible, but if, for example, I could know authoritatively
Yes.
just what the FBI warning is, number one. Number two, when the FBI warning is given, at what stage. Number three, what happens in the event that counsel is requested or counsel appears representing the arrested person. Number four, what happens in the event that counsel is requested, but that the person in custody does not have counsel.
All right, sir.
I'd be very grateful if there's some way in which...
We'll get that. We'll get that. I hasten to point out, though, that I think the FBI is the only one that does it uniformly. The Narcotics Bureau and Customs, I don't think it's just the FBI.
I know that. That's very evident from the records that we have, that
Yes.
the FBI does seem to have some regularized procedures.
Could I ask you a question on
Yes,
a little
please.
broader basis? As I read your brief, the government's position is that as a matter of constitutional right, neither a warning of counsel nor a warning of a right to remain silent is a requirement. But that absent either one of those warnings, those are factors that can be taken into account on judging voluntariness, and that the ultimate constitutional issue in these cases is whether or not the admission or statement or confession was voluntary.
That's our exact position.
Now, you're not receding from that in anything
Not in
you've
the
said.
least. Not in the least. We also say that for practical matter, the warning is better to be given, but it's not required. I have not receded at all.
I didn't understand you had.
No, sir.
Mr. Fawcett?
Mr. Chief Justice, just a few words. I left San Francisco on Friday, therefore, if the page proofs mailed to me Wednesday did not arrive in time, it certainly is not Solicitor General's fault. The printed brief mailed Thursday did not arrive at that time either. However, I do think it is a little odd that an ex-party request was made for this additional material on January 14th of this year without notifying me. I think it is also odd, curious, that I asked for the exhibits when I was first assigned this case in December of '63 and could not get them. Now suddenly they're here. I would also now, on the merits, make a few comments on what the Solicitor General has said. First, saying that the record has absolutely nothing in it. Then he turns around and he concocts this wild story that the petitioner decided to trade a federal conviction or a state conviction for a federal one. He points to the fact the trial judge in California so commented sometime thereafter. A number of interesting points. First, of course, the state charges would have been Missouri, not California. Secondly, he is presently serving a sentence of 30 years with, under federal law, a minimum parole of 20 years. Under the maximum of the statutes he was convicted under, it would have been a 50-year sentence with earliest parole permissible in slightly less than 34 years. As this court, I think, knows, California, at least, customarily pardons life sentences at about 7 to 9 years. The sentence under California law would have been 5 years to life, not just life, as the Solicitor General's brief points out. If indeed Westover made this choice to trade one for the other at the time he was in custody, I submit that shows pretty adequately that he certainly needed counsel. He made a lousy choice. Secondly, on the Coppola point and the detention, we, of course, are not arguing here, nor did we below, but the Court of Appeals adopted this same view that there's nothing illegal about state-federal cooperation. Of course not. There is, however, something illegal, and I would submit perhaps unconstitutional, about an unarranged, unadvised detention. It then becomes a question of looking to see how the federal authorities contributed to that. Whether or not Missouri has a small book 20-hour statute permitting state authorities to hold without a specific charge, I don't think we want to encourage that in federal law. This court need not reach constitutional proportions to strike it down. I'd like to quote, just because I think it's sound, from what the Second Circuit said in the Coppola decision. It said, if this cooperation between federal and state authorities reached the point of arrest and detention by local police for the purpose of enabling federal officers, now, not the only purpose perhaps, but the purpose, to question the defendants concerning the bank robberies for a period of time forbidden to federal officers by Rule 5A of the Federal Rules of Criminal Procedure, admissions thus obtained would properly be excluded. Such a rule prevents federal officers from evading the letter and the spirit of Rule 5A. I'd add just a few words to Mr. Justice Fortas's colloquy with the Solicitor General on the right to counsel. I find it very odd that the standard warning that the Federal Bureau of Investigation gives to counsel, gives to accused, is that they have a right to counsel, yet the Solicitor General stands up here and says, oh, but they don't have a right. I can't understand whether the federal government is talking out of both sides of its mouth at the same time. Are these simply empty words which in fact mean nothing? Finally, I would like to comment on the discussion that has concerned whether or not a person without means to provide a lawyer can say or will say, I won't talk, or I want a lawyer before I talk. I submit first it's pretty hard for a person in detention to stand up to the police, certainly hard for anybody except an experienced criminal. That aside, however, if that is to be meaningful, the common federal practice, which this case has, won't assure it. That is to say, unless you have something like a tape recording of what went on, a verbatim statement of the questions and answers, it is a hollow thing to say, and ever thereafter to know whether or not the right to counsel and the right to remain silent was ever intelligently waived. Certainly a narrative statement such as this, where the federal officer ingests what was said and puts it down in the words, oh, by the way, I would also like to say that. That certainly simply shows no signs of a waiver or much of anything else. Yes, Your Honor.
What do you say to this proposition? This court will slow on the constitutional rules, very wide-sweeping investigations of depth now as to what reform.
Yes, Mr. Justice Harlan. A couple of points. I'd comment twice, or two ways. First, I'd point out the prompt arraignment statutes on the books of well over half of the states of the Union, and point out that, as this court knows, they are commonly ignored. I think the states have had their time to start to clean this up, and they haven't taken it. I would comment, secondly, that I think the approach of the American Civil Liberties Union is very sound. They say, you needn't say, a right to counsel is ipso facto and barring all else, the only way we can protect the privilege against self-incrimination. What they do say is, with what we have now, that's the only way we can protect that privilege. That leaves you open later. If the state comes up with something else, something better, perhaps the tape recording would do it, then at that point you would say that is an acceptable alternative.
Mr. Fawcett, do you agree that I would make the statement that somebody else here has made, that the issue here should be considered to be Fifth Amendment, not the right to counsel?
Well, as I interpret Escobedo, and as I think it makes sense, I don't really find myself in thorough agreement with anybody else. The American Civil Liberties Union, for example, puts the right very heavily on the Fifth Amendment privilege. But as I said in my argument in chief, I think what Escobedo did was to devise a means to protect that. I think, as has already been said, they are both, and they're part and parcel. But I think Escobedo went more than Malloy versus Hogan. It went to the position of saying, here's a cure, not here's a wrong that must be righted, but here's a wrong that must be righted that may be righted by this means.
What about a third approach, that is, the Fifth Amendment?
I wouldn't be troubled by that.
You wouldn't be troubled?
No.
Wouldn't be troubled by what, would you?
By putting the footing on due process. I think probably all of these other rights ultimately come down to due process in any case.
That would lead us to deciding all these cases on the totality of the situation?
No. As I say, Mr. Chief Justice, I reject the totality of the circumstances, and I think Escobedo rejected them. I think it said you must have counsel at this focused interrogation point. Whether you say the reason we must have counsel is due process or that specific provision in the Sixth Amendment, I think is not that important.
The uniform course of decision of this court had been totality.
Yes, sir.
You don't mean to suggest that there's anything short of Escobedo that suggests a different history of this court and the problem.
I think there's a different history, which, starting with the concurrence in Spano has, as I say, moved away from a necessity of viewing every case on the totality of its circumstances, a recognition that when there's a behind doors interrogation, you can't always know what the circumstances are, that Escobedo, flowing on Spano, White, Messiah, has gone a step towards rejecting, or at least adding a new qualification to the conventional totality of circumstances.
But Spano itself.
No, Spano did not. It was the concurrence. Yes, sir. That's correct. That, I think, was the start. It was not, of course, the majority view.
I think if you look in the note, Chambers against Florida,
Sir.
you will find where it was pointed out that there had been two lines. One which used due process in its abstract sense, and one which applied it to the Fifth Amendment and to the precise language of the statute. And I think there were plenty of cases cited along that line.
I think there were. Thank you.
Chief Justice, and may it please this honorable court. This case presents with perhaps more poignancy than any of the others that have previously been argued this week the problem of determining the scope of the investigative powers of the police and the exercise of their function as guardians of society, and determining the scope of the constitutional rights of the accused. Beginning in December 1962 and continuing through January 1963, there occurred in a limited area of the city of Los Angeles a series of extremely brutal crimes. A lady named Mrs. Wells, on her way home from work on December 21st of 62, was waylaid, robbed, brutally beaten by an unknown assailant who made off with her purse and its contents. Later, a Mrs. Dixon had the same thing occur to her. A Mrs. Mitchell was waylaid near her home and struck down and killed, her possessions taken. A Miss Mayauchi, on her way to work in the early morning, was similarly accosted and her possessions taken. And finally, a Miss Ramirez, on the day before the arrest of the respondent here, suffered a similar occurrence. In the case of Miss Mitchell, the victim died. In the case of the other victims, they suffered long hospitalization periods. There were fractured skulls, fractured jaws, losses of equilibrium, and certainly an inability to identify the perpetrator of the crime. Whoever this person was, he made one mistake. With the assistance of a lady named Lena Franklin, he negotiated some checks which had been stolen from Mrs. Wells at a market. This occurred on the 22nd of January, 1963, the negotiation of the checks. On the 30th, the officers learned that he had done so. On the 31st, they located Lena Franklin. Upon locating her, they went with her to find the person who had been introduced to her as Roy Wells, the person who cashed the checks. She did not know the address. She did know what the house had looked like because she'd been there. They went there. They saw the respondent on the front porch. They called out his name, Roy Wells, the name he'd signed to the checks. He went inside the house. They followed him. They entered. They arrested him for a series of purse snatch robberies, and they came upon a fakeness nest.
They did
Very
what?
difficult to hear you, counsel. Could you
I'm
speak up?
sorry, Your Honor, if I have a habit of not knowing whether I'm talking loud enough. Upon entering the house and searching it, incident to the arrest, which was a lawful arrest and has never been challenged, the officers found a great deal of stolen property. They found particular items of property which had been taken from each of the individual victims with the robbery or murder of whom the respondent here was subsequently charged. In addition, according to the testimony of the arresting officers, they found a number of other purses and a number of other wallets whose provenance is not identified in this record. In the house were 5 persons: the respondent Stewart, his mistress or wife, as the case may be, his niece, a lady named Jackie Jackson, and 2 other gentlemen. At the time of this arrest, search, and seizure, the officers had no means of knowing, other than perhaps a bland suspicion, perhaps, that the same person had committed all these offenses. They had no means of knowing that this was not a ring of the 5 people who were all in this house at the same time. And this is certainly different than the type of situation envisioned by the Chief Justice yesterday, where the police get a vague description of somebody and pick up 90 people who look like them and take them down to the police station. So these persons were taken, arrested, taken to the police station.
All 5 of them?
All 5 of them, yes. That's in the record. The defendant Stewart, Lillian Lara, a man named Vernon, a man named Evans, Jackie Jackson, the niece of the defendant Stewart. During the ensuing 5 days, Before the production of Stewart before a magistrate, he was questioned, as the record shows. The record shows also the amount and the length of the questioning, approximately a total of 2 hours and 45 minutes or 2 hours and 46 minutes, as the case may be. This was the total amount of the questioning. There's no claim here that he was questioned at late hours continually by relays of police. There's no claim here that he was denied access to anybody he wanted to see, whether wife or friend or relative or counsel or bondsman or whatever. There was indeed a claim of coercion at the trial, a claim which was, I would suggest, devoid of substance.
You would suggest what?
Is devoid of substance.
Oh.
A claim solely that the common law, that the confession by the defendant was given in return for a promise to release Lily and Lara. This was rebutted by the officers. The questions here are whether, antecedently to the giving of his confession, the police were constitutionally obliged to give Stewart a warning of a right to remain silent and a right to consult counsel. There is a second issue which was raised by Mr. Norris in his brief, a claim that there was an unlawful delay in the arraignment, and because there was an unlawful delay in the arraignment, the confession being, according to Mr. Norris, the product of that unlawful delay, the confession should also have been excluded. I will address myself first to the first point. As suggested in the briefs, and this is a good phrase, I like it, so I keep saying it. This case is a grandchild of Escobedo and a child of Dorado. What we are contesting here is the interpretation which the California Supreme Court placed on the Escobedo case, an interpretation of which the California Supreme Court in Dorado, and by extension here, claim to be. And here I'm thinking perhaps of Justice Black's use of the word compelled under the Fifth Amendment. But they said that we are compelled, as a matter of federal constitutional law, to hold, on the basis of the Escobedo case, that these warnings must be given. These rights must be waived. Otherwise, a statement, no matter how free and voluntary it may otherwise be, may not be received in evidence. In other words, the California Supreme Court has held that there is a generalized Sixth Amendment right to counsel which emanates from circumstances occurring either at or after the arrest of the accused. We believe that the true interpretation of Escobedo is the interpretation which was suggested by questioning and oral argument by Mr. Justice Stewart and Mr. Justice Harlan, that it is a totality of circumstances case. Continually, throughout that decision and its limited holding, Escobedo speaks of under the circumstances here, where, as here, under the facts, as here, and certainly, in that case, which was involved the denial of a request to consult retained counsel by a person whose attorney was on the outside trying to get in at the same time. This was an affirmative act of denial by the state under the circumstances as found by this court. We do not, therefore, read Escobedo, as our Supreme Court has done, as creating in any individual a kind of inchoate executory interest which vests at the time of arrest. It's been suggested, and here I'm thinking of an article which Mr. Justice Fortas wrote several years ago, that the right to counsel begins at the time of arrest because at that time the adversary system commences. Now, does it? We believe, as does the Solicitor General, that a certain amount of questioning is a social necessity. That is, not only because some prosecutors may say we must have confessions, but also because questioning serves both an inculpatory and exculpatory purpose. And let me, if I can find in my notes, bring out a few statistics which I think will make this point. These facts are contained in Crime in California, a very compendious book which is issued by the California Bureau of Criminal Statistics, Department of Justice. In 1964, there were approximately 100,000, a little over, arrests for felony in California. Of these, 27.5% were released without charge. These are men who were either determined to be innocent by the police or determined there was insufficient evidence to even seek a complaint from the district attorney. 27.5% were released. Of those arrested for robbery, 43.1% were released. Of those arrested for burglary, 31% were released.
Were what?
Released. Those arrested for aggravated assault, 28.2% were released. Homicide, and that is the most serious conceivable charge, 20.8%.
What's the overall?
The overall 27.5%, and if it would be of assistance to the court, I have a copy of the book. I don't know if it's available in your library, but may I lodge it?
You may.
I don't have an extra copy for Mr. Norris here, but if they're not available in his library, then we can furnish him with a copy.
I will.
The lowest.
What is that book?
It's called Crime in California. It's compiled by the Bureau of Criminal Statistics, Division of Law Enforcement, California Department of Justice. The particular table I'm concerned with is on page 49. It's table Roman numeral 3/7. The lowest percentage of releases, and I think this is significant, forgery and check offenses, which I think all will agree are the type of offenses where an investigation after an arrest is the least necessary. I write a check on a bank in which I have no account. The check is dishonored. You check with the bank and you find out I have no account. There is the offense, and the need to investigate after an arrest on probable cause is of minimal importance. In all of these other matters that I've laid out, something that occurred after the arrest based on probable cause resulted in the release of the man. We do not know whether these gentlemen had counsel in the police station or not. There's no way of knowing or cross-checking. But certainly, questioning by the police must be regarded as having played a significant factor in the decision not to charge. I do not know how significant a factor because we cannot empirically go that much more deeply. But I think this makes my point. That questioning serves a dual purpose, not merely to get confessions because we've got to have confessions in all cases, but it does serve the police function of bringing to charge and trial those against whom there is evidence sufficient to justify such a step, and not bringing to charge those who are not guilty and should be released.
May I ask you if the
Yes, sir.
27.5% meant that many people had been detained or arrested and interrogated while they were under detention?
Again, Your Honor, I have no means of knowing, but let me accept that for the purpose of argument, because I believe you are intending to raise a question which you raised earlier in the other arguments. Let us assume so. I think the tenor of Your Honor's questions yesterday, based on the Fifth Amendment, were simply that under the Fifth Amendment, as Your Honor interprets it, under the Fifth Amendment as applied to the states under Malloy and Hogan, a statement made by a person who was under arrest and in the police station is a statement which is compelled within the meaning of the Constitution of the United States. I think that was the drift of the questioning and the point which you were putting to counsel. Secondly, I think Your Honor was also concerned with the number of Escobedo cases that would have to be determined by somebody unless there were a simple and easy-to-follow test for determining the admissibility of confessions. I talked to the Solicitor General on Sunday and was informed that there are or have been this term 170 Escobedo cases, which either are now pending or have been pending.
Where?
Here. And there are probably thousands more elsewhere.
Well, what do you...
But I would suggest...
What inference do you draw from that?
The inference I would draw is there are a lot of people who are contending they were improperly convicted. I draw no other inference from that because I have not examined the facts of any of the cases. But to get... I would say so. I would say so, Your Honor. Thank you. Thank you. That had not occurred to me.
It might also be possible that they were trying to take advantage of this to be doing what it held.
That depends upon the facts of those cases, and that's exactly the point I'd like to make, Justice Black. And I think I'm sort of bouncing off a question by Justice Harlan, or a comment by Justice Harlan, that was made yesterday in argument. That I don't see how you can say, as a matter of law, that any statement, in any case, that is, all statements in all cases made by the accused who's been arrested on probable cause and taken down at the station, is necessarily, by virtue of the fact of arrest and detention alone, a compelled statement.
You wouldn't
I think it's a question of fact.
that he was held under compulsion.
I do not deny that, no. But
then
this
it's the question, is it not, as it always is, of the approach you made to how liberally you will construe the Bill of Rights Amendment.
Well, let me suggest this. I think that it's a question of fact, depending on the totality of the circumstances in each individual case, just as
but
under
the provision doesn't say that. It doesn't say it depends on the totality.
Yes, but the provision of the Constitution simply says no person may be compelled to be a witness against himself, and it doesn't suggest any particular circumstances in which he is or is not. It's compendious terminology, which must be understood in the context of particular facts. Now,
the natural inference, isn't it, that if a man is taken under arrest, he's taken under compulsion, he's compelled to go where they tell him to go.
Yes. Under legal process, yes. That is, if the gun is pointed at me, I don't have much choice.
The general idea is that a man is arrested only to detain him in order to await a proper trial in the court.
I would accept that. I would accept that. But, Your Honor, I would still suggest that it would be a factual question in each particular case, just as under the Fourth Amendment, which is a specific constitutional guarantee. The question whether a particular
what does the Fourth Amendment say?
Well, I don't have the exact wording in mind.
It says reasonable, doesn't it?
It says unreasonable searches and seizures.
There's a difference.
All right. There's a difference between reasonable and unreasonable.
And there's also a difference between saying no unreasonable search shall be made and no witness shall be compelled, no person shall be compelled to be a witness against himself.
Well, they deal with different things, but the point I want to make, Your Honor, is this, that here you have a specific term of art in the Fourth Amendment, which is applied to the states. You can't have an unreasonable search, and you have an exclusionary rule. And the point that I want to make is that even under this specific constitutional guarantee, it's a question of fact in each individual case. Probable cause.
I agree with you. It says unreasonable.
Probable cause based on facts of each individual case, and I would suggest, and this ties in also with the Sixth Amendment interpretation of Escobedo, because the farthest reach which has been given to Escobedo that we know of is that of the California Supreme Court, which by the inherent force of the logic of its own decisions has come to the conclusion that the Sixth Amendment right to counsel vests at the time of arrest. And under the decisions, as set out in our brief, there is a certain pattern that once you start with that presumption, I do not go so far as to say that necessarily you do bring the members of the grand jury physically into the police station. But the only statements which can be admitted under the California rule are those which are either completely volunteered by the defendant. In other words, when the officer comes up to me, I pull out the gun that I used and said, this is the gun I used. I'm the man you want. Or those statements which under the California court's construction of Escobedo are made where there's a possibility a victim may still be alive and there is a compelling necessity to find the victim. And so you find the powers of the police to investigate, either for inculpatory purposes or exculpatory purposes, reduced to this point, that unless you have reason to believe that a victim might still be alive, you can't question. And the other exception is, a statement can be received in evidence if the defendant's remorse strikes him so quickly, that he begins to blurt things out.
Well, Mr.
Now,
Winger, do
yes,
you believe that
yes,
under
Chief
our
Justice.
Constitution, the police, without having probable cause that a person has committed a crime, can arrest him, put him in jail, and hold him there for the purpose of interrogation?
As a general principle, I would suggest no. However,
It's a general principle.
well, I don't know, Your Honor.
A principle is a principle, isn't it?
I'm sorry, Your Honor. I don't know whether that question is antecedent to something that has to do with this case. I will agree the police should not.
Well, don't try to read our minds as what we
I'm
might
sorry,
come
Your
to
Honor.
later. Let's just
The
answer
principle is the
question
principle.
that
I
we
agree.
asked you.
I agree, without qualification. That is true.
That is true.
Because arrest must be made on probable cause.
All right. Well, then, if it's made on probable cause and the man is taken to the jail, he's taken there preliminary to putting him on trial, is he not?
One would assume so, yes.
Well, when does his right to counsel attach?
Well, we've understood that the right to counsel attaches at critical stages of the state proceedings which follow the filing of formal charges. Escobedo said, bringing the time back prior to filing of formal charges, that if a man has an attorney whom he wants to see and he wants to see that attorney, the police have no right to keep them apart. And that's a principle with which we agree wholeheartedly.
Do you think that that because a man hasn't hired a lawyer in anticipation of being arrested, that he should be treated less generously by the law than a man who perhaps does have reason to believe he'd be arrested and is arrested when he has a lawyer?
Well, if it please the court, we don't believe, and we've argued this, I think, perhaps with some vigor in our brief, that equal protection principles apply this far back. And I think this was suggested by Justice Black yesterday in a question. Do the principles of Griffin versus Illinois apply at this stage? We would suggest they do not. Society is full of inequities and inequalities of all sizes, sorts, and shapes. And we suggest that these principles do not apply at this particular stage.
And why don't they apply?
Because I've always understood, and if I'm wrong, please, I'm subject to correction, that in the judicial process, the Equal Protection Clause applies on the appellate stage, certainly. That's the right of a poor man to have a transcript, the right of a poor man to get a brief on appeal. Everybody's entitled to counsel at trial, and there are only a few states that did not concede that prior to getting. We agree that at critical stages of the state proceedings, which follow the filing of formal charges, that he's entitled to counsel as a matter of right. But the question is not so much whether he should have a lawyer in the state house with him, sitting beside him during interrogation, or whether he could telephone, but whether the state is constitutionally obliged to advise him that he has a right to consult an attorney before being questioned by the police. And that's the fundamental question in the case, to which we suggest the answer should be in the negative. I don't know whether I've answered your question, Your Honor, but I've attempted to.
I guess we'd all agree that we should have a lawyer when he actually becomes desperately in need of a lawyer, wouldn't he?
Well, may I answer
when the
this?
government's taking him in charge.
Well, that's the flash. Excuse me. I think what Stewart needed in this case, more than a lawyer or anything else, is something no longer to give him. And that's a convincing explanation that would exculpate him. A convincing explanation that would exculpate him of how that property came to be in his house. I would suggest that.
I don't quite understand your answer.
We think
You say that if he had not been guilty, he could have convinced the authorities that he was not guilty by explaining how he got that? Is that
well, that's part of it. That's part of it, yes.
And you say that's his obligation when the police have him in the
I don't
station
say
to
he has
prove
a
his innocence?
constitutional obligation to exculpate himself. I suggest that was his greatest need.
And
under the circumstances of this case.
And don't you think that at times a man might need a lawyer to adequately exculpate himself?
Well, again, there are perhaps times where he might. But the question again, and I do not mean, I wish to focus, to use a phrase, on the way we view the problem. And I keep returning. That if the person doesn't know, he can consult with a lawyer.
If what?
If a person doesn't know, he can consult with a lawyer.
Yeah.
If he doesn't know, that he doesn't have to talk. These are factors which go to whether his statements are voluntary. These are factors which can be considered at the trial, be considered on appellate review, as part of the totality of circumstances in determining whether a man has been denied due process of law at his trial. And we suggest the test is a compendious one, which requires, I'm sure, a considerable degree of analysis of the facts of particular cases, but that it is a test which this court should adopt as the test for determining admissibility.
Well, wouldn't the best test be that that he was informed of his rights by the authorities before they took a statement from him, and then there wouldn't be much question about whether he knew?
Well, there again, this raises a problem, Mr. Justice Warren, a problem which how's my time? This raises a problem which was suggested in our brief, that if he has a right to a warning, then he has a right which must be waived. Is that not true? That's quite clear. That follows. There's a warning, there must be a waiver. Now, let us suppose that so-and-so is taken to the police station and he's read his rights, as under the Dorado decision. Said, you have a right not to say anything. Anything you say may be used against you. You have a right to consult an attorney before you speak to us, or at any particular time, in addition. Then the defendant either remains silent, nods his head, exercises one or the other of these rights, or he says words, thanks, I know that, or something. At any rate, he makes some reply. If a waiver is required, the test of waiver is the Johnson and Zerps test, a knowing, intelligent waiver of these rights. And the very factors which are involved in a determination whether a right has been knowingly and intelligently waived are those which go to voluntariness. If the man is a mental defective, the policeman may not know this, and he may read his rights to someone, and someone may say, all right, I'll go ahead and talk. At the trial, perhaps years later on collateral attack, it will come out that this person was one who was incapable of waiving his rights. And so you are importing complicated principles of waiver that are difficult enough to determine in the context of a judicial trial. And I'm thinking here of Henry in Mississippi, where you couldn't tell from a record of a trial whether there was a knowing waiver of a particular right to object to particular evidence. You are importing these concepts into the police station, Mr. Justice Warren, and you're putting them on the shoulders of police who are not sophisticated experts in the criminal law, and particularly not sophisticated experts in problems of waiver and constitutional law.
Do you agree that if a man says, I haven't a lawyer, but I'd like to talk to my lawyer before I talk to you, Do you agree that in that case, the police should not interrogate him?
They certainly should afford him an opportunity to get a lawyer if he wants one.
Suppose he says, well, I just can't go to a phone. I just can't go to a phone and call because I don't know a lawyer. But maybe my friends and relatives can get a lawyer for me sometime during these proceedings, and I'd like to have one.
That's a request for help, isn't it, Mr. Justice Warren?
It is a request. Now, is that sufficient, in your opinion, to prevent the police from further interrogating?
I think they should afford him that opportunity before going any farther.
He has a right to that.
I think he should do that. He has a right under the Haynes case to call his wife. You remember the Haynes case, and it was suggested in argument by the solicitor yesterday that Escobedo is the lawyer equivalent of the wife in Haynes. I think he should be afforded that opportunity, and the statutes of California provided, even before the Escobedo case, I'm referring specifically to Section 851 of the Penal Code of the State of California, provided that upon arrest and booking, and no later than 3 hours after arrest, that a person has a right to make several phone calls to a person who may be his relative, his friend, his attorney, his bondsman, or whatever, and these were liberally construed in practice. If he didn't have the money to make the call, he would be given the dime or whatever it took at public expense. I would like, since I don't wish to discuss another problem in rebuttal that I have not mentioned before, I'll simply, because I wish to reserve time, mention the contention made under Wong Sun versus the United States. There is a claim made by Mr. Norris that there was an illegal detention here which would render inadmissible the statement which was made by Stewart on the last day of his detention. We submit that the detention was lawful within the statute of California, Section 825, whose constitutionality has not been challenged by Mr. Norris. On that basis, I would wish to submit my opening argument and await Mr. Norris' reply.
Before you sit down, may I ask you, do you, as you read the majority opinion of the California Supreme Court, do you think that the court felt that, do you think that the court felt that the result which it reached in this case was compelled by this court's decision? And
yes, sir. There's no question about that. There can be no question. Now, this Stewart case is the third case on this point in the California Supreme Court. First was Dorado, in which they stated they were compelled by the decisions of this court to so hold. The second, which is the case of Modesto, the third is Stewart. And Stewart cites Dorado. And
I understand that, but I'm still asking you whether you feel that, as you read the case, whether you think that the California Supreme Court felt that the result in the present case was compelled by this court's decision in Escobedo, or alternatively, whether the California Supreme Court may have felt that this was an appropriate, desirable application of Escobedo in its judgment. Do I
Your
make
Honor,
the distinction clear to you?
I think I understand the distinction. It is one which I do not think can be made, because all of the ramifications of the Dorado rule, which stem from Escobedo, are stated by the California Supreme Court to be emanations from the Escobedo case as they conceive it. And these applications are not state rules of evidence, and they aren't regarded by the California Supreme Court as state rules of evidence. They're regarded as constitutional compulsions as well. I think that answers your question. I hope it does that. I hope that satisfies your view of what we believe that the California Supreme Court has done here.
Well, I wouldn't go quite that far with you, but I understand what
Yes, that is our position, which is all I was attempting to say.
Mr. Norris?
Mr. Chief Justice, may it please the court. At the outset, if I may, I would like to follow up on Mr. Justice Fortas's question, because as an advocate, of course, I was looking for some independent state grounds upon which to base a claim that the writ was granted improvidently. There was another ground, as you know, which I did find and argue. That is now behind us. I was satisfied, Mr. Justice Fortas, that there was no independent state ground, that the California Supreme Court did feel compelled to reach the results it reached in this case because of Escobedo. Whether or not the California Supreme Court would have reached the result anyway in the absence of Escobedo is, of course, another question. I think, and I will argue this, I hope I will find time to argue this, that the California Supreme Court has taken the correct approach in interpreting and applying Escobedo. The California Supreme Court, in effect, said there are three questions. One, is the, quote, accusatory stage, close quote, reached at the time of the interrogation? Two, is the right to counsel which attaches at that point dependent upon a request? The answer, no, citing Carnley and Cochran. Thirdly, was there a waiver of the right to counsel? And the California Supreme Court, again correctly, I believe, looked to such questions as warning, as the age and the experience of the accused, to determine whether there was a waiver. I believe, Mr. Justice Fortas, that the California Supreme Court was relying squarely on Escobedo.
In other words, that it felt bound to reach the result it did in this case by the United States Constitution as it understood that Constitution had been interpreted in the Escobedo decision. Is that right?
That's as I read the California Supreme Court opinion, Mr. Justice.
It did not feel itself free to reach any other conclusion in this case because of the compulsion of the United States Constitution.
That's my reading of the case, yes. And it is my position here that on the facts, the Stewart case raises a very narrow question. And that is whether the request itself was an essential ingredient in the Escobedo case. I believe, of course, that constitutional rights cannot possibly turn on such a tenuous ground. I was interested that the Deputy Attorney General conceded that if Stewart had requested counsel, presumably the state would have had to furnish him counsel, whether he knew a lawyer or not, whether he could afford a lawyer. Now, once you reach that point, I think we can't penalize, of course, the accused who may not even know enough to ask for a lawyer. This case is indistinguishable, as I say, on all of its facts, except for the absence of a request. So to reverse the judgment of the California Supreme Court, it seems to me, this court must either overrule Escobedo or distinguish Escobedo on such a tenuous ground that, for all practical purposes, I believe it would be overruled. The state makes an argument that in denying a request, the state took an affirmative act and placed itself between the accused and his lawyer. Well, if it's an affirmative act that we're looking for, and I don't really think one is necessary, we have it. When the police prolonged the detention for 5 days before taking Stewart before a magistrate, that is an affirmative act, keeping Stewart from his lawyer, because once he gets into the formal judicial process, he's entitled to a lawyer. I would like to review the facts of the detention just briefly. He was arrested, along with his wife and 3 other persons who just happened to be at his house on the evening of January 31st.
The house was full of stolen goods, wasn't it?
The house was full of stolen goods.
And the police took to the police station the 5 occupants of the house.
That is correct, Mr. Justice. Whether or not the arrest of all 5 of them was based on probable cause, I don't know. I concede that the arrest of Stewart was based on probable cause.
His case.
His case. And the record is silent on the reasons why they arrested the other four. Maybe it was because of the stolen goods.
I hope you'll forgive me for interrupting the order of your argument, but I'd like to get back to what you were talking about a few moments ago. And let me try to state to you what's going through my mind on the basis of what Deputy Attorney General said. And I'm going to use different language. Seemed to me that perhaps what he was saying, translated into Escobedo terms, is that the investigation, the interrogation, should not be considered to focus on the suspect until a point well beyond the arrest. Did I make myself clear to
Yes,
this
Mr.
point?
Justice Ford.
Now, yesterday or the day before, the counsel rep from the prosecutor's office of Kings County, New York, as I remember, suggested that the accusatorial stage begins not upon arrest, but when the police have a prima facie case. I made a note of it, and I think that is what he said. And there's another suggestion that perhaps a right to counsel in Escobedo terms, that is to say when this focuses, arises at some point after the arrest, but so let us say before the formal accusation, the indictment, or whatnot. And in view of that, what would you say? Does the distinction between this case and Escobedo turn solely on the request that was made in Escobedo and the lack of a request here? In other words, is there any difference in time as to the request, when the request has to be made in one case rather than the other?
Yes, I understand the question, Your Honor. If it is whether we adopted the prima facie test, we would have reached the accusatory stage in this case, as well as in Escobedo. I would say clearly yes, without regard to the request, because here, I believe the police had much more evidence against him than they, by the time of the confession, certainly, and even at the time of the arrest, than against Escobedo. They had a personal identification of him as the one who negotiated the checks. They found the stolen property. After they took him into custody and questioned him, they got the opinion of a handwriting expert that he did indeed sign those checks. They finally got some admissions from him that he had possession of some of these articles, although he always denied his involvement in any of the crimes. And finally, on the morning of Tuesday, the 5th, the 5th day of detention, the sergeant testified that he opened up the interrogation by saying, "Roy, you killed that old woman and you aren't even sorry." Now, if that isn't enough for focus and the accusatory stage, I don't know what is.
In other words, if the test should be that the right of counsel attaches at a time when demonstrably the police are out to establish a case against the individual, something beyond just probable cause. That even if that should be the test, it's your submission that the facts in this case would fall within the limits of that test.
Without question.
Is that it?
Yeah. And I do think, Mr. Justice Fortas, that the court in Escobedo made what I consider to be a good effort to try to answer what I consider to be the hard question in these cases. It's a question that Mr. Justice Douglas asked the other day saying at what point anterior to trial do Sixth Amendment rights accrue? And I think that this court in Escobedo did a good job in trying to come up with some guidelines as to when that point is reached. I think the California Supreme Court is doing an excellent job in interpreting and applying Escobedo, giving some more flesh to the guidelines set forth here.
May it not be a little confusing to talk about the right to the appointment of counsel at that time? Of course, it's never been done. They're not ready on the trial. But to talk about it as though that means a complete right to appointment of counsel to continue to represent a man, is it not more in line with the fact? Here's a man under detention and held under compulsion. He is asked questions that would tend to incriminate him, beyond a doubt. The court simply says that he shall not be compelled, he shall not be held to have waived his constitutional right. One of the reasons being that he doesn't have a lawyer who could advise him. I think maybe there's difficulty of getting it because all of us, including me, have talked so much about the right to appoint counsel. Basically, the question here is whether you're going to admit a confession given by a person who is held under compulsion without letting a lawyer advise him so that he could determine whether he could waive his right to not to be compelled to incriminate himself.
Mr. Justice
You're
Black,
not arguing, I'm sure, that we're going to establish a new rule that every time a man gets arrested, he's got to have a lawyer appointed at that moment.
I would not argue that, Mr. Justice Black, and I think that is not required by Escobedo.
It's the circumstances.
And I think that's a false argument.
Circumstances that come up that show that he's held in custody when the purpose of holding usually is simply to keep him there for trial. He's interrogated. And the court, in fact, what it held was that you couldn't hold that that man had waived his right to not to be compelled to incriminate himself when he had no lawyer to tell him what it meant.
Mr. Justice Black, I agree with you, but I also must part company because I do think it is important to analyze these cases in terms of the right to counsel.
Undoubtedly.
Because
in that connection, but for what purpose?
Well, for a number of purposes, Mr. Justice Black. I can conceive of a situation, for example, in which there could not possibly be any finding that the compulsion itself caused the man to answer the police officer's questions. I can imagine a case, for example, where you have a reasonably intelligent layman who may be advised, a Gideon, if you will, who may be advised by the police that we're going to have to hold you until tomorrow morning when we'll take you before a judicial officer. You don't have any obligation to talk to us. So you're not going to be held here very long, just until we get you before a magistrate. Now, we'd like to talk to you. You don't have to understand, but we have a few questions, and feel free to answer them. Now, the only thing he doesn't know is that is his right to counsel.
He knows there are 5 or 6 policemen around there, and he's in custody and can't get away.
He does know that. That's right. The compulsion is that he can't get away, but I think that it would be pretty hard to find compulsion that to answer the question.
What you think about compulsion.
Yeah. Well,
if you think about it as the old drawing of John, that one. What you have is a man who is in custody of the law, can't get away with a group of policemen, probably in a little room, and they ask him questions. But then, what I'm suggesting is that maybe we shouldn't go too far on saying that under all circumstances and conditions, a man who's arrested has a right to a lawyer. It can be said. We're simply holding that we're not going to let any confessions in that were taken at a time when a man was in the custody of the law and he didn't have a lawyer to advise.
Mr. Justice Black, I think we end up at the same point, because I think my position is that the only effective way to protect the right to remain silent, the right not to testify against yourself, is to make sure that he has a lawyer. It is counsel that is the vehicle for protection of all of the other rights. I was interested that the American Civil Liberties Union argued this primarily as a Fifth Amendment case on the ground that there may be some other ways of protecting the right to remain silent. But when it was all said and done, they agreed that the only one they could really think of was the right to counsel.
Well, can't the Escobedo case on analysis be explained in precisely the terms that Mr. Justice Black is suggesting? After all, Escobedo had a lawyer. Danny Escobedo had a lawyer. He had a lawyer's advice, and the lawyer had advised him not to talk. And the very fact that Escobedo then did talk after he was in confinement in the police station was very clear evidence that he had been compelled to talk. Isn't that right? Because he had been advised by a lawyer not to.
Mr. Justice Stewart, I could argue that I think the other way, that those facts show that Danny Escobedo waived his right to counsel and waived his right to silence. That his knowledge would, under Johnson against Zerbs, could be argued that way.
Well, that would be true if there were any evidence of waiver, but the evidence was all the other way. He kept asking you to see this lawyer who had already given him this advice, which was evidence that he did not waive it and did not intend to waive it.
Well, that may be, and it may be a totality of circumstances case, but I question whether this court would reach a different result just because Danny Escobedo either didn't have a lawyer or didn't know of his right to a lawyer.
I wasn't trying to put in your mouth any totality of circumstances theory, because I know that you don't espouse any such theory. I was merely trying to suggest that the Escobedo decision can be explained in terms of the compulsion of a compelled confession, particularly in view of the fact that, because of the fact that he did have a lawyer who had advised him not to talk.
I suppose, Mr. Justice Stewart, it could be read that way, but I prefer to read it the way the California Supreme Court has. I might say... Go ahead.
Norris, excuse me again, but Justice Stewart said you did not espouse a totality of circumstances rule. I'm not quite clear yet as to what you consider to be the right rule, whether you do or do not regard a totality of circumstances rule as appropriate.
I would urge this court not to adopt the totality of circumstances rule.
And what rule would you urge on this?
If I may answer that first by saying that even though, as an advocate, I could go down each of the circumstances cited by the Solicitor General in his brief and argue that on each one of them, in my case,
I understood.
It argues for overreaching as a conclusion, clearly. The view that I would urge upon the court is that the hard question, again, the question I think we should grapple with, is when a criminal prosecution begins under the Sixth Amendment. Because it's at the advent of that process that the right to counsel comes into play. Now, that's a hard question. I don't think it's a totality of circumstances
Another
question.
right came in, however, in advance of that. And that's the right not to be compelled to be a witness against himself.
Well, that may be, Mr. Justice Black, but the Fifth Amendment also talks in terms of criminal cases. So maybe you have the same problem under the Fifth Amendment of determining, for all practical purposes, when does a person stand accused of a crime by the forces of the state?
Well, you don't have that problem in terms of Fifth Amendment privilege against self-incrimination, do you?
Well, I'm not sure about that, Mr. Justice Fortas. It does talk in terms of in a criminal case. Now, maybe it is arguable that unless you have reached this point in the proceedings, you don't have a criminal case, and the Fifth Amendment doesn't come into play.
The self-incrimination provision's been successfully invoked, and I think sustained by decisions of this court, administrative proceedings,
That's right.
congressional hearings, and all kinds of things which aren't criminal prosecutions. So you may not have that problem if you approach this from the point of view of privilege against self-incrimination.
Well, I don't think this court can escape that problem, Mr. Justice Fortas. At some point, this court must decide what marks the beginning of a criminal prosecution in the Sixth Amendment.
Why?
Well, because...
The courts held a long time ago that what that means is that the government shall not compel a man to give evidence against himself anywhere or under any circumstance. So why do we have to determine when the prosecution actually begins? The words of the amendment are very simple.
Well,
and they've been construed as meaning that means the government mustn't compel a man to give evidence against himself anywhere at any time.
And I would prefer, Mr. Justice Black, to avoid the question as to whether during secret police interrogation it happened to be voluntary or not voluntary, because I can conceive of some circumstances in which it might be involuntary or voluntary. And if it is, then I see no more reason to exclude, to admit the confession than in the case of arraignment, where he's asked to plead. The difficulty I have is distinguishing White against Maryland and Escobedo. Those who argue against Escobedo, without regard to the question of compulsion, let's assume it's totally voluntary, which I think is not the case here. But let's assume that it is. You mean to tell me we're going to let the police effectively charge the man with crime one night and then interrogate him in the absence of a lawyer and let him confess his guilt and make a judgment as to whether he should talk? Make a judgment, for example, as to whether or not he is not committing himself to taking the stand at trial, as in Carnley, with the consequent results?
Suppose you were taken by the police, told to come down, they're going to interrogate you about a murder, and they thought you probably committed it. They brought a number of policemen down, took you down, and interrogated you. Do you think you need any more compulsion than that to show that it's compelled testimony?
That's a hard question.
Aside from any waiver.
Yes, it's a hard question. Oh, aside from any waiver, but what right does he have to waive? Can he waive his right to remain silent in the absence of counsel?
We have held many times that a man can knowingly and voluntarily waive a constitutional right.
That's right, but I don't. That's correct, Mr.
What
Justice
you are
Black.
going on the assumption is you've got to say, we compel beyond all doubt to say. Therefore, you've got to plead to the counsel, because we're compelled beyond any peradventure to say that it's not compulsion for the government to send its police agents, take a man in with a large number of them and get him down into a little room by himself and then interrogate him about whether he's guilty or not. Does that not spell compulsion to you and compelling?
But, Mr. Justice Black, he may waive that intelligently.
Well, that's quite different. I'm not talking about the waiver. That's why I said maybe in the Escobedo case that was brought in, because if the counsel was there and told him that he could intelligently waive it. But nevertheless, it wouldn't keep it from being compulsive unless he made up his own mind that despite the fact that he's held there in secret with these officers, I'm willing to go the limit and give the information.
That's what I'm concerned about,
With
Mr.
my
Justice.
advice of counsel.
Provided he has the advice of counsel.
No, that would be enough to show it as a waiver.
Well, as I say, my view is that the case is indistinguishable from White. If we won't let him answer the judge's question as to whether he's guilty or not guilty without legal counsel, we shouldn't let him confess the night before to police officers who have him in detention. That's an even more, he has a greater need, I should think, for counsel at that point, perhaps even than at arraignment. Mr. Justice Clark, I really don't think that follows from my position. I'd like to discuss for a moment the consequences of... But that, it seems to me, is a choice for the police to make. In my view, Escobedo does not require the state to provide lawyers in the police station. What happens after he's arrested and after this process of interrogation begins is determined by the state. If the state wants to engage in that process, then he's accused of a crime, for all practical purposes, he's a defendant, and he must be furnished with counsel. But if what the state must forego, and the practice that the Escobedo rule will end, is the very practice that I think this court should end. And that is secret interrogation of a person accused of a crime by the police and in the absence of counsel.
If we should adopt your proposal, as I understand your proposal, then the controversy would shift to the issue of the question of whether or not the investigatory process had ceased and the accusatory process had begun, whether there had been a focus. And certainly that's a very evanescent kind of a concept to try to pursue, isn't it?
Not as evanescent, Mr. Justice Stewart, as totality of the circumstances where you have to take into account the education of the accused, the qualities of the accused, his knowledge, his experience, and all the rest.
Well, that's not, the totality of the circumstances isn't a rule. The rule is that coerced confessions are inadmissible. And you look at the evidence to see whether the confession was coerced, and that's, I suggest, at least as workable, if not much more constitutionally supportable, than trying to chase this will-o'-the-wisp of finding out when there had been a focus.
Well,
and that would be the issue if your proposal should be accepted.
That is true, but I think that is a more meaningful guideline than the test of voluntariness or involuntariness. And I think that it will be a more meaningful guideline to the police. The practical effect of such a view, as I say, will be to discourage secret police interrogation. And I believe the core of the problem is the incompatibility of the process of detaining an accused person for the purpose of secret interrogation. I think that process is totally incompatible with the safeguards of our accusatorial adversary system. And if you permit the police to engage in this process, it's so easy to circumvent all of those safeguards. It becomes a mockery. Why, the police, the representatives of the states here have argued in effect, we must have the right to interrogate. Why, if we don't interrogate them there, we certainly can't interrogate them in the courtroom in the absence of counsel. Well, I should say not. And they shouldn't be permitted to so easily circumvent the safeguards.
Why wouldn't the simplest rule on that basis be to adopt the English rule that no statement made to the police can be used in evidence?
Mr. Justice Harlan, that may be the simplest rule, but I do believe...
English, those are the two broad differences between what's been argued here for 2 days and what is exemplified by the difference in the English practice and our practice. They're veering away a little from it now, and we're being asked to go to the route that they're veering away from.
Well, I believe that the California Supreme Court is trying to go down a sensible path, somewhere between those two positions, Mr. Justice Harlan, and perhaps that's the route we should take for the moment, because the California Supreme Court is making a case-by-case determination. And in some circumstances where there's a spontaneous confession to the police, where there's an effort to explain some circumstances, California Supreme Court is saying, fine, those confessions or admissions.
Mr. Norris, that's exactly where I'm having a little difficulty in understanding your position, and it may be that I'm responsible because of interrupting you so often. But as I get us to this point, what you've said, you do not believe that the state's obliged to furnish counsel immediately upon arrest.
That's correct. I think that is not a necessary result.
Do you believe that if after arrest the police begin an interrogation, that then at that stage, in order for the statements of the person in custody to be admissible, he has to be furnished with counsel?
That is my position. Yes, Mr. Justice.
In every case, but now you told us just a second ago that if if the person in custody volunteers, then that's admissible, even if he doesn't have counsel.
I would qualify my response along that line. I think the police must engage in this process of interrogation. I think the police must engage, as they did in this case, in a little adversary proceeding where they're trying to extract from him a confession. I think that there is nothing to protect an accused against compulsion from him within himself. If he's walking back to his cell with a guard, he might say something that would just volunteer something. So
You're going to have to help me a little more. Suppose a man is arrested. He's not furnished with counsel. Then the police say something to him along these lines. They say, well, did you do it? And he says, yes, I did. Nothing more happens than that, except that he is in custody. Now, by giving you that sort of simple illustration, I'd like to see if I can clarify your position.
I would want to know more facts. In the Cotter case, I believe it was, decided by the California Supreme Court, the fella called up and said, gee, I just tried to kill someone and I'm going to be on a given corner. Come and get me. And they arrived and he said, here's the knife I used.
Well, that was before arrest, but take the same thing after
I'm going to get into the police car. He was in the police car and they said, what really happened back there? And he said, he told them, gave them a detailed statement. And then they interrogated him again at the police station, more formal interrogation. The California Supreme Court held that the confession in the police car was admissible because the police hadn't yet engaged in the adversary process.
Now, you agree with that?
I think that's a meaningful line, yes.
Now, what about, suppose he had not telephoned them and had not, in fact, confessed at that time. Suppose they had picked him up in front of the house or the place where the crime was committed, put him in the police car, and then he had just volunteered these statements.
Just volunteered the statements? I think they're admissible. Just as they would be admissible if he volunteered them to the guard after he left the courtroom, indeed, and didn't have his lawyer with him.
But suppose the police picked him up, put him in the police car, and then said, did you do it, Joe? And then he said, yes. How about that?
It's a hard line, Mr. Justice Ford.
I'm not trying to get you to answer the questions
understand.
for that purpose. I'm trying to get as specifically as I can for my own benefit what your position is.
We're focusing on what I call the hard question, and that, I think, is the hard case.
Unhappily, we have the hard question.
You have the hard question. Oh, it'd be very easy to draw the line at trial, but Powell said no, sometime ahead in advance of trial. And indeed, White and Hamilton said that it would be as early as arraignment, and Messiah held that it didn't even have to be part of the formal judicial proceeding, that the adversary system was operating. And I think that you can't draw the line so formally, and it's hard.
I beg your pardon.
Yes, excuse me.
Well, you were answering Justice Fortas' question. I'm sorry, I didn't interrupt.
I just wanted to say that it would be simpler to draw the line at one of these cutoff points, but I don't think it would be meaningful because you would so easily permit the police to circumvent all of the safeguards of our system.
Well, then you are sort of a totality of circumstances, man, or sort of a sub-totality of sub-circumstances.
In the sense that the line will be hard to draw, but it doesn't get into all of the factors and the tough factors that turn on the particular individual. It's what the police are doing and what the process that they're engaged in, which becomes the important process. Yes. Excuse me, Mr. I'm sorry. Well,
Where would your rule lead
I think the only practical effect of the rule that I think is the Escobedo rule would be to... Yes. The only practical consequences, I believe, Mr. Justice Clark, would be to put an end to the practice of interrogating persons accused of crime in a police station in secret without the advice of counsel. And I think that practice should be discouraged.
Suppose it was out in a rural area. I think it's undone in my state. not a lawyer in the whole county.
Well, I think the avenue open to the police is not to interrogate him, but to take him before a magistrate at the earliest possible time. I believe it is incompatible with our system to give the police the power to take a man and hold him in secret and interrogate him.
What would you say about a warning? If they gave him a warning and then saw, do you think that meet your view?
That would come to a question of waiver, Mr. Justice Clark. I think for one man, a warning might be effective. For another man, an experienced criminal lawyer, a warning might be unnecessary. Still, for another man who really isn't capable of making a judgment even with a warning may not be enough. I think that's a factor to take into account in determining whether he has made the knowledgeable and intelligent waiver of his constitutional rights.
I'm not taking into account one that's suffering from some mental problem. Just the average person, as the police advisor along the line of, say, FBI was. If you say that, and then he went on and talked anyway.
In my view, that would not be enough. It would not be
How
enough.
much further would they have to go?
Well, because I have my experience with this is in the district court, and I've watched Judge Hall, for example, interrogate indigents about their rights, and it's very tough to waive your right to counsel before Judge Hall, and I think it should be. I think that you have to have evidence that man knew what he was doing. You can't force upon him a right to counsel. You can't force upon him any of his constitutional rights. But that is a hard question, and that is a totality of the circumstances question, it seems to me. Yes.
You're supposed to put it under the fifth instead of the sixth.
Well,
and the same circumstances occur.
Then I think you have essentially the same question. It's a question of waiver, and it may not be. Well, that's why I would prefer to keep away from the Fifth Amendment, because I think it ought to be as under White against Maryland. It just ought to be whether he had the protection of counsel in making the judgment about whether to.
Take California statistics. 27.5%, I believe, of those people were picked up for investigative purposes. Apparently, I think it would be at least a deduction to say that they were picked up for investigative purposes. They were released. Did you give counsel to all those 27.5%?
No, Mr. Justice Clark. I would simply require the police to take them before a magistrate forthwith.
Without question.
Without question. That is correct.
Then they'd had to hire counsel, although they were not guilty, and the police found out they were not, and turned loose. So they'd have to hire counsel. It'd be quite a burden on the court, wouldn't it?
Well, that's a judgment for the individual to make. If he feels that he can give a good explanation why he's not guilty, I should think he could do that pretty easily.
Get back to the very thing I asked you then. You can question his judgment also after he's warned. Most of the people that are picked up know they don't have to make mistakes, but after they're warned, along the line that they're not only don't have to talk or be used against them, but they're entitled to counsel. Wouldn't that be a matter of judgment then for them if they went on, assuming they were a normal person?
I think that's right, and as I say, there's no way to keep a man from volunteering a statement.
So, rather than requiring an appointment with counsel, wouldn't it be just as effective from the standpoint of administration of justice comparing it? Just put the warning in. If a man goes on and talks after he's warned and after he said he's entitled to counsel, well, then he's made a judgment.
Right. And that may be a fair position, but I think it should turn on whether he's made the kind of waiver of constitutional rights that this court requires in order to be effective. And that very well may be the practical result.
Wouldn't the question of whether there or not there was a waiver depend to some extent at least upon on the kind of warning that he was given? Let's take two extremes. Let's take one where a district attorney has been arrested for crime, And the police said to him, now, Mr. So-and-so, you know what your constitutional rights are. You know you don't have to testify and so forth. That would be one situation. On the other hand, if you take a poor illiterate fellow who could neither read nor write and who had no friends available or family available, and they just went through and said, you know what your constitutional rights are, you don't have to testify, and if you do, we can use it against you, and so forth. That, in the exact words that they spoke to the district attorney, there might be a great difference there, might there not, as to whether there was a waiver if the man after that said, answer the questions when they started speaking to it.
I would agree with that, Mr. Chief Justice, and that's why I believe that you can't tell automatically from the words of the warning. I think you have to take into account the qualities and the capacity and the education of the accused person himself.
No.
You're going to totality then?
No.
Well, I'm not quite sure. I'm never quite sure what that means, Mr. Justice Clark. I must admit, but
You mean on waiver?
On waiver, it does mean certainly that you have to take into account the age, the experience, etc., of the accused. And if that is what is meant by totality of circumstances, yes, that must be taken into account. On the question of waiver, not, however, on the question as to whether we have effectively reached the accusatorial stage, which is just another way of saying that we have reached the point where the person stands accused of a crime by the forces of the state. And that's, I believe, the time, I believe, when he's entitled to all of his constitutional rights, including his right to counsel at any time that the state proceeds against him in an adversary way. I have argued as an alternative ground that the judgment should be affirmed because the confession was elicited during a period of illegal detention. And I will just state that point because I really think these two arguments tend to run together in terms of their practical effect. The fact is that Roy Stewart was held for 116 hours before being taken before a magistrate, as were 4 others. And we don't know the grounds upon which they were arrested. We do have a rather remarkable line in the record. The sergeant testified that the other 4 were released, including Stewart's wife, following his confession on the 5th day because there was no evidence to connect them with any crime. Our view is that under California law, they must be taken before a magistrate without unnecessary delay. The state argues a 48-hour maximum in terms to permit 116 hours. I think that is, that you can't possibly reach that conclusion under California law. Without unnecessary delay means without unnecessary delay, and they must explain why he was held all day Friday when the courts were open, then all day Saturday, all day Sunday, all day Monday when the courts were open, and they finally got their confession out of him on Tuesday morning and took him before a magistrate that afternoon. Our position is that the state must establish reasonable ground rules to authorize police to arrest persons and to hold them for a reasonable period until they can get them before a magistrate. A valid purpose of such a statute may not, in our view, be to hold him for the purpose of interrogation. Now, if the police do not operate pursuant to these ground rules, then the police are operating beyond the law, and that, we submit, is clearly a deprivation of liberty without any process of law, much less due process of law. And we think, therefore, that applying Wong's Son, the exclusionary rule, and McNabb, that this confession obtained during a period of illegal detention must be excluded.
In what community was this arrest made?
In downtown Los Angeles, in the Watts area, Mr. Chief Justice, in the area of the line.
only, we'll be adjourning in 2 or 3 minutes if you have another point.
Thank you,
we
Mr.
may
Chief
make it.
Justice. I would like to conclude by pointing out that there are issues remaining, and since we do not concede the voluntariness of this confession. The voluntariness was challenged at trial. Instructions were given. It appears that the requirements of Jackson against Deno were not satisfied. The California Supreme Court expressly reserved that question for retrial. I wanted to point that out. There is also a question under Griffin against California, since the prosecutor commented on his failure to testify on some of the counts. Now, in conclusion, I would like to say that we must make a choice, it seems to me, between the adversary accusatorial system or the inquisitorial system. And I think those who argue against Escobedo are caught between them. I think we must recognize that this practice of secret police interrogation, why, they conducted a little pretrial procedure here against Roy Stewart, complete with tape recorders which they turned on at their convenience, complete with an accusing witness, complete with a statement that the handwriting expert testified that, or had stated that he had signed the checks. They tried him in the back room of the police station and held him as long as they needed to finally get the confession. And when he did confess, he confessed to a simple act of purse snatching. He was very careful to avoid, in his confession, saying that he had anything to do with any of the other crimes. He confessed that he ran up and he took a purse, and he said, he was asked whether he kicked her, and he said, "I'm not sure. She fell, I think, and, well, apparently she hit her head, and there is no evidence that this was an intentional beating." He didn't know the consequences of the felony murder doctrine. He certainly did need a lawyer at that time. What he confessed to was a single act. What he didn't understand were the legal consequences. Thank you, Mr. Chair.
Mr. Ringer, you may proceed with your argument.
Thank you, Mr. Chief Justice. I would like to begin by making one preliminary point, which has no relevance whatever to the case, I think, but it was injected by Mr. Norris. Neither the crimes nor the arrest of Mr. Stewart occurred in the Watts area. So I don't think we find in this case the emotional aura that is associated with that subject. This was some 6 miles north of Watts. Secondly, I think we should bear in mind that when the officers arrived at Mr. Stewart's house, they found a house full of stolen goods which were not limited to the exhibits which were introduced in evidence at this trial. It's been conceded by Mr. Norris that Stewart was arrested on probable cause. I think it's quite clear from the record that Lillian Lara was arrested on probable cause at the very minimum. Now, it's true that the record as to the other 3 men is totally indeterminate as to the existence of probable cause, although they were in a house which was full of stolen goods. But this would seem to follow the record being indeterminate precisely because it was Stewart who was on trial and not these other people. And so there was no occasion to go into the other circumstances involving them. Out of this 116 hours delay before the taking of Mr. Stewart before the magistrate, we've already pointed out the total time of interrogation consumed was less than 3 hours. According to the testimony of the investigating officers, all the other persons involved were questioned about these exhibits, as well as the other exhibits that were found in the house. The ultimate question in this, and I think in any case, involving the introduction and evidence of a confession or incriminating statement of the accused, is whether it was coerced. I mentioned in the opening argument that there was an issue at trial of coercion, which was strictly limited to a claim that the officer had promised to release Lillian in return for his confession, and that he had confessed, and that she was released, and that this was rebutted. The other claims that have been made by Mr. Norris, I think, are as follows. That fundamentally, that this man was This man made a confession which should not have been received in evidence against him because the right to counsel attached even upon arrest. We have already stated our views as to the Escobedo decision. We understand, of course, that there is a conflict in opinion among the various jurisdictions as to the meaning and scope of Escobedo. We suggest, however, that our interpretation of it, that it's a totality of the circumstances case, is the proper and the correct one. The next point I'd like to bring out is this, that this case differs from the other four before this court, in that in each of the other cases, when the police arrested a man, they arrested him because of a certain specific crime, and any statement that was taken was about a certain specific crime that they'd arrested him for. The officers went to his house having probable cause to believe that he committed at least a forgery of the Wells checks. They discovered all this other property, which led and envisioned the thought of his possible implication in a series of other brutal crimes, including murder. Had they not questioned him, there would have been no way to bring home to him or to anyone else in the world these crimes, and the police would have been required simply to do this, to take the exhibits which were found, return them to the victims, and to say, we think or we have a suspicion that your aunt was murdered by this gentleman, that you were beaten by this gentleman, and that would be an end of the case. There would be a certain social cost, a considerable social cost. You're dealing in this type of case with an unwitnessed homicide, where there are no fingerprints, no technical leads, no magnetic evidence, no electronic evidence, no scientific evidence of any kind. And there are certain kinds of crimes which can only be solved by asking questions. I'm not suggesting that whatever rule that your honors will adopt will be one for unwitnessed crimes and another for witnessed crimes. But I'm suggesting that in determining whether Stewart's conviction was properly obtained and whether Stewart's confession was properly received in evidence, that these factors should be taken into account. As for the emphasis of Mr. Norris upon the secrecy of the interrogation, I think we can take the word secrecy too far. This man was in jail, there's no question about it, and he wasn't invited by 7 armed officers. He was arrested and taken to jail. But there's nothing in the record, and no claim made here, that he was not allowed to see anybody he wanted to see. In fact, he wanted to see Lillian Lara, his girlfriend or his wife, whatever you want to call her. He wanted to, he asked to, and he did. And he even claimed that she came to see him a second time, which the officers denied having occurred. There was, we submit, on the facts of this case, no compulsion in the constitutional sense, whether we look at it from the point of view of coercion or from the point of view of the Fifth Amendment. With respect to the state statute, we submit that the statute was complied with in this case, and that to hold that it was not would be to take a rather giant leap. The argument is based on Wong Sun versus the United States, and this is, I would suppose, a rather muted argument under McNabb and Mallory. The Mallory rule, as I think is generally recognized, is a rule arising under the supervisory jurisdiction of this court. It's never been suggested in any opinion of this court that it's a rule of constitutional dimension. So in order to apply it to the states, you would have to take a pretty giant step. And that, of course, is a decision for yours to make. It's for mine, perhaps, to contravene and say should not be done. It's for Mr. Norris to urge. That's your decision. It's a pretty giant step to take.
Mr. Ringer,
yes.
Is there any point prior to the signature of the written confession of which you think the right to counsel would attach?
In this case?
Well, in this case, or generally.
Well,
you've got to say in this case, but what are your general observations?
Well, my view is that there is no generalized Sixth Amendment right to counsel. there was a denial of assistance of counsel in Escobedo because the state did affirmatively deny him counsel.
Well, is there a point prior to the signature of the written confession at which a warning should be given? I'm talking about all of this, of course, as bearing upon the admissibility of the confession.
What I wish to say in reply to your question, I hope you will not construe as sort of getting away from it. What I say is in determining the inadmissibility of his confession, whether or not a warning was given is a factor among the totality of the circumstances. This is the test proposed by the Solicitor General in his brief. But I do not mean to concede or to suggest that that would be the dispositive factor. It would simply be a factor in determining voluntariness because the ultimate test is one of coercion.
Voluntariness of what?
Of the statement,
what I'd like to do.
The voluntariness of a statement made by a person to the arresting or investigating officer.
I'm asking your help in trying to refine these concepts a bit. The statements are voluntary, let us assume, or not involuntary, let us assume, in the sense that the arrested person was not beaten and he was not mistreated or subject to any psychological torture.
Correct.
At all. But he was there and he was being interrogated. And he did not have counsel.
That is true.
Now, is it your position that only if involuntariness of the confession in the sense of either psychological or physical maltreatment, that's the only kind of, that those are the only circumstances that would make a confession involuntary for the relevant purposes?
Well, there are, may I meditate on that for a moment? The typical, indeed, the only cases of the coerced confession that we are familiar with in the records of this court, or in the records of our own courts, are cases in which the police did something, whether physically or psychologically, which under the traditional concept of due process broke this man's will, or whatever other formulation may be chosen to use in a particular case. And what I'm suggesting is that certainly the absence of a warning or the absence of counsel would not, standing alone, render a confession involuntary in the classic sense. But I think it would depend upon the particular facts of the case.
I know, but what I'm trying to get at is this. In your view, is the totality of circumstances merely a new way or a special way of saying, of asserting the coerced confession rule? In other words, when you say that the rule ought to be totality of circumstances, are you saying anything more than that the confession ought to be admitted unless it is a coerced confession in the traditional sense? Do we get anywhere by saying totality of circumstances?
Well, totality
or are we
of
remitted to the old coerced confession?
Totality of circumstances is a catchphrase, which means that the court looks at all the facts. And I suppose you can attach too much significance to the particular use of a catchphrase. But what I wish to say is simply that the usual test of the coerced confession, the usual test of admissibility, is one of coercion. And that unless you can say that before some specific statement is made, either in this case or in some other case, the Sixth Amendment right to counsel is specifically attached, then the test does remain one of voluntariness in the traditional sense.
I'm a bit afraid that the issue is presently drawn, it seems to me, may be one between the exclusion of admissions on the ground of physical or psychological pressure, punishment, traditional sense. Or the asserted presence of pressure or coercion or whatever one might want to call it, which flows from the very fact of the arrest, the absence and the absence of counsel. And I'm afraid that perhaps when you say the rule ought to be a totality of circumstances rule, it never doesn't advance us much beyond the fact that it is a reassertion of the traditional coerced confession rule.
Well, it's not this, the rule which was propounded in the solicitor's brief, in which I am suggesting is not necessarily an advance. And whether there should be an advance or a stand, certainly no one claims there should be a retreat. But the question is whether there should be an advance or whether the rule is compendiously formulated there is the proper one.
No, well, all I'm trying to do is to clarify in my own mind with your help whether the issue really may not be one of, we accept the pre-Escobedo rule in the cases where there's no specific request for counsel, or whether Escobedo has some implications that carry the problem beyond the pre-Escobedo rule of coerced confessions.
If it please the court, I can't deny that there are men of great honor and integrity, men in my court who believe it does have implications. And there is, of course, a difference of opinion as to what implications it has. But we do regard the Escobedo case as having said what it meant and meant what it said. Whether we do regard the rule contended for by Mr. Norris as an extension. And if you believe it should be extended, you sit here as a court to extend it. But the question is whether it should be.
Well, Mr. Ringer, isn't there in this a rather classical case as to what can happen to people when they're just brought in for investigation and interrogated? In this case, as I understand it, the police went to the home of this man, and there happened to be some neighbors or visitors there in the home at the time. They found some stolen goods in his house, and they put everybody in the house in jail. And they held them there for 5 days.
Yes, they did.
Just a moment, let me finish, please. Held them there for 5 days until one of them confessed, that being Stewart.
That's
And
correct.
then when he confessed, and only when he confessed, did they release the other 5 who spent 5 long days and nights in jail because of your interpretation that under our Constitution, the police have the right to arrest people and hold them on suspicion, perhaps, and hold them until they get ready to let them go.
Well, if Your Honor, please, as I endeavored to point out, Stewart and Lillian were arrested on probable cause, and as to the others, we have an indeterminate record.
Pardon?
We have an indeterminate record as to the other 3 people. I can't make any assertion one way or another. What grounds of suspicion of these 3 people the officers had when they went there or got when they talked to these people or did whatever they did at the premises? You see, I don't know the answers to those
I
questions.
understood that we tried in theory. They didn't. They had no knowledge of these other people, didn't even know they were to be there or anything else. They just knew that this fellow had passed a check belonging to the woman who was killed.
As that may well be true, Your Honor. I'm simply in no position to affirm or deny because I don't know and the record doesn't tell us. I would assume that as California had an exclusionary...
But would you think that the police had any right to do that if the facts were as I state? That they went there to get this man because he had passed that check, and then they arrested everybody in the house and kept them in jail for 5 days for investigation.
If Your Honor, please, I believe as you believe, as we all believe, that arrest must be based on probable cause. The last time I was here 3 years ago in Curran, California, that was the precise question before the court. The principle of which everyone agreed upon. All I say is that California had the exclusionary rule, or at least a version of the exclusionary rule, which was quite similar to the federal rule, many years before Kerr and before Mapp and before Kerr. The record does not show anything other than that they were there and that this house was full of property. And I can draw no presumption one way or the other as to that, because the issue was not explored at trial. This was the trial of Stewart, and the trial, whatever the investigation did, the trial focused on him, to the exclusion of the others, except as counsel for either side might have chosen to bring out those of the facts which they wished to. And so I can accept the principle, but I have no way of prejudging or post-judging the facts. I believe that my time has expired, but I wish to say one word. This case is unprecedented. It is unprecedented because this is the first time that this court has consented, at the request of a state, to review a judgment of reversal in a state criminal case involving questions other than statutory or constitutional construction. It's not normally the practice of counsel to thank the court for taking over the case, but this is the first time it's been done, to my knowledge, in 200 years. And I should thank the court for hearing our side and contemplating the position which we advance.
Before calling the next case, I would like to thank counsel for both sides for having presented very scholarly arguments in all of these cases. And I would like particularly to express our appreciation to those who took these cases as charity cases or were assigned to them by the courts below. Mr. Norris, I know you were appointed by this court because of the indigency of this man, and we are very grateful to you for assuming that obligation. It's a public service, in our opinion. And Mr. Fawcett, I don't know whether Mr. Fawcett is still here or not, but he was appointed by the Court of Appeals in number 761. And we thank him also. I'm told that Mr. Earl was appointed through the Legal Aid Society, which we asked to argue the case. And our thanks go to him. I'm sure that Mr. Frank and Mr. Flynn in 759 also were doing this as a work of charity. And I'd like to express our appreciation to all of them, and of course our appreciation to those who represent the interests of the states. It's been a good job, and of course been very much help. Thank you, gentlemen.
Thank you.